Good afternoon, everyone. Today is Wednesday, February 25th, and welcome to the House Judiciary Committee. We're going to start with Delegate Warman, House Bill 963. Delegate Warman, I don't recall seeing you in our committee before. The second time, okay, but, well, welcome back.
Could I bring up my panel?
Yes, please.
Thank you so much.
So I see that we have Registrar McFarland, Megan Good, Teresa, oh, obviously, and them, okay, we got everybody. Whenever you're ready, Delegate.
Alrighty, well, thank you, everybody. Thanks, Chair Bartlett, Vice Chair Davis, and members of the committee. I'm very, very happy to be seeing you guys bright and early today. This is House Bill 963, and for the record, my name is Delegate Teresa Warman. This bill, you've seen it before. You passed it out of this committee favorably in a bipartisan fashion last year, and it just simply removes an outdated provision in our Estates and Trust article that prevents someone from managing their loved one's estate simply because of their citizenship status. This committee, like I said, this committee and the House passed this bill in a bipartisan manner last year, and although it did not make it across the finish line in the Senate before session ended, families affected by this provision are still navigating probate today, which is why I'm bringing it back. This bill originally came from a very real and very painful situation. Last year, the committee heard from Maria del Carmen Castellon Quintana, the widow of Miguel Luna, one of the 6 construction workers who tragically lost his life in the collapse of the Francis Scott Key Bridge. While navigating unimaginable grief, she learned that because she was not a U.S. citizen, she was barred from serving as a personal representative for her husband's estate, even though she shared finances, shared property, and shared a life with him. It was deeply emotional to hear her testimony last year, and this committee, followed by the House, saw it fit to pass it. And during the interim, I continued conversations, and I came to understand that this issue extends well beyond this single tragic case. We know that Maryland is home to diplomats, international students, researchers, professionals on long-term visas, and families with international ties. Many of them live here for years, sometimes decades, building lives here, owning property here, and raising children here. If something happens unexpectedly, the current statute can create barriers for these families during the probate process, at the very moment that they are grieving. This bill does not remove any meaningful safeguard that is in Maryland law. A personal representative must still be at least 18, be mentally competent, and not be convicted of a serious crime absent good cause. And they must also be obviously nominated in a will or entitled under the statutory order of priority. The registers of wills would maintain full authority. Courts retain full discretion, and bonded requirements remain the same. Non-residents must designate an in-state agent for the service of process. This bill simply ensures that eligibility is tied to judiciary fitness and non-immigration classification. This is about making sure that in moments in grief, Maryland families are evaluated based on their ability to fulfill these duties and not their passport. I respectfully request a favorable report, and I'll pass it on to my panel.
Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the committee. For the record, my name is Byron McFarland. I'm the Register of Wills for Howard County, and I'm here to express my strong support for this bill, as I did last year. I do want to note I'm speaking for myself and not for any of my Register colleagues. I'm going to try not to reiterate too much of what Delegate Warman said, but as we know, when someone passes away and they have probate assets, those are assets that are in their name alone or don't have a beneficiary, they have to go through probate. The personal representative, or PR, has to be someone named in a will, someone with statutory priority to serve under Maryland law, or someone who has been appointed through a judicial probate process. So there's been a court hearing and a court has determined that they are the appropriate person to serve. Put another way, it isn't just anyone. It's someone who the decedent chose themselves. It's someone who the General Assembly has chosen to give priority under Maryland intestacy law, or it's someone who a court has trusted with this role. There are some restrictions, as Delegate Warman said, and those are pretty standard across the country. Most states require that a personal representative be an adult, not convicted of a serious crime. In Maryland, that means an honesty-related crime, so something like larceny, perjury, forgery, not, for example, a minor drug charge or a DUI or some other kind of, maybe a crime of violence. It's honesty-related crimes because we're looking at people who are going to be fiduciaries. And so the barrier that Delegate Worman talked about, what does this actually mean in a very real way? What it means is that people who are often in a place where they've got to deal with their loved ones' estates, the only way to get around this restriction is to hire an attorney, and sometimes that's cost prohibitive. And so we have a barrier to accessing our probate system and our system of justice. We want people to do things the right way, and we want people to be able to deal with their loved ones' assets in a timely, efficient manner. The last thing I want to note is that none of our neighboring jurisdictions have this restriction. DC does not, West Virginia, Virginia, Delaware, Pennsylvania do not have these restrictions. Over 40 states do not have this restriction. So I think we should bring ourselves in line with what most of the country does and give people this access to deal with their loved ones' estates. Thank you.
Thank you.
Good afternoon, Madam Chairwoman Bartlett, Madam Chairwoman Davis, and members of this committee. My name is Ninfa Amador Hernandez. I am a policy manager at CASA, and I am here to express We Are CASA's strong support of HB 963. Firstly, I want to thank you for this committee's support of this bill last year during the 2025 Maryland legislative session. And simply put, as has been shared already, this bill supports Marylanders through the bureaucratic probate process while they are navigating the aftermath of grief. You all might remember our CASA member who testified here today in this committee last year. And we all know the devastating impacts of the Francis Scott Key Bridge to our local communities and to Maryland's economy. However, I don't think we can understand the pain and the grief of those who lost loved ones that day on that bridge. And one of those victims was Miguel Luna, a beloved father and husband. And since then, We Are CASA has been supporting his grieving family. However, we have encountered significant difficulties and challenges in this probate process and supporting his widow. And because of that, we are once again here supporting this bill. I urge you to recall Mr. Luna's widow's testimony from last year, as she shared her hope that no one else will have to suffer the double burden of losing a partner and then being denied a voice in the distribution of shared assets solely because of that survival's immigration or citizenship status. Once again, we are thankful for Delegate Warman's leadership on this bill and for the partners here at the table supporting us. We urge you to help us restructure Maryland's very outdated probate system in this simple change and urge a favorable report of this bill. Thank you for your time.
Chair Bartlett, members of the committee, thank you for the opportunity to testify in support of House Bill 963. My name is Megan Good. I'm a tangled title attorney with the Maryland Volunteer Lawyers Service, and my team works to help low-income families preserve and pass along their family home. We regularly assist clients with the probate process. We're asking for your support to change the Maryland Code to remove unnecessary barriers for non-citizens to participate in the probate process. Maryland law currently requires otherwise qualified individuals to be U.S. citizens or a permanent resident and a qualified family member in order to serve as the personal representative. And this requirement for personal representatives is both unique and unnecessary. As stated, our neighboring states, Delaware, Virginia, West Virginia, and Pennsylvania, do not require a personal representative to be a citizen or legal permanent resident, nor does the state of New York. These jurisdictions have large populations of non-citizens, and the absence of similar provisions in their codes reveals that this section of the Estates and Trusts article is unnecessary, and it targets a marginalized segment of our community for exclusion from an important public process with no practical benefit. The single act of asking about citizenship status during the probate process creates a barrier that harms both families and local communities. Not only is it an affront to the dignity of grieving loved ones, but at MVLS we see firsthand how barriers to service increase the likelihood an estate will never be opened and property will remain titled in the name of a deceased individual. When property cannot be properly passed from one owner to another, it's at a heightened risk for deterioration and vacancy. Families lose their home, and vacant properties reduce property values, create safety issues in communities, and cost state and local government money through reduced tax revenue and expenditures to address blighted properties. For these reasons, we strongly urge you to support House Bill 963. Thank you.
Thank you. Delegate Ericon.
Thank you, Madam Chair. Thank you, Delegate, for bringing this bill back. Again, I'm sorry it didn't cross the finish line. Do we know anything about our chances this year in getting it through that side? Have we heard anything from the other chamber?
Yes, thank you so much for the question. We're in much better shape. I made sure to talk to the senators that were unfamiliar with the case and that might have had questions. One of the Senator West is an expert on this area of the law, and we had a couple chats over the interim, and he's on board with the changes.
Okay, awesome. So
And
there
with the
have
bill
been
now.
some changes. It's not in the exact same form.
It was really convoluted the first time. It was my first session, so the way that it was introduced was just not right, and we ended up striking the bill to do what it does now.
Okay,
So yeah,
okay.
we just like a rewrite, but the intent and what it will do is the same.
Okay, and do we have an update on the witness's case from previous? Obviously, this law didn't pass. It couldn't help her. How is she doing? How's her case doing? Was she able to get her property back yet, or is that still a situation that's ongoing?
Thank you for asking about our member, Delegate Erica. I appreciate your thoughtfulness. She is still without her property. She is still having to work with this other PR in lieu of her when it should be herself
Right.
before her assets. So we are really counting on your support and that of this committee to get this through the House, and then we'll work in the Senate to pass the law, because it's the law that's hindering her ability and others' ability to be able to complete the process.
Yeah, I'm sure there's a lot of other folks, no matter what their status is. This is obviously an overlooked issue that needs to be addressed. So I appreciate you carrying the banner again this year, and hopefully it'll cross the other side. Did you hear that other side? This year. God bless.
Thank you.
Thank you. I just want to ask you about the Bar Association. Oh, were you going to go? No, Delegate Cardin, go ahead. Okay. I just wanted to ask you about their amendment. I don't know if you've seen it, Delegate Warman, but essentially they are putting some parameters that, they're fine with. It looks like they want to keep it in, and then they want to keep in what you're taking out, and that is the citizenship, that the letters of administration may not be granted to a person who is not a U.S. citizen or permanent resident of the United States unless that person is domiciled in the U.S. and the spouse, ancestor, decedent, or sibling of the decedent, or a descendant, I'm sorry, or sibling of the decedent. I think that might not be something that you would be in favor of, but I just wanted to find out so that when we go back in committee, we'll know what your position is on it.
Correct. I believe that's too restrictive and doesn't really account for the realities that it's more than just direct descendants that have to deal with these issues, especially with immigrant communities. A lot of time it's extended family that has to deal with these end-of-life issues. And I think it would just kind of, it would not deal with the issue as fully as we would expect, it would without that amendment. And yeah.
Thank you. Delegate Cardin?
Thank you. And that was my question, but now, given your answer, and this I think would be from Mr. McFarland, given that there's clearly, as you've all testified, there's no issue with fiduciary lapses based on your not being a United States citizen. We all agree on that, I think. We got unanimous support last year. But the Bar Association also wants them to be domiciled here. It would seem to me that it would be easier if you, regardless of whether they're a family member or not, that might be an issue that you have, to have, wouldn't we prefer that they be domiciled here to be able to be a PR versus, and then I'm just wondering from your professional perspective.
Yeah, so, I mean, under current law, there is no Maryland residency requirement for any personal representative. So I was born and raised, well, I was born in Baltimore, raised in Howard County. I could become personal representative as a U.S. citizen under current law. I could move to Moscow with no intent on ever returning and remain personal representative. That's current law. So I think that requiring residency, I think part of the issue, and I think we don't have anyone from the private bar here, but an awful lot of people in Maryland, their only closest relatives don't live here. They may have cousins or nieces or nephews or siblings or children who don't live in Maryland. So we have a lot of personal representatives who live elsewhere in America and abroad. Sometimes we have personal representatives who are appointed here and they will move. We have a personal representative right now in Howard County who lives in the Virgin Islands. But they're a U.S. citizen, so they qualify. So I think I understand where the bar is coming from, but I think to Delegate Warman's point, and maybe Ms. Good can get into this a little bit more, is we're dealing with people who, with the proposed amendment, it's the people at the margins who are really going to be most negatively impacted by that. So for example, if you have, let's just say you've got two best friends from abroad who come to Maryland on a student visa. So my only connection here, my only personal connection here in America is not my husband or wife or my partner or my child, it's my friend. They're probably really well positioned to take care of my estate, but they can't under Maryland law, and they would not under that amendment either.
If we just removed everything except for unless the person is domiciled in the United States, so that you're not then having somebody who is a non-relative, not living here, no connection whatsoever to anything here except that they've been either named or they're coming and saying, I should be the personal representative. Because right now, even if they're named, they can't be the personal representative in this.
Right, under the original text of the bill, they could be appointed, but they would have to be named as the PR in the will, a valid will, or they'd have to be appointed by a court. So somehow they'd have to navigate that. We probably wouldn't see that many of those kinds of cases, and the person would have to kind of really want it to go for it. So I think, but those are, I don't know if I can hand it off to a panelist to talk about that.
Okay.
Sure. Yeah, the other thing I'll point out that I don't think has been raised yet, if you're not a resident of Maryland, there is already a provision that you're also naming a resident of Maryland to be the agent during part of this process. So there's still, for folks who are trying to serve from outside the state, there is still some, forcing of them to anchor somebody who's involved with the estate within Maryland. But yeah, we would, like from the perspective of an attorney practicing, serving folks who are low income, we would strongly oppose this amendment because it really kind of guts and weakens the purpose of this bill. Regardless of citizenship status, many of the people that we work with rely on more extended family networks. Their closest relationships are cousins, non-married partners, et cetera. So we're really asking for you to support a clean passage of this bill. Like we said, other states aren't requiring these restrictions, and it's not posing issues. Whether or not someone can serve as a PR is really about their ability to be a trustworthy person and engage in this process, and one's citizenship status has no bearing on that.
Okay, thank you. Delegate Moreno?
Thank you, Madam Chair. How does this reduce Maryland probate costs by allowing non-citizen relatives to serve as executors? And I guess this question would probably be for Registrar McFarland.
So the question is, sorry.
Oh, how would this reduce the Maryland probate costs by allowing non-citizen relatives to serve as executors?
Yeah, so something I always try to share with folks is that people think, when we hear the word estate, we think of a lot of money. In terms of the probate estate that people have, not everyone who dies has a probate estate at all. For me personally, and a lot of estates and trust folks, because this is what we do for a living, we have all of our assets jointly held. We have beneficiaries, we have trust, those kinds of things. I don't have a trust, but we're able to avoid the process entirely. So probate actually disproportionately hits people at the lower end of the economic ladder, and it disproportionately hits people of color. That's the truth. It's also true that the average, in Maryland, the average estate, most of our estates are valued at under $50,000. And again, people hear the word estate, they think millions or hundreds of thousands. And even in Howard County, which is a wealthy jurisdiction, the median value of estates in Howard County is under $10,000. So when you're talking about someone having to go out and hire an attorney, a lot of attorneys will not even take those cases for two reasons. One, it's not worth, I think some of them might say it's not worth their time. Some of them would also say, from a professional integrity perspective, they can't in good conscience take that case. You know, your brother died, you want to be appointed as PR, it's an $8,000 estate, I'm going to bill you $4,000. I can't in good conscience do that. And so then what do? And under current law, they don't have any recourse.
Do they go pro se at that point, or?
If they can't be appointed, they don't have an option.
Okay,
Yeah.
thank you.
Great, thank you. Members, any other questions? Seeing none, that concludes the panel for House Bill 963, and it also concludes our bill hearing for that bill. We're going to move on now.
Thank you.
Just one moment, please. We're going to move on to Delegate Phillips, House Bill 1575. I'm going to call up Alice Barrett, Joseph Mead, Stephanie Wolf. Oh, Delegate Phillips, if you don't mind, can you just give us 1 second? We may have to have a bill hearing before your bill. I apologize to your witnesses. Yeah. Okay, thank you, Delegate Phillips. We're going to call up Delegate Williams, House Bill 1061. I'm calling Tara Jackson. And you all will be able to begin shortly. Okay. So we have Tara Jackson.
Yes,
Yes, you can have a seat wherever you feel comfortable.
thank you. Come on. Okay, great. Wonderful, wonderful. Good, and I think,
I'm sorry?
is this it for the panel? Yeah, I think this is it for the panel, because the chief
It's just me speaking.
because the chief's not able to make it correct. Yeah, the chief's not able to make it. Okay.
Okay, Delegate Williams, whenever you're ready, you may begin.
All right. Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the best committee in the House, the House Judiciary Committee. I am Delegate Nicole Williams, representing District 22, and testifying in favor of House Bill 1061, also known as the Criminal Law Wearing, Carrying, or Transporting a Handgun Prior Convictions. This legislation is really simple, and it's really to just address a loophole in the law as it relates to the Maryland handgun sentencing statute, just really to ensure that courts can treat prior convictions from other jurisdictions the same as if it was a conviction here in the state of Maryland for purposes of the sentencing when a defendant reoffends. That's all this bill does. So this loophole is present under Section 4-203 of the criminal law article. In cases where a defendant has prior convictions under this section in Maryland, enhanced penalties can currently apply. However, the same cannot apply if they've been committed of that exact same crime in another jurisdiction. And we have lots of other places in our criminal code where we can bring in prior convictions from other jurisdictions for purposes of sentencing. And so this bill is really just trying to really fix that one loophole that we see here in our law. It's really aiming to ensure consistency and uniformity in sentencing, and really doesn't create any new crimes, doesn't alter any existing penalty structures, and like I said, is really just clarifying and correcting a piece of legislation just to align it with other places in the code as it relates to how we deal with repeat firearm-related offenses. And so for those reasons, I'm urging this committee to give a favorable report to House Bill 1061. And I know my awesome state's attorney can really elaborate a little bit more about why this is needed.
Thank you. Good afternoon. Tara Jackson, and I'm honored to serve as the state's attorney for Prince George's County. I want to begin by, of course, acknowledging Chair Bartlett and Vice Chair Davis. Thank you for all the work that you and the members of the committee do in creating safer communities throughout the state of Maryland. Last year in Prince George's County, we had a significant decrease in overall violent crime compared to 2024. Carjackings were down about 50%, homicides were down about 40%, numbers that far exceeded the national declines. And that progress reflects the hard work and collaboration of all of our law enforcement partners, and I think I just saw one walk in, Sheriff Carr, and strong collaboration with county leadership, state leadership, and community organizations. But we have a lot of work to do. Still, too many persons are victims of gun violence. In fact, just this year in Prince George's County, we've already had, I think, 15 homicides, all of which were committed by people using guns. And then there are the non-fatal shootings using guns, the carjackings using guns, the armed robberies using guns, and the assaults. There are far too many illegal guns on our streets, and oftentimes people don't leave their homes intending to use the gun that they are illegally carrying, but they find themselves involved in an altercation or an argument that escalates and out comes the gun. And we all know that no good comes from that choice, but the gun was readily available for use. In fact, it's not unusual for us to find that our defendant and victim were both carrying guns. And in some cases, we see the witnesses carrying guns as well. In Prince George's County in 2024, we had 1,529 arrest warrants involving a 4203 handgun charge, which is the wear, carry, transport prohibition. And in 2025, we had 1,360 arrest warrants for that same charge. Too many. So what do? We have to send a strong message to those who choose to illegally wear and carry handguns, and to those who do so repeatedly without regard for the law. Maryland Criminal Law 4203, as you've already heard, prohibits persons from wearing, carrying, and transporting, and that same statute provides for enhanced penalties where defendants have been previously convicted of the same offense. But the problem is, as you've heard from Delegate Williams, Chair Williams, is the prior conviction has to have been in Maryland. That is why we worked so hard to bring this common sense, practical legislation forward. And I thank you, Madam Chair, for caring about the public safety and for sponsoring this legislation. This legislation is being proposed simply so that prior gun convictions in other jurisdictions matter, so that prosecutors are able to seek enhanced penalties when the prior firearm conviction occurred in Washington, D.C., Virginia, or Pennsylvania.
Madam State's Attorney, I'm so sorry to cut you off, but we do have a time limit here, and you've exceeded it, and I gave a little bit of leeway. If someone has questions, then that way you might be able to elaborate more.
I apologize, Chair. I thought I was given wrong instructions.
No worries, no worries. Thank you so much, and we're going to go on to, I didn't get your rank, Carr. But
this is our sheriff for Prince George's County, Sheriff John Carr.
Thank you. All right, thank you so much.
You have him on the witness list, Madam Chair. We weren't certain.
We're good.
Okay.
Sheriff Carr.
Okay, well, good morning, everybody, and thank you for allowing me to come here and actually testify. I am asking for a favorable review of this bill as we talked about gun violence. I am in support of our county attorney and basically talking about the violence that we've seen in Prince George's County, and not just only in Prince George's County, but really throughout the state in dealing with gun violence. I believe that this bill would be able to strengthen our prosecutors in making sure that they're able to keep our citizens safe, especially when it comes to those who have actually been committed or convicted of a crime or gun violence, having a gun violence crime or a crime in which they were carrying or a possession of a firearm from another county or another state. So I am just asking for a favorable review, and I'm here to really answer any questions when it comes to whether our county or just really throughout the state as far as what we see as far as trends.
Perfect. Okay, Assistant State's Attorney Whittam, you're here for questions, right?
Yes.
Okay, all right, that's what I thought. Okay, members, do we have any questions? Delegate McComas?
I just want to ask, okay, so somebody gets caught with an illegal gun or whatever, and how quickly can you get the background that they have been the same kind of problem in, let's say, Washington, D.C. or an adjoining state, or even if, you know, it's California or something? How's the process, how do you want the process to work so that you can swiftly get the guy where you want him?
Sure. Well, I'll turn it over to our assistant who's over the gun unit, but typically we have records, at least for our adults, in short order when we have NCIC checks. So typically we'll have those. For young people, for juveniles, we don't have those as quickly, but I know that we're not dealing with juveniles necessarily with this law. Is there anything?
Thank you. The long and short is what Ms. Jackson said. We run the NCIC through our investigator. We get that back within, I'd say, maybe 48 to 72 hours from when the request is made. It's then incumbent on the state's attorney prosecuting the case to review it, determine what, if any, out-of-state convictions would exist relevant to this bill, and then to inform opposing counsel and the defendant of our intent to seek the subsequent offender penalty. So it's fairly swift.
I guess my concern, though, is let's say they are a bad person and they have had a lot of gun violations. You may not get them bonded up, you know, get them in jail for a while until you know, so that they're going to get bonded out or they get recogged, and then they just disappear into the Ethernet. So how's that going to work? I'm just wondering how that could work.
Sure. Do you mind if I? Yeah, go ahead. So when a case is initiated by law enforcement and the person is seized and brought before the commissioner, one of the first things that happens is the commissioner also runs an NCIC check right away and prepares what's called a pretrial sheet, which is reviewed at the bond review hearing. At that point, one of our state's attorneys who is in the courtroom at the bond review hearing or the commissioner themselves would see the prior record and would make the appropriate determination.
So the commissioner or the judge would then make the decision that they need to be bound over?
Yes, ma'am.
Okay. All right. Thank you.
Thank you. The Vice Chair?
Thank you. I understand that it's important that we note that there is a pattern with illegal gun use, and maybe just not in the same state. I understand that. I have a question. Do you have a problem with limiting to 10 years, within a 10-year period? Or do you have putting guardrails on the law?
Thank you for your question, Madam Vice Chair. I don't see yeah, I would be concerned about limiting. If it's a conviction, it's a conviction. I think from a prosecutor's standpoint, we want to know everything that's on the person's record. Now, if it's expunged, then we wouldn't have that information. But if it's a conviction that is still active, we would want to know about those.
Conviction that's active?
Meaning a current conviction that is on the person's record.
And they've served their time?
Yes, even if they've served time.
I asked the question because there's a big difference between a 20-year-old with a gun and a 50-year-old, let's say, with a gun, and then giving them enhanced penalties for something they did at even 16 or 17.
Sure. And, the prosecutor has discretion to determine what's appropriate under the unique set of circumstances. So I'm not suggesting that we will always ask for enhanced penalties, but what I'm saying is that not to have the ability to consider, for instance, in Prince George's County, a conviction that happened 5 minutes away in the District of Columbia is definitely tying our hands. Because, as you know, crime is fluid. And people move from the district to Maryland every day, live in one place, commit crimes in another jurisdiction.
Yeah, I understand the jurisdictional issues, and I don't have any objection to that. My concern is that the time between one offense and the other.
And so I don't want to jump in on that. I think your concern would probably be valid, but I think this is more for having that tool in the tool belt. The prosecutor does have that discretion in reference to how they would actually execute as far as moving forward with the charges itself, but you really want to be able to look at the totality of that individual as far as them actually having maybe a handgun conviction, maybe somewhere else, and even in that 10 years, as you said, who you are in your 20s, you're much different in your 50s. And you have to take consideration of that when they're actually going to trial. So I think just having it in the tool belt doesn't mean that it will be used in that type of form and fashion just to, hey, this is something I made a mistake when I was younger, now I'm older, and now I'm suffering more of a heavy penalty. I do have faith in our judicial my partner.
Also,
yeah.
You understand that the bill is statewide, though, right?
Yes.
Thank you.
Go ahead, if you wanted to add something.
Thank you, Chair Bartlett. To Vice Chair Davis's point, we actually had a case come across our desks in my unit. I run the firearms and narcotics unit for Prince George's County. We had one of these exact situations come through our desk earlier today. One of my prosecutors brought it to me, sought permission to not pursue the subsequent offender for this exact reason. A conviction more than a decade ago, and he's a tow truck driver. The police asked if he had a firearm. He said yes. And he was very forthright. This is a perfect example of someone who's not flagrantly violating the law on the regular, but does have a prior conviction and would be subject to this tool. We exercised our discretion and made an offer to the defense not considering the subsequent offender penalty. It's not a requirement, it's an option.
Okay, thank you very much. Members, I don't see any further questions. So that concludes this panel and the bill hearing for House Bill 1061. Thank you very much.
Thank you.
Delegate Phillips. House Bill 1575.
Thank you for coming down. I didn't think you'd be able to.
I'm going to call up again, and I apologize that we couldn't keep you up here, but Alice Barrett, Joseph Meade, Stephanie Wolf, and Noreen Shaw.
Thank you. Madam Chair, Madam Vice Chair, and to members of Judiciary, give me a second to get myself together. I need the bold print. Here we go. All right, good afternoon, Madam Chair, Madam Vice Chair, and the members of the Judiciary Committee. As you know, I'm Delegate N. Scott Phillips, Legislative District 10, requesting a favorable report on House Bill 1575, the Community Trust Act. This bill does one essential thing. It draws a clear constitutional line between Maryland's criminal law enforcement responsibilities and federal civil immigration enforcement. House Bill 1575 prohibits state and local correctional employees and law enforcement officers from inquiring into a person's citizenship or immigration status during routine stops, searches, arrests, or booking, unless it is material to a criminal investigation or necessary to provide a protection under law. It prohibits detaining or prolonging detention based on solely on suspicion of a civil immigration violation. It prohibits transferring an individual to federal immigration authorities or notifying immigration authorities of custody unless there is a valid judicial warrant. And the bill makes clear that administrative documents issued by federal agencies are not valid judicial warrants. It also requires agencies to adopt written policies and provides accountability if those policies are violated. What this bill does not do is equally important. It does not prevent cooperation on criminal matters. It does not shield violent offenders. It does not interfere with federal supremacy. If federal authorities present a valid judicial warrant, cooperation may occur. But civil immigration detainers are not signed by judges. Their administrative requests holding someone beyond their lawful release based solely on that request exposes local jurisdictions to constitutional liability. The Fourth Amendment protects persons from unreasonable seizures. The Fifth Amendment guarantees due process to persons. Those protections are limits on government power, and they are not limited to citizenship. At this moment in our country, we are seeing aggressive civil immigration enforcement tactics, extended detentions, custody notifications, and status inquiries during routine encounters. When state actors participate in civil enforcement without judicial process, constitutional lines blur. This bill restores clarity. It protects Maryland taxpayers from costly litigation, and it protects public safety. When immigrant communities believe that any interaction with local police could trigger immigration consequences, crimes go unreported, victims stay silent, witnesses disappear, trust erodes. Effective policing depends on cooperation, and cooperation depends on trust. The Community Trust Act ensures that Maryland law enforcement remains focused on criminal law, while civil immigration enforcement remains a federal responsibility carried out with proper judicial process. This is about constitutional fidelity, public safety, and clear lines of authority. For those reasons, I respectfully ask for a favorable report on House Bill 1575. Thank you. All right, we can start to my right and work our way over.
Thank you. My name is Doreen Shaw, and I'm the Director of Immigration Policy at the National ACLU. In my role, I work with legislators around the country who, like you, are debating how to best protect their communities in the face of masked violent federal agents who are tear gassing children, dragging elderly people from their cars, turning our highways into immigration checkpoints, following families into the emergency room to deport them, killing people, and covering it up, all in the pursuit of deporting 100 million people. They are unleashing this terror in states around the country, states like Florida, where they are welcomed in. In the face of this enormous assault on our rights and safety, many states are considering measures like this one, which would protect our communities by ensuring that Maryland residents do not have to fear that by calling 911, they're inviting ICE agents to their doorstep. By passing the measures of this bill into law, Maryland would join states like Oregon, Washington, California, Illinois, Colorado, Vermont, Maine, New Jersey, Connecticut, and Rhode Island. In the days since Governor Moore signed the 287G ban, it's important to note that we've seen sheriffs move to circumvent this ban, using informal collusion arrangements that are beyond public scrutiny that open up counties to liability. One sheriff in a county said he planned to provide arrestee lists to ICE to review and check it. Another said he was replacing his 287G agreement with, quote, something that doesn't look much different. We know what happens if we fail to act today. We've seen that where loopholes exist, ICE will move in, exploit them, and cajole local law enforcement into assisting in a dangerous, deadly drive to deport our neighbors and family members. We can't let that happen. I urge a favorable report.
Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the committee. Thank you for the opportunity to provide informational testimony about the legality of this bill, House Bill 1575. My name is Joseph Mead. I'm Special Litigation Counsel at the Institute for Constitutional Advocacy and Protection at Georgetown Law. I spent nearly 20 years studying, litigating, teaching, and advising units of government on the Constitution, including federal versus state authority and the constitutional context of immigration. This bill does a couple of important constitutionally grounded things. First, it reaffirms Maryland's sovereign authority to decide how state and local resources are used. And second, it ensures that state and local officers comply with constitutional requirements. First, under our system of dual sovereignty, the federal government may, and obviously does, enforce federal immigration law, but it may not conscript state and local governments to do so. Maryland is thus free to decline to participate in federal immigration enforcement. Many jurisdictions, as my colleague pointed out, across the country have made similar choices, and courts consistently and uniformly have upheld policies like those in this bill. Second, the bill clarifies that state and local governments may not detain somebody solely on the basis of an ICE detainer or administrative warrant. Under the Constitution, law enforcement generally needs probable cause to believe that a person committed a crime in order to detain them, and absent an exception, that detention must be pursuant to a judicial warrant. ICE detainers do not justify a constitutional seizure. They generally do not state probable cause that the person committed a crime, and they are not warrants in the constitutional sense. Neither federal nor state law authorizes state or local officers to detain someone based solely on an ICE detainer. This bill properly leaves enforcement of immigration law to the federal government while protecting Maryland residents from unlawful detention. The bill conserves state resources, reduces legal risk, and reinforces the structural safeguards of federalism. Thank you.
On the end, if you, oh, yep, thank you.
Thank you. Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. The Maryland Office of the Public Defender respectfully urges this committee to issue a favorable report on House Bill 1575. This bill promotes trust in our institutions by creating a clear, uniform, easily implemented policy statewide that keeps our law enforcement separate from ICE and ensures that our officials remain focused on public safety through the enforcement of state law. I want to briefly highlight two ways that the status quo undermines trust. First, disparate local jail policies are causing widespread Fourth Amendment violations now. Across Maryland, people are being held on administrative ICE detainers after they are ordered released from local custody without judicial authorization. This occurs both because some jurisdictions have written policies that systematically allow for illegal holds, and because some policies are unclear or difficult for correctional officers to implement. This bill clarifies that proper legal authority is required for any arrest or continued detention, protecting basic rights and reducing the risk of lawsuits. Second, informal collaboration across the state is undermining due process, particularly when officials help ICE arrest someone before their day in court or after their case ends without a conviction. These notifications frequently funnel Marylanders into deportation proceedings on the basis of charges that are never proven, on the basis of wrongful arrests, false accusations, and minor offenses. 78% of ICE detainer arrests in non-287G counties in Maryland in 2025 involved people with no conviction at all, and many more involved people convicted only of traffic offenses. Communities can see this pattern, and it erodes trust. And for those reasons, we urge a favorable report.
Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the committee. My name is Alice Barrett. I'm here today representing We Are CASA as a managing attorney for Immigration Legal Services in strong support of House Bill 1575. Thank you, Delegate Phillips, for sponsoring this bill. For nearly 40 years, We Are CASA has worked with immigrant families in Maryland, and today we serve more than 180,000 members and handle approximately 1,800 service cases a month. We operate Maryland's largest raid response hotline. So when we speak about the consequences of local cooperation with ICE, we're not speculating, rather we're responding to what CASA members are living through every day. Last week, Governor Moore signed into law a ban on 287G agreements, and this victory was absolutely critical, but it was only the first step. In 2025, nearly 29% of Maryland residents arrested by ICE were transferred directly from local jails, and more than 80% of those transfers were unrelated to 287G. While we stopped formal agreements, law enforcement is still cooperating with ICE informally and voluntarily every day. Informal jail transfers are now the primary pathway for Maryland custody into ICE detention. For CASA members, this means a parent disappears before their case is resolved, children lose their primary caregivers overnight, rent goes unpaid, victims never get to see justice when their prosecutions are disrupted, businesses break down, and once members are transferred, we have countless reports of extremely violent arrests, shackling hands and feet, denial of food, water, basic medical care, overcrowded conditions. For some, getting transferred to ICE is a death sentence. This bill does nothing to stop ICE from doing its job. It only limits Maryland's involvement in ICE's work in ways that circumvent due process and co-opt limited state and local resources for the now most highly funded law enforcement agency in the country. And it ensures law enforcement follows the Constitution. For these reasons, we respectfully urge a favorable report.
Thank you, everyone. Delegate Erica.
Thank you, Madam Chair. Thank you, Delegate. Could you just walk me through what the process would look like now? Let's say, you know, in Hartford County, we pick somebody up on a crime suspected of, I don't know, distribution of child porn. We bring them in. What does it look like now? How do we interface with ICE now?
So let's take ICE out of it. Let's just focus on the fact that an individual was picked up, any individual was picked up for an allegation, and you mentioned a felony, and that individual would go through the normal processing. Should the court determine that that individual should be detained and maintained in detention, that's exactly what would happen. Eventually, there would be a trial and there would be a finding. During that period of time, if that person happened to have an outstanding warrant or be on the radar of ICE, as you know, they have access to all of the same databases that all of our crime enforcement organizations do. They would then reach back out to that agency, and if it was appropriate, they would get a judicial warrant, and they would serve that judicial warrant.
How? I'm very confused. So we have the person, they go through our legal process. Mm-hmm. How is my officer to know that they should contact ICE to find out if the person was supposed to be here or not supposed to be here?
So I think the answer to that, Delegate Erican, is that it is not the responsibility of the local officials to determine whether what somebody's civil immigration status is. That's ICE's job.
Okay, I hear you, but the governor, when he signed the bill you referenced, actually said, and I'll just quote him, "We will continue to work with federal partners to hold violent offenders accountable." So he's saying we the state of Maryland, will continue to work with ICE to arrest bad people and then have them removed. So how does this bill dovetail with what the governor has quite literally just said we intend to do as the state of Maryland with our law enforcement?
So I think first of all, he said we'll continue to work with federal partners to hold violent offenders accountable. There are a number of different federal partners that the state works with, and ICE has been historically one of them, but is certainly not the only one, nor the most effective one from a public safety standpoint. The second is when somebody is booked into the jail, they are fingerprinted. Those fingerprints go into the FBI database, and if that person is someone who ICE is looking for, then DHS gets a notification affirmatively. Whether ICE gets a notification or not, they have access to the FBI database. So we're not hiding, this bill does not hide any information from DHS. It simply says we are not going to use our resources to do their investigation.
Okay, and so here's another scenario that I'm trying to understand. We have somebody come in, let's say we picked them up on something smaller, not a felony. Maybe it's a nonviolent crime. But this individual did get convicted in another jurisdiction, let's say in the state of Virginia for an atrocious crime, and ICE has been looking for them. How would that person be caught here?
again, and I'm sorry, Delegate.
No,
Phillips,
go right
I
ahead.
mean-
Go right ahead.
ICE would be notified when they're booked into the jail. If ICE is looking for that person, they're going to get a notification that the person has been booked into the jail. And from there, ICE, with its very, very substantial resources, can conduct its investigation and make the arrest as appropriate. They do not need our help to do that.
Unfortunately, what I've heard in this hearing, however, is that we will not be respecting detainers unless it is something that is charged with a crime here, a violent crime here. You're looking for the worst of the worst. Well, this person wasn't charged with that. So we will not be respecting detainers per what was just spoken in this hearing 5 minutes ago.
But Delegate, let me say this. The reality is, once again, at $80 billion, they have the resources to comb every database available to identify when an individual is picked up. And once that individual is picked up, they're going to get a notice. And once they've gotten that notice, they can then go to a judicial officer, get a warrant, and come back to whatever jurisdiction it is and say, we have a warrant for that individual. And that would be under normal circumstances, whether it's a U.S. citizen that gets picked up in Florida but has a charge in Maryland, that's the same process that would work. So the process really isn't different. And once again, these are persons, and persons have Fourth and Fifth Amendment rights, in my opinion. And that's why the bill is going this way.
Okay, well, unfortunately, that, as you probably know, that's not how ICE works. They don't ever get judicial warrants. That's not how they have. It's in-house, as we've heard many times, by ICE themselves. By ICE themselves has come here and spoken to us and said, here's how we decide to do a detainer. We do not go to a judicial officer. We have it in-house. That is the stated policy of that organization. So, and we've had the same debate numerous times here about how that is not realistic. It's not efficient, and it's not how it's done. So if we do not have a judicial warrant, what I'm trying to make sure we understand here when we pass this bill, if we pass this bill, is that someone who committed an appalling and atrocious crime in another country or another state, but here was picked up on something minor, we will not respect the detainer. We will not respect it per the way that you've described the bill, and therefore we will be actively permitting horrible criminals who have committed awful crimes, either here or abroad, to be released because we do not respect ICE detainers unless we have charged people with violent crimes.
Delegate, if I can help address that question of would ICE ever be able to get a judicial warrant? The reality is they do. And in fact, I spoke this morning with one of my colleagues who is a former ICE longtime official, and I said, what would they do in this situation? And she referenced to me 8 U.S.C. 1253, they could get a warrant, and they have done this in precisely these circumstances. They could get a warrant based on illegal entry or reentry. These are criminal provisions. Look, ICE, as I mentioned, there are a number of states that have bills like this. ICE has been dealing with this for quite a long time. ICE has the ability to go get a judicial warrant if we're talking about a situation where they can get a judicial warrant.
Okay, so that is not what ICE told us on the record in this very chamber not very long ago. So they said the exact opposite. They said that is not what we do. So
I think, Delegate, they said that's not what they do, but that's not necessary. They can do it. It's a choice that they've made to leverage the administrative process versus going to a judge. And in my estimation, much of that is because if I take it to a judge, then there's a different standard that they're going to have to adhere to.
okay, well, I appreciate that, and my final comment will be isn't that so? It was said that ICE is not very good at the job they do, but I will say for the record that the Baltimore ICE detention facility and the folks that work there have the highest number of collection of child predators in the nation. So they are incredibly successful at getting people that rape children and babies off of our streets. Thank you. And that's so.
And to that, Delegate, I want them to continue to do that, but I want them to do it under the color of law here.
Thank you. Delegate Williams?
Yes. Thank you, Delegate Phillips, first for, number one, just bringing this bill, this really important piece of legislation. I wanted to, I guess my question is for Ms. Wolf. In your testimony, you were describing how people are transferred from ICE to local jails in Maryland that had no criminal conviction. Was wondering if you could speak more about the difference between the charges versus the conviction when it comes to people being funneled, by ICE.
Yes, thank you, Delegate, for the question. When people are transferred from a local jail to ICE, this is the same population. I know everyone on this committee is familiar with the debate over the 287G program. The population being targeted by these informal forms of collaboration is the same population that's being targeted by 287G programs, which are folks who often are being released from a local jail before their day in court, or they're being released from a local jail after their case has resolved without a conviction. And that's why we see, when you look at the ICE detainers in Maryland non-287G counties that resulted in an arrest in 2025, 78% of those people did not have any conviction. Not a conviction in this case, and not some conviction previously. And that is who is being primarily targeted. And as I said earlier, people can see this pattern, and what it results in is the perception and the reality that even very minor interactions with our law enforcement, even interactions that you didn't anticipate were going to result in you getting arrested, even interactions where there's been a false accusation or a mistaken identification, those are resulting in people getting transferred to ICE. We heard this very eloquently from many people in Wicomico County as they described why they didn't want a 287G agreement and what they were already seeing with the informal participation that that county was already engaged in with ICE. They can see that pattern, that this is not targeting people with serious convictions, that it's targeting people who just have been swept up into the legal system.
Thank you for that.
The Vice Chair.
Thank you, Madam Chair. This question is for Mr. Mead. You spoke about the many cases that show what's happening with these holds that are unconstitutional. How much are the litigation costs, and do the counties pay for this?
Yes, the counties would pay, and it can be quite substantial, and the risk is significant. Recently, a jury awarded plaintiffs in Suffolk County, New York, $125 million in damages, plus the attorneys have submitted a bill for $5.5 million. And that's just the plaintiff's attorneys, in addition to whatever the county spent on its attorneys to litigate this case. There are other examples. New York City recently paid $92.5 million. Attorneys have sent a bill to LA County for over $4 million. So the risks can really add up. And I would just say that in addition to this liability exposure, every dollar, every hour that is spent doing the federal government's job for it is one less hour, one less dollar going after the criminals, going after the people who are committing crimes in our community and keeping our community safe.
Thank you.
Thank you. Delegate Emery?
Thank you, Delegate Phillips. I wonder if you or one of your colleagues, or on the, one of your co-panelists, could talk about how this relates to the 2021 Dignity Not Detention Act.
Sure.
Thank you, Delegate Embry, for the question. The Dignity Not Detention Act prohibited police on the, among other things, prohibited police on the street from inquiring about civil immigration status, from doing investigation in the course of their work, from prolonging someone's detention or detaining them in the first place in order to investigate their immigration status. It did not prohibit them from communicating with ICE, as long as that communication doesn't prolong detention. I think at that time, this body probably didn't think that it was necessary to specify that, because if you're not communicating about status, then what would there be to communicate with ICE about? But what changed in 2025 is that hundreds of thousands of ICE warrants were uploaded. ICE warrants, which are administrative warrants not reviewed by a judge, were uploaded into NCIC and are now visible to police officers as they conduct their traffic stops and their interactions with the public. This bill would close that loophole, which I don't think that this committee intended to open or to leave open, and ensure that police cannot communicate with ICE about someone, for example, that they've encountered in a traffic stop or in some of the course of their other duties. It also strengthens the intent of dignity not detention to ensure that we are not using our local jail resources to house people who are really being detained for ICE. The Fourth Amendment violations that I mentioned earlier are instances where our jails are housing people after they've been released by the state courts, merely for those people to be picked up by ICE. Essentially, we're lending them bed space and we are not charging them for it. Dignity not detention prohibited us from leasing bed space to ICE, and this would fully effectuate that concept in Maryland. Thank you.
Delegate Cardin?
Thank you, Madam Chair. Thank you all very much for coming. Ms. Shaw, it's great to see you in person. So first of all, if in fact the policy is to do these administrative warrants and for expediency purposes, it's not unprecedented, nor is it that difficult to change the policy to get to access judicial warrants. It may cost them a little bit of time, maybe a little bit of money, but it wouldn't be impossible and it would create greater oversight. That's question number one. Is that true or is it not true?
I would say that's true.
Okay.
Delegate.
Okay, thank you. Number two, your bill allows for the inquiry into information that's material to routine booking. Is there any concern that there can be a policy created that might include immigration status and other information that might inadvertently be allowed in this bill? That would be number two. And then I have one further question. So
I'd like to answer that.
I'll give you the third question just to make sure. I think this is direct to Ms. Shaw. You mentioned a number of other states, I think like over a dozen states that are already trying to adhere to this policy. Can you just describe what's happening in those states and whether it's working or not?
Thank you, Delegate. I'll start with the last question. So I mentioned Oregon, Washington, California, and Illinois. They have bills that are quite like this one. We also have measures that have long been in place in Colorado, Vermont, Connecticut, and Rhode Island. New Jersey has these same kinds of protections through an Attorney General directive, which because of the way that government is set up is actually binding. Maine just passed enacted a bill recently that includes some of the protections of this bill. So it is a huge swath of the country. And you see in these states, I mean, some of them like Washington and Oregon and California, they've had some kind of bill like this for quite a long time. ICE continues to operate in those states. ICE can seek judicial warrants. ICE can get information because of the fact that when people are booked into local custody, their fingerprints are automatically shared with the FBI's database. They are automatically, DHS is finding out about these individuals, and it has the capacity because Congress has given $170 billion to the immigration agencies to do immigration enforcement work. They have the ability to pick people up. The other thing I want to mention is the states that don't have measures like this. And one might say, well, in those states, are things better in any way? You know, look at a state like Florida. I talked to my colleagues there quite a lot about, well, is ICE in Florida? I mean, Florida, every single sheriff in the state is cooperating as even part of the 287G program, is out there working with ICE. And the reality is that people in their day-to-day lives are being picked up by ICE. Farm workers are being stopped in their work buses. People are being arrested for walking their dog on the wrong part of the beach and then being funneled into deportation. So we know that these policies work, and we know that in places that don't have these policies, people are not safe from the terror of ICE raids and ICE deportations.
I can take the second question, Delegate. So with regard to routine booking procedures, I know my colleague with the public defender can elaborate more on precise definitions of that under case law, but the notion there is that as part of routine booking, that is when basic information would be entered that would go into the NCIC database, which in fact enables ICE, right, to continue doing its job and locate individuals themselves. That's certainly the intention. It should not be used as a process where specific inquiries would be made by local law enforcement. However, routine booking in that sense does make it possible for ICE to have the information that they need to use their immense amount of resources to seek judicial warrants for those individuals who were booked in whichever facility, albeit with judicial oversight, as was addressed in your first question. And I'll just let my colleagues speak further to that as needed.
Thank you. Yeah, I would just say that in the context of the Miranda rules, there is a definition. There is some things are routine booking questions and some things are not. So there is a precedent for, we have a rule that says routine booking questions are okay and you can't go beyond that, and the courts have kind of interpreted what that means. So I think an analogous procedure could be applied.
Thank you.
Delegate Taylor.
I will. Thank you, Madam Chair, and sorry I was missing for a lot of this. I've been waiting to hear this bill. Thank you, Delegate, for bringing it. So forgive me if this question has already been asked, because how does this year's version of the bill compare to last year's? And Jane, is that? No? Oh, that's the wrong one. That's right. That was the question for the other one. That's right, because we're not on that bill. We're on this one.
I know what you're.
Okay. All right, now I understand.
Different
Okay,
bill.
then I do have a question for this bill too, of course. I do. I absolutely do. That's what you get for coming in late. I thought we were on the other bill. But can you guys talk more about how victims aren't able to get justice when their abuser is transferred to ICE before their case is done? Maybe somebody from CASA.
Well, I'll let somebody from CASA, but at the end of the day, right, I mean, we have a responsibility to prosecute those individuals who commit crimes here in the United States.
Yeah.
Right? And if a person is transferred prior to going through our judicial system, then victims don't get their just day in court.
Right.
They just don't. So I don't want OPD if anyone else was speaking.
Sure, I'll elaborate briefly from CASA. I mean, we've worked with many victims of crime in our line of work, including U visa applicants and others who have turned to the U.S. justice system to seek accountability for those who've perpetrated crimes against them. And when civil immigration enforcement is prioritized over criminal prosecution, it creates a lack of accountability for those offenders, and I think leaves the victims, in limbo. They may not have access to restitution. If we're talking about, a mother, she may not have access to required child support. If we're talking about individuals who have been removed before any prosecution could be carried out, before there's any accountability. I mean, unfortunately, there is also the risk of illegal reentry, right, if we're talking about offenders. And so it's not really the best approach to ensuring justice for victims. The proper approach is for civil enforcement and criminal enforcement to remain separate, and for the criminal justice system to be responsible for these prosecutions.
Absolutely. Thank you.
Delegate Valentine.
Thank you, Madam Chair. And thank you, Delegate, for bringing the bill and for the panel giving us a lot of information today. It's appreciated. I did want to touch on the normal booking procedures for a moment, only because in page 2 of the bill, I believe, I have it highlighted under I. I know a lot has been said about officers not inquiring about immigration status, citizenship, but at the end of that sentence in I, it talks about place of birth. And I just want to make sure that we're on the same page, that that is normal booking procedure, their place of birth. I know law enforcement for 30 years has been asking place of birth because it goes on fingerprint cards, like the FBI cards. So would that be considered normal booking procedures for the purpose of this bill?
I can answer that. I think it would, and my experience is the same as yours, that is a standard.
Just standard routine booking procedure. My next question, and I wanted to touch on when we were talking about running through databases and things like that, and that we do not want our local detention facilities to be doing that. Again, normal procedures, anytime someone's getting ready to be released, you run a wanted check. So you're going to be doing a national database search to see if anything does pop up. So that would also be considered normal procedures, correct?
Running the wanted check.
Or wanted check before you're released to make sure they're not wanted by another state, by anyone. So that's all normal procedures. The reason I'm asking these questions is because obviously this would affect individuals in these facilities that aren't here in this hearing and aren't, that I see on page 4, could be subject to damages, can be subject to things, and I want to make sure they're all acting within accordance of this bill. So we're clear on that. I know fingerprinting was touched on as a means of identifying people in the testimony, but my question for the fingerprinting is, if there's fingerprints in the system, correct? Because we all know in the last several years, there's hundreds of thousands of individuals, if not millions, that are in this country that weren't fingerprinted, correct?
There are people who are in the country who have not been fingerprinted. I think of the population of people who ICE would want to arrest, who ICE is seeking, if there's already a warrant for them, if there's an ICE detainer or ICE warrant in the system, then that's because they know who this person is. They, in almost all cases, are going to have fingerprints.
Have fingerprints, okay. Madam Chair, I have two more questions. One has to do with the purpose of, let me look here, should not detain or prolong the detention of the individual. And with this, I want to run a parallel with other states. And here's where I'm kind of going with it. So you run that wanted check before someone's released, and you might get a hit from, or a wanted inquiry from Pennsylvania, just say hypothetically. And at the time of that response, then there's certain requirements for the facility, and that could be to hold until they get more information. It could be hit confirmation via a teletype. It could be some documentation that's sent to the agency. But not always is there a warrant that's accompanied. It could be that that agency's in a location in a rural area that they may not have, and it may take an hour or two. And that courtesy is extended throughout this state and counties all over this state to let that agency, based on that initial teletype, that agency have time to get that to that. Are we saying that the federal government is not going to be given that same courtesy that another state would be for that 1 hour, 2 hour, maybe 3 or 4 hours? I've seen it statewide. They're not going to be given that same courtesy to produce that warrant or that what you're looking for, that judicial warrant. Is that the intent of this bill?
So I think if what you're asking is, should the facility presume that an ICE warrant is a judicial warrant until proven otherwise? I would submit that the answer to that should be no, because in the majority of cases, they are not. So yes, we are saying that when the person finishes their state court, whether it's a sentence or they're released on bond, when they're being released by the state court judge, we should not hold them additional time unless there is a judicial warrant. If there's some confusion about whether there is, you know, they can take reasonable steps to clear that up, but not to the extent of prolonging somebody's detention.
I guess my question is, and this has happened with another state that says there is, and then 3 hours later there's not, or something has been recalled, and we wouldn't be going after our detention center facility individuals because they may have held someone for 3 hours or 4 hours because it was a state charge from another state, but we would hold them accountable if it was a federal case?
I think
that's kind of my concern.
If I may, I believe it's also important to distinguish criminal from civil charges here once again. I think the examples that you're describing are likely related to criminal charges in other states, and this does nothing to limit criminal law enforcement agencies, right, from with regard to wanted checks. We're talking specifically about a very supercharged civil law enforcement agency where additional caution should be exercised.
Okay. And then my last question, Madam Chair. I know the comment was made about administrative warrants not reviewed by a judge. I believe you made that statement. But law enforcement serves warrants every day in the state that are not reviewed by a judge. State warrants that are not reviewed by a judge. By a judicial officer.
Judicial officer.
But not a judge.
That's correct, and I should have said judicial officer.
Okay. Thank you, Madam Chair. Thank you.
Thank you. Members, seeing no further questions, that concludes this panel for House Bill 1575. We're going to move to the next panel. And in that panel, I have Alexandra Morgarin, Diana Bergman, Joanna Silver, Marie Fouché, Evan Guevara, Callie Schmitz, Okay, could you just give me your name so I can mark, so I'll know who I have here?
Sure, it's Joanna Silver.
Thank you. And next?
Diana Bergman.
Okay,
Mary D. Fouché.
okay. And Callie Schmitz?
Yes.
Okay. So we have, okay. Do we have Alexandra Morgarin? Okay, okay, thank you. And what about even Guevara? Oh, Guevara. Guevara. Oh, okay. You're gonna do a way better job of pronouncing your name than I did. Okay, let us begin, please, from this side and just work your way down. Thank you so much.
Thank you, Madam Chair. My name is Joanna Silver. I am testifying in my personal capacity, but I've worked for over 20 years as a federal public defender in the District of Maryland, representing people involved in both the criminal and immigration systems. From that experience, I would like to share a few points in support of the Community Trust Act. First, it is in fact easy for ICE to obtain a judicial warrant if there is probable cause to believe someone committed a federal crime. ICE can alert our United States Attorney's Office and present a complaint to a federal magistrate who can in turn issue a warrant. There is a U.S. attorney and a magistrate judge on duty at both federal courthouses in Maryland at all times. Similarly, if ICE or DHS needs information about someone for a criminal investigation, it can easily get a subpoena for that information from a federal court. This is a routine part of how all federal law enforcement agencies conduct their investigations. Second, ICE does not need the assistance of our local law enforcement or corrections departments to do their jobs. I have represented many people over the years who were released into the community from local or state jails, and ICE has used their resources to find them and put them into removal proceedings. ICE has more resources than ever with which to do this work without our assistance. Third, as I've testified to previously this session, in the past year, I have witnessed ICE prioritize deportation over everything else, acting with a complete disregard for due process and undermining rather than enhancing public safety. Among other things, they are repeatedly deporting people instead of allowing their federal criminal prosecutions to go forward. If ICE is willing to undermine the efforts of the United States Department of Justice in furthering public safety, then you can be sure that ICE is not interested in public safety here in Maryland. We can keep our state safe without enabling a cruel and unjust immigration system. I urge you to issue a favorable report.
Greetings, my name is Diana Bergman. I currently reside in Carroll County y soy orgullosa de ser cubana. As a resident in Carroll County, the same county that we watched a viral video of a mother's window be smashed as her daughter begged ICE agents to not take her mother, this happened last year shortly after our sheriff signed 287G agreement. Since then, I have witnessed and watch my current sheriff and other sheriffs continue to spread fear throughout our communities. The fearful rhetoric makes the sheriffs look uneasy, full of anxiety and uncertainty about their duties and responsibilities. By warning the public that ICE activities will increase in the state of Maryland, it comes across like they're unprepared to protect us all throughout the community and keep everyone safe and protected. These sheriffs seem confused and could use some clarification. These sheriffs are elected officials and serve an oath to serve and protect all and not based on immigration status. House Bill 1575, the Community Trust Act, will prohibit officers and agents of the state and local correction facilities from taking certain actions related to immigration enforcement. Other federal agencies, such as the National Security Agency, must obtain judicial warrants in order to obtain custody of an individual that might be in the custodian of local law enforcement. If we don't provide clear guidelines on how local law enforcement engages with ICE during transferring custody of individuals without a judicial warrant, it could get messy. The overall goal is to prohibit law enforcement agents from taking certain actions related to immigration enforcement. Our local and state officials are not immigration custom enforcement. It makes absolutely no sense to do their job of another agency and ignore the responsibilities of serving as a local and state law enforcement. I'm asking the Judicial Committee to set a clear message forward to outline clearly how state and local agencies perform their jobs and not their jobs in different agencies that harm and killed Americans. Please vote favorable for House Bill 1575, the Community Trust Act. Sí se puede. We can do this together by demonstrating what is expected of our local and state enforcement in the state of Maryland. Thank you.
Thank you, Madam Chair and committee members. My name is Callie Shumitz. I work for the Maryland Center on Economic Policy, and we're here in strong support of House Bill 1575, the Community Trust Act. Maryland's economy is stronger today because of our past choices that have made our state welcoming to immigrants. When immigrants move to Maryland, it means more jobs, more consumers, more workers, and more business owners. About 21% of Maryland's workforce are immigrants, and about 19% of economic output of Maryland's labor force is because of immigrants. Immigrants fill critical jobs in healthcare, construction, childcare, and many other essential industries. Immigrants run small businesses. About 1/3 of Main Street businesses in Maryland are owned by immigrants. And the taxes that immigrants pay are also critical to funding our public services that we all rely on. A Cato Institute study released this month that looked at decades of data found that immigrants pay significantly more in taxes than they received in benefits at all levels of government. So we're in support of this bill because community safety is essential for a healthy economy. If immigrants are afraid to go to work, to open their businesses, to shop, and to go out in the community, if children are afraid to go to school and get the skills that they need to join the workforce, that hurts all of us. So it is in our best interest to do everything we can to promote safety for our immigrant communities. So we respectfully ask for a favorable report on House Bill 1575. Thank you.
Okay. Time did it start? Yeah. Okay. Good afternoon. My name is Evan. I am 10 years old. I am a 4th grader at Featherbed Lane Elementary School. I was born and raised in Baltimore County, Maryland, and I am a member of We Are Casa. This is my first time talking at a bill hearing. I am here today to tell you about my favorite uncle, my Uncle Minor. I love him and I miss him a lot. Last year, when I was only 9, my uncle got deported. ICE took him. I am a kid and I don't know everything that happened. All I want to tell you that it's true. ICE is separating families. After he left, I got really sad and cried a lot. My Uncle Minor took really good care of me. He used to take me fun places. He would say that he loved me. And before he got deported, my mom took my brother and me to visit him when he was in detention. It was a scary place. I asked my mom if we could bring Uncle Minor back home with us. I really wanted to, but I couldn't. I was happy to see him, but I also was sad because he was still there. My uncle doesn't know that much about Honduras. He came to the United States when he was 16. That's just 6 years older than I am. He lived here for most of his life. His kids are here. I have 5 cousins and they all miss their dad so much. What happened to my uncle is not unfair. I support this bill because I think Maryland shouldn't be helping ICE to do things like this. I don't think our leaders should be helping ICE take our uncles and aunts and moms and dads away. It's happening to a lot of kids like me. That is why I wanted to tell you my story. Please pass the Community Trust Act so no one has to miss their uncle as much as I miss my Uncle Minor. Thank you.
Thank you, Evan. You did an excellent job. Thank you very much for sharing. Ms. Fouché?
Yes, good evening. My name is Mary D. Fouché. I'm a public health physician and an immigrant from Haiti. I have called the Eastern Shore home for the past 8 years. I am here to testify in strong support of the Community Trust Bill. I have been a social advocate on Maryland Eastern Shore, not from a distance, but from inside the communities. I know what it means to fight for our humanity. When Wicomico County faced a 287G agreement, over 200 community members show up at that hearing, and that same community is watching what this legislature does today. And please do not forget that this administration is manufacturing illegality by ending programs like TPS and by attacking the very refugees this country made promises to. Over 400 years ago, during anti-immigrant riots in London, Shakespeare wrote a speech known as The Stranger's Case. Imagine that you see the richest strangers, their babies on their back, plodding to the ports, and say the king should banish you. Where would you go? What country should give you harbor? That questions have never been answered. It is being asked again right now on the Eastern Shore. Karen McCabe, a teacher at Wicomico High School, told the Baltimore Sun, she is watching students be terrorized and abandoned. She is scared about suicides. She is watching kids crash and burn, and some don't even have family members left. You are moms, you are dads, you have kids in your life, you can relate. And do you know what happened to Karen McCabe? They didn't ask her to sit down with these kids and see what can be done, calling life crisis and see what can be done. They put her on administrative leave. Shakespeare understands that we are still struggling to accept cruelty toward the strangers does not protect the host, it degrades it. Let us be honest. On the shore, we have a strong community built by Haitian and H-2B visa holders. Those who profit from immigrant labor and immigrant rent remain silent when those families are being threatened. You cannot profit from a community while remaining indifferent to the suffering. Due process rights are for all, non-citizens and citizens alike. This bill protects that sacred constitutional right against seizure without a proper warrant, enshrined in the Fourth Amendment. The stranger case is not an abstraction. It is about the Haitian baby whose father was taken by ICE when he was 8 days old. It is about Kevin Martinez, diagnosed with cancer, who died in terror after his Mexican mother was detained. It is about this Venezuelan pregnant woman choosing between a prenatal appointment and deportation. I urge a favorable report. The question is the same one Shakespeare asked 400 years ago. Will we see ourselves in the stranger, or will we look away? Thank you.
Thank you. Thank you very much. Members, do we have any questions? Delegate Phillips.
Thank you, Madam Chair. And thank you, Evan, for being here today and sharing your story. Do you play sports, Evan?
Mm-hmm.
What sports do you play?
I play soccer and karate, and I do karate.
Soccer and karate. And you went to Featherbed. That was one of the schools that I used to play basketball. It's my neighborhood. That's where I grew up. So thank you for being here. Thank you for sharing your story about family and how important family is. Isn't that so, Madam Chair?
100% so. Delegate Moreno.
Thank you, Madam Chair. Thank you, Evan, for testifying. But this question is more about, it was discussed about the economical contributions of immigrants. Does anybody have any figures as to how much is contributed?
I don't have in my notes right here. I can follow up with you. I think what the figure I cite is about 19% of the output of the Maryland's labor force. So in terms of dollars, I think it's significant, but I don't have a number right in front of me.
In 2022, it was 100 billion, 60 federal and 40 state, but isn't that so?
Sounds
Thank you.
correct to me.
Thank you. All right, members, thank you very much. Panel, oh, I'm sorry, Delegate Valentine.
Thank you, Madam Chair, and thank you, panel. I just wanted to touch on the economic impact as well for the witness in the center, because I believe you recited a report. And I just want to be clear on this because I've heard contradictory terms on this when it comes to economic impact that might not be what your testimony was. And I just want to clarify. So the report you stated or cited would lead us to believe that the small amount of taxes paid by the individuals we're talking about that are here in the country illegally is a net positive when compared to the amount of services, benefits, education, healthcare that they're eligible to receive? You're saying that that is a net positive for our economy?
Yes, sir. So this is a report from the Cato Institute, which is a conservative-leaning think tank, libertarian, I think is how they describe themselves. They just released a report a couple weeks ago. It looked at 30 years of government data in terms of taxes paid and benefits received, and found that, and I can share the report with you.
I would love you to do that.
Yeah.
30 years, I was just thinking about in the last, say, 4 or 5 years would be what I would like to look at, not 30
Sure,
years.
and their report, it's, broken down into lots of detail, and it separates, they looked at immigrants as a whole, as well as the subset of undocumented immigrants. They've also looked at, the children of immigrants who might who are U.S. citizens who might be eligible for more things. In all of those cases, the taxes paid exceeded.
And is that nationwide report, or is that specific to Maryland?
It's nationwide.
It's nationwide, so it's not specific to Maryland. And you said it was a conservative think tank. I would also be curious as to who funded the report.
That I'm
Okay.
not aware of their fund. I'm not affiliated with them.
Okay.
So.
All right, thank you, Madam Chair.
Any other questions for this panel? Seeing none, thank you for being here. Thank you. Taj Smith?
Hello, I'm here.
Yeah, you found the button, right?
Yes.
Okay, you may proceed.
Okay, thank you. Good afternoon, Chair and members of the committee. My name is Taj Smith, President of the Washington County NAACP. We strongly urge a favorable report on the Community Trust Act. In Washington County, we are at a breaking point. The federal government's recent $102 million purchase of a warehouse for an ICE detention center, which our Attorney General is currently suing to block, has cast a shadow of fear over our entire community. Despite the state ending 287G agreements, our county commissioners recently passed a resolution of unwavering support for ICE. This has sent a clear message to our immigrant communities that they are not safe here. We are seeing results of this fear every day. Families are in hiding, children are missing school, people of faith are afraid to attend their own churches. This erosion of trust doesn't just hurt immigrant families, it makes our entire county less safe. When a significant portion of our population is too afraid to report crimes or engage with local agencies, the entire community suffers. The Community Trust Act draws a necessary line. It ensures that Maryland law enforcement is not an extension of the federal deportation machine. By requiring a judicial warrant and stopping proactive collaboration, this bill protects the presumption of innocence, and it prevents the racial profiling we see all too often. It doesn't stop federal law from being enforced. It simply ensures that Maryland resources are used for Maryland's safety. It is time to choose trust over fear. On behalf of the Washington County NAACP, we urge a favorable report on HB 1575. Thank you.
Thank you, Ms. Smith. Do we have the other virtual? We don't have any of them? Okay.
Madam Vice Chair, I believe Dr. Lee might be on.
What is that? Ah. Sarah, can you hear me?
Yes, hello.
You may proceed.
Thank you so much. My name is Sarah Stout, and I am the Director of Policy and Advocacy at the Prison Policy Initiative. We're a national nonprofit research and advocacy organization dedicated to exposing the harms of mass incarceration. We're very pleased today to be here to support H 1575 because it dovetails with some research that we've done recently on ICE and its collaboration with local law enforcement. In particular, the collaboration that happens in jails. President Trump's policy of cruel and lawless mass deportations needs collaboration from local and state law enforcement to proceed effectively, and banning 287G agreements is not enough. Most ICE arrests in jails and other lockups occurring in Maryland are occurring not through formal 287G agreements, but through informal collaboration by local and state law enforcement with ICE. There's a general belief that people who are arrested in jails and prisons by ICE are somehow dangerous criminals. This is not the case. Only about half of the people in Maryland who are arrested by ICE through informal collaboration have any criminal background at all. And overall, only 3% of people arrested by ICE in Maryland have violent criminal history. So fundamentally, what we're seeing is that people are being funneled from routine interactions with law enforcement, like traffic stops, into jails and then directly into ICE's deportation into ICE's deportation machine. The experience of other states has also shown us that although banning 287G agreements is a very important start, it's not the be-all and end-all to actually stopping ICE collaboration. In New Jersey, they took the step of banning 287G agreements, but unfortunately, a number of sheriffs continued to collaborate with ICE, and their arrests out of jail custody have remained high. In contrast, Illinois has actually stopped those collaborations and has much lower levels of ICE arrests. So we urge you to support the bill.
Thank you. Do we have Dr. Henry Lee? Virtual? No? And Eric Lopez? Excuse me? Okay, Dr. Henry Lee, you may proceed, sir.
Yes. Yes. Yes.
Dr. Lee, if you have on another audio system, you're going to have to turn it off.
Okay,
The web,
you have me? Okay.
Are you on?
My name is Henry Lee. I'm a 6th generation Asian American. My family has been in the United States. Okay. Is it okay now?
Yes, please proceed.
Very good. Okay, let me begin again. My name is Henry Lee. I'm a 6th generation Asian American. My family has been in the United States since 1870. I have held elective offices. I've held leadership positions in public and private entities in Montgomery County, in the state of Maryland, and nationally in my profession. During the past 156 years, only the first generation of my family and the last generation were deemed completely legal. So we've had 4 generations of illegal immigrants, including my generation. We've been singled out for harassment, declared not human by the California Supreme Court, deprived of our civil rights, property rights, and voting rights. SB 791, HB 1575 is important to prevent present and future generations of people like me to be singled out for certain immigration enforcements in disproportionate numbers. This bill will help ensure due process for immigrants, residents, citizens, and all who reside in the state of Maryland. This bill will ensure citizens and non-citizens alike will be treated with dignity and equality under the eyes of the law. This bill is not a bill to prevent legal enforcement of law and judicial actions. It's to ensure that the laws and regulations enshrined in our Constitution are applied to all residents of Maryland in a fair and equal manner. As part of an Asian American family who has been painted as illegal or not deserving of a place in America, I have seen what fear, paranoia has done to people like us. It deprives family and people like us of their lives, their liberty, and their right to pursue happiness. Passage of this bill will send a message to us and law enforcement employees and agents that their actions must be legal, they must be just, they must be fair, and they must respect human rights. Thank you for allowing me this time to testify on behalf of this bill.
Thank you, Mr. Lee. Now, last call for Eric Lopez. No? Any questions for this panel, colleagues? Seeing no questions, that concludes the favorable panel in this bill. I'm going to call the unfavorable panel next. Sheriff Charles Jenkins, if you could come forward. You may proceed, sir.
Good afternoon, Madam Chairwoman, committee members, Sheriff Charles Jenkins, Frederick County Sheriff. I don't have a lot to say today. I have little to say, especially after you basically dismantled the 287G programs across the state of Maryland. That in itself has irreparably harmed public safety in Maryland. Very successful program. Now you take it a step further. After the governor, the day he signs that bill, sends out a letter of what we can do to continue cooperation. Now what 1575 does is take that away from us. Again, another step in making Maryland less safe. I can't believe what I'm hearing. I've heard a lot of lies up here today, either mischaracterizations or absolute lies about what's going on. No one's being targeted in the state of Maryland, I can assure you that. What you are doing by doing this is basically you are elevating the status of criminal aliens in this country, in this state, above the citizens of Maryland and the public and the safety of the citizens of Maryland. I think that's horrendous. I think it's shameful what you're doing here in this legislature, in this General Assembly, and I hope you're happy with it. I really do, because what you're going to see is what you never wanted to see. The fact that ICE will be in here in numbers, in force. We've never wanted that. We've never had that. So again, I don't have a lot to say. I would just, again, strongly oppose this bill, as every Maryland sheriff does, although some are not, I guess, in a position to come in there and express that. So that's really all I have to say today.
Thank you, Sheriff.
Any questions?
Any questions? Delegate Valentine.
Thank you, Madam Chair, and thank you for coming down, Sheriff. Delegate Erican, who's not here, did kind of quote the governor in earlier. I don't know if you heard her. She was with the one panel. You mentioned a letter from the governor. Is there anything in this bill that you can think off the top of your head that is contradictory to what you received from the governor?
The way I interpret the bill, the way I read the bill, the intent of that bill is to basically contradict everything in this letter. We won't be able to pick up the phone and make a call to ICE. We won't be able to allow an ICE agent in our facility. We won't be able to hold someone for any period of time. And so listen, I've got 20 people in my jail with detainers serving sentences or waiting for trial. ranging in crimes from anywhere from first-degree murder, rape, sexual assault, domestic assault, strangulation, drug trafficking, armed robbery, assault on police officers. Now, what do I do with those people when their sentences are up? Let them walk out of the jail? Or how about if I put them in a car and bring them down into your jurisdictions and drop them off? How about that? The folks sitting behind me, I'm sure there's people that live in the immigrant communities behind me. How about if I brought them down to their communities and let them out, let them loose? Let ICE come into their neighborhoods and apprehend them. We've never wanted to see that. That's been the value of the 287G program. And again, what this bill would do would totally handcuff us from making any contact whatsoever with ICE.
Thank you, Sheriff.
Thank you, sir. Delegate Moreno.
Thank you, Madam Chair. Is it your position that no undocumented immigrants should live in Maryland?
No one ever said that, sir. In my entire 15, 17 years of coming before this committee, and most of you probably weren't even here over those years, I've never mentioned anything about illegal immigrants. It's criminals. I've always been focused on criminals.
Are you okay with undocumented immigrants living in Maryland if they have no criminal history?
Am I okay with it? Listen, the fact is we can't deport or remove whatever the numbers are. I have no way of knowing, nor do I care what the numbers are. I'm concerned about the safety of people in Frederick County and the state of Maryland, because what we do in Frederick County, which is the fastest growing county, impacts the state of Maryland.
If an undocumented immigrant that was a victim of a crime called you, would you help them?
Every day. I do that every day, sir. I have reached out. I assign U visas for victims of crimes and witnesses of crimes. I actually have a very good relationship with Hispano de Frederick organization. When there's an issue in their community, they reach out to me and I do whatever I can to basically help them with their situation or their problem. Yes.
Thank you.
Thank you, sir. That concludes, I'm sorry. Delegate Phillips.
Thank you, Sheriff. You mentioned that you have individuals in your jail today that you believe have a detainer, but they're going through the judicial process in Frederick County. Is that correct?
That is correct, sir.
All right. And should they be found guilty, they will serve their time appropriately. And
that
if
is correct.
If it's a felony,
yes.
They're going to go to a state prison. If something else, they're going to stay right there in Frederick County's prison, correct?
So depending on the sentence, so in a lot of cases of more serious crimes, of course, they'll do their time in DOC, but that detainer is still there for them when they're released.
Okay. And with that detainer, once they've been booked and once they've been determined to be convicted of a crime, is it not true that all of that information is clearly identified in NCIS and that all law enforcement agencies have access to that data?
That is correct. However, I will tell you, I've heard testimony up here about how quickly ICE has access to that. Generally, it's up to 16 hours before they have access or somebody reviews that. So whoever made the comment about it's immediate, it's not really immediate. So there's always that risk that that individual will be released prior to basically ICE coming to realize, we got somebody we want.
Yeah. But as soon as that person is arrested, that information is entered into NCIS, into the database. Is that correct?
It is correct, yes.
Okay. And for those who have international warrants, that information is in the international databases like Interpol. Is that correct?
That is correct. However, we do not have access to that outside of 287G.
Yeah, but ICE does have access to that. Is that correct, sir?
Yes.
Okay. So with $80 billion, you're saying that ICE cannot figure out how to identify those individuals who've been arrested in our judicial system?
I never made that comment. I don't know what ICE's funding levels are. I have no idea. I just know that they need the help and cooperation of local law enforcement to carry out their mission of removing criminals. That I know.
Okay, and what we're saying is we don't believe they need the help of the state of Maryland and Maryland law enforcement to do that. We believe that they have the resources. They put more resources in that than we have in the state of Maryland. So I appreciate it, Chair.
Right. Madam Chair, can I bring up one important point? Take me 10 seconds.
Is it the answer to his question?
Not particularly.
Go ahead, sir.
Okay, so I wanted to bring out, somebody brought up a question about knowing the importance of where they were born. Every individual has the right to contact their consulate if they are not born in the United States. That's one of the reasons that we ask that question coming into the jail. What country are you a citizen of? Because they have the absolute right to reach out to their consulate. So I just want to make that point.
Thank you. Thank you for making that point. Delegate McComas, we have one more question. I'm sorry, sir.
Yeah, we had 2 horrible murders in Harford County. And basically, there may have been some hiding out with relatives on one of them, and the only reason the guy was eventually caught was because there was some DNA in LA or wherever where there was an incident. And then the other person, he was allowed to go to school and everything else because they didn't get the DNA on the little girl, the autistic little girl, Kayla Hamilton. Obviously, with those 2 incidents, you know, Harford County's a little skittish about losing the 287G and everything. So let me ask you this. Could those have been prevented anyway? Because it's very concerning because it makes everybody a little nervous.
Delegate, it's really hard to sit here and talk about situations and what ifs and what could and could not be prevented, okay? I just know that the criminals that we have seen come through our detention center over the years, illegal immigrants from some of the most violent cultures and countries on the planet, some of the horrendous crimes, the rape of children, the rape and sexual assault, the murders, attempted murder. I don't want them in my community. So I can't sit here and say what if in any given situation. So I'm sorry.
Well, let me ask you this. Do you know much about the crimes that were committed, let's say, in El Salvador and some of those excuse me, those countries? And then because this one person that killed Kayla Hamilton, he had written to a minister, and it was caught by the detention center that he had killed 4 people in El Salvador before he had killed Kayla Hamilton. And I guess the concern that I have is that we're getting some bad hombres that are coming into the community, and this bill could really handcuff everybody. And I mean, there's the issue of gangs, and we've had a lot of, we've had some serious gang issues over the years that I've been around. And those guys are dangerous.
Delegate, you've heard me testify this year after year after year to the point of nauseam for you, I'm sure. But listen, I can tell you that the number of criminal gang members, including MS-13, 18th Street, that we have removed from this country through this program, which was great, okay? The violence that comes out of Central America. Like I said, some of the most violent countries and cultures on the face of this planet are in our country. I don't think we deserve to live with that risk, that threat.
Thank you, sir.
Thank you.
Thank you.
Delegate Mangio.
Thank you, Madam Chair. Just thank you, Sheriff. Real quick for me, as a public safety official and as public, as politicians, public elected officials, whatever we call ourselves, obviously our obligation is for community safety, I would say first and foremost. And whether ICE has an $80 billion budget, a $200 billion budget, it just seems to me that the most simple way would be to cooperate and work together. And that's where I'm lost in all this, is the lack or the willingness to just push cooperation aside. So can you just talk or maybe give a very, and without being repetitive, of course, but a brief example about how simply refusing to cooperate with our federal law enforcement, because what I believe in many cases is more political based on who the President of the United States is, could result in something that was very simple, but because you're not allowed to cooperate, leads to something possibly very tragic.
So probably the simplest example I can give you is the fact that we have an officer with the U.S. Marshals Task Force that works every single day to go out across the state as a TFO, Task Force officer, to work and cooperate and pick up these violent criminals, including those who come into Frederick County and hide there, because a lot of times they do. Every single agency, I mean, we have MOUs to work with U.S. Marshals, the FBI, the ATF. Every single day we are cooperating with law enforcement, the FBI, large-scale operations every single day. So for some reason, it's frowned upon when you say the word ICE. I don't know why, because again, it's about criminals. It's about public safety. It's not about targeting any immigrant community or any ethnicity. It really isn't. The young lady who mentioned up here a while ago that people are targeted, no, they're not. Absolutely are not. So I'm sorry, I got carried away there.
Yeah, thank you for your answer. It just seems to me in general that cooperation with law enforcement.
It pays dividends, yes.
Thank you.
Thank you, sir. Thank you for coming.
Thank you.
This concludes the hearing on HB 1575. We're going to call HB 495, Delegate Rosenberg next.
Can my panel come up with me?
Yes, sir. Please bring your panel.
Thank you, Madam Chair and members of the Vice Chair and members of the House Judiciary Committee. House Bill 495 would prohibit an arrest of an immigrant who is fulfilling a civic obligation by attending a proceeding, civil or criminal, in a courthouse. This has happened in Maryland. It is not speculative and is clearly discouraging people from doing what they are obligated to do as a resident of this country, to participate when asked. This isn't just being an innocent, so-called innocent bystander. This is if you've been called as a witness or if you are a member of a family where someone is part of such a proceeding. Similar bills have been enacted in Connecticut, Illinois, and New York. And this is, I mean, I would submit it as a protection that all of us should have and would not object to legislation, or excuse me, to an amendment widening the bill so that it would include any person who is attending a hearing in a courthouse should not have to be worried that their presence at a civil function will be the opportunity for them to be arrested. I would urge a favorable report from the committee and welcome any questions that you might have, and welcome my witness in support.
You may proceed.
Thank you. Thank you. Good afternoon, Madam Vice Chair, remaining members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. The Maryland Coalition Against Sexual Assault is the coalition of all of the rape crisis centers, but we're also home to SALLY, the Sexual Assault Legal Institute, which provides direct legal services to survivors all across the state. And when I saw this bill, I know you have a lot of bills in front of you on these issues, but I wanted to be here to just verify that survivors are afraid to go to court. Survivors are afraid to go to court. And when witnesses are afraid to go to court and they don't go, sex offenders go free. When victims of sexual assault, domestic violence, child abuse are afraid to go to court, they don't get protective orders and violence continues. And when we don't take steps to prevent fear and help people feel safe when they go to court to seek justice, abusers are not held accountable, and both individual victims and the larger community are endangered because we don't have the tools to keep our communities safe. So House Bill 495 it's a small step in your larger jigsaw puzzle of addressing these issues, but it will help ensure access to the courts and access to justice. So the Maryland Coalition Against Sexual Assault urges a favorable report on House Bill 495.
Yes, Delegate Carton.
Sure. Thank you very much, Delegate Rosenberg, for bringing the bill. So 2 questions. The first one is, if you had mentioned that should be true for anybody. So if there's, and this is not just for civil procedures in court, this would be for criminal procedures in court. So if there's somebody who has an arrest warrant outstanding and they, you know, for a serious crime, let's say a second-degree assault on domestic violence, and they come to court for a traffic matter, and the court knows that that there is an outstanding warrant for them, you're saying they shouldn't be able to be served that warrant right then and there?
I think that that's a heavy burden for the enforcement agency to meet. And this committee certainly has the experience and the wisdom to decide if there are such circumstances where your civic right and duty to present yourself before a hearing, public hearing in a courthouse, should be subservient to your record. And I appreciate that.
Yeah, I see it all the time, especially with incarcerated parties who come in, there's an outstanding warrant, they know, and they serve that defendant right there with another warrant. The other question is, I can't remember the bill number, but it's Delegate Ebersol's bill 1431 maybe, that I think we just voted on, that prohibits any kind of, is it without a warrant or at all? It prohibits courthouses. Have we passed?
It's related to courthouses and a warrant subpoena in court.
So would this accomplish the same thing as that bill? Does that bill accomplish the same thing as this bill, is the question?
I couldn't quite hear your summary of the
So the bill, I believe, adds courthouses to sensitive places where immigration and customs enforcement cannot execute or detain somebody without.
Well, this bill is a higher standard because you have to be there for a reason.
Right, there they just can't even
Right.
go into the courthouse at all.
Right.
So wouldn't that accomplish?
It would, if it's the committee's wisdom to do the broader protection, I certainly
Fair
would
enough.
not object.
Thank you.
Thank you.
Thank you. Delegate McComas.
Okay, I'm going to digress a little bit, but then I'm going to get to the question, Sandy. Okay.
I'm here.
You recall when we did away with the bail bonds industry, all right, and that everybody was to be recogged and everything. And so we don't have anybody that's going to, that's going to be bonded, that the bail bondsman's going to be the one to get the guy to go back to court when they need to go to court. So there's a lot of FTAs, failure to appear, that float around in the system. And then there's probably also dealing with Delegate Cardin's work. He does a lot of dealing with civil debt and stuff, and so they maybe won't show up for the exam, the oral exam, or any deposition, or any presentation of their finances, so they can work out a deal to take care of the debt. So the state police are not going to run after somebody that failure to appear on a DWI or anything. So the easiest thing that they're going to know that there's a DWI there when the guy goes to court is, oh, this guy is either a defendant, a plaintiff, or he's a witness. And so then they can pick him up and say, hey, dude, you're a failure to appear and you need to post something or something, because that's the administration of justice. So this is just one further step that we're going to have trouble getting things resolved within the court system. And I sort of think that we're overdoing things. And I know where Ms. Jordan's going as far as we got to figure out a better way to do this than what your bill's proposing, because we cannot have people go into court and that they're not accountable when there's outstanding warrants or failure to appear or oral exams that they're not showing up for. It's not fair for the plaintiffs and the law enforcement or the prosecutors. Isn't that so?
Well, I would say that is a part of this bill, but the risk to citizens or non-citizens goes significantly beyond that, and the bill could be refined in an appropriate way to deal with the problem that we're trying to address, which is people who have every right to be in that courthouse and may have been summoned to go to that courthouse, and that becoming a convenient way for them to be incarcerated. That, I think, we need to address.
Do you agree that the broader issue needs to be resolved before we take care of the issue of folks being able to testify against, somebody that
I would only object to
sexually
your use
abused
of the
or
word
whatever?
before.
Pardon?
I'd only object to your use of the word before, because that implies to me you'll take care of one issue and then we'll see you next year on the other issue.
No, I think we need to, but we need to deal with the issue because it's going to affect the court system. And they are a separate branch of government and co-equal with the legislature and the executive. So I think that's a problem. And this was a problem when we did away with the bail bondsman, because the state police are busy enough that they can't go and pick up people, or let's say the folks within Baltimore City, the sheriff's department, or the police department. So it's a problem. So, and I think maybe we need to talk to the judges and see how many FTAs they've got and how many, and the civil bar about how many oral exams aren't.
If this bill becomes the means by which you address all of those problems, or do your best to address all those problems, I'm for that. That's why council is here, yeah.
No, but I think maybe we need to have a conversation with the judiciary and the law enforcement.
Thank you.
Thank you.
So, I'm sorry, madam, but I know that's been a problem for.
All right.
It's a big issue.
Delegate Boucher.
Thank you, Madam Vice Chair. Thank you for bringing this bill. It's always good to have a controversial issue come forward. Do you believe that U.S. citizens should be granted the exact same immunity if they show up for court for proceedings, if they're a witness for something, if they have a detainer on them or an arrest warrant?
Well, I think that's what the discussion we just had was, if the committee can find a way to distinguish between individuals, citizens or non-citizens, who do not have the right to, because of a warrant, to free access, not just to the courthouse, but to the community. I think I'm okay with distinguishing between those people in that circumstance and people who do not have that warrant hanging around them.
All right, thank you. That concludes the hearing on HB 495. Delegate Rosenberg, you have HB 650, and you may call up your panel, unless you want my help.
Well, I have some other witnesses too, if they could
I didn't see
come
them.
up.
They're not on the witness list.
Oh, nobody is signed up? We have some people here.
Hold on, I'm sorry.
Oh, hi.
Thank you, all here. You guys.
Okay.
And I think you have some virtual witnesses today.
I'm sorry, we're set. Thank you.
Look, they're not on the witness list.
Okay.
Help a sister out.
This is the offspring of SLAP, now called UPEPA.
Excuse me, is this the new bill? The
Yes.
second bill. I got it now.
Yes. Sorry for any confusion.
That's fine. You may proceed.
Okay. This SLAP suits, or UPEPA, I favor SLAP, but SLAP suits are strategic lawsuits against public participation. They are lawsuits brought to intimidate someone or a group of individuals, a community association, that has spoken out in opposition to a matter of public record. That is, it could be a zoning issue or any neighborhood issue where the developer who has been slowed in his or her plans because of neighborhood concerns or objections files a lawsuit knowing that the lawsuit is not likely to prevail, but also knowing that the lawsuit is all but certain to intimidate the neighborhood and individuals in that neighborhood from continuing their participation in public processes before a zoning board, before local city council, whatever the case may be. I'm going to date myself. I first learned, and I've said this to the committee before, I first learned about SLAP suits on LA Law when it was in prime time. And I recognize that LA Law in reruns may be dating myself for this committee. But this is the committee where the first SLAP law was adopted, there was a small work group created, myself, the then lobbyist for the Bar Association, Buzz Winchester, and Judge Joe Murphy. And we worked on a SLAPP bill. It took the Senate a while to get the wisdom of this committee and our body, but it was eventually enacted by the Senate. We have tried over the years to improve our SLAPP law. One of the major flaws in our law is the requirement to demonstrate bad faith on the part of the party that has brought the suit, which the community is now claiming to be a SLAPP suit. And this committee had passed the bill out of your Civil Law Committee, subcommittee. You've passed that bill several times. The Senate has not. We are now before you with a bill that is the recommendation of some of you, one of your favorites from law school, as you may remember, the Uniform, I forget the full name since it's been so long.
Law Commission.
The Uniform Law Commission, thank you, which tries to adopt model laws that can be, so that the same law is adopted in as many of the states as possible, so that there's a more consistent application of the law of SLAPPs all across the country, and it doesn't matter what jurisdiction you're in, to facilitate the handling of those cases. So I urge a favorable report, and having heard the buzzer. Thank you.
Thank you. You'll have a chance to talk again. I'm sure there'll be
No
some
doubt.
questions. All right, where do you want to start? Want to start on this side?
However you want to do it.
I'll go in the Good afternoon, committee. My name is Rebecca Snyder. I'm the executive director of the Maryland, Delaware, DC Press Association, and we strongly support this legislation. This, as Delegate Rosenberg has noted, this committee has passed very similar legislation in the past. The UPEPA law, which I'll leave the attorneys to tell the details of, is in fact very similar to the anti-SLAPP legislation that we've brought previously. It's important to note that the ULC law, which is now passed in Pennsylvania and Delaware and I believe Virginia, would help us avoid that patchwork of statute that makes it, that allows people to jurisdiction shop. We do feel like, and you'll hear from others on the panel, that this is an important issue, not only to press. The current SLAPP statute lets through far more SLAPP suits than it holds back. So it's an important piece for press freedoms because you don't want the chilling effect of litigation and the costs of litigation to fall on news media. But you'll also hear from individuals, from those in the domestic violence community, and others where SLAPP suits really are very pervasive. In working in this issue, I realize it's much wider than simply the press. And so this is legislation that will help people speak out about issues that are important to them in their community. And we urge a favorable report. Thank you.
Thank you. Thank you, Madam Vice Chair, members of the committee. My name is Max Mishkin. I'm an attorney in the Media and Entertainment Law Group at Ballard Spahr, and I appreciate the opportunity to speak today in support of House Bill 650. I'd like to touch on just a few points from my written testimony about how the uniform bill in particular will vastly improve on what is currently Maryland's outdated and unfortunately ineffective anti-SLAPP law, and why it's an important step forward for our state. So first, the changes that House Bill 650 and the uniform bill would provide have a proven track record. You can look at that by looking at anti-SLAPP laws in place in other states across the country, in particular the ones that have implemented the uniform law, and you'll see state after state agreeing that when someone sues over speech on a matter of public concern, then the person suing should have to show early on that that case has merit. Likewise, you'll see that the consensus view that when a plaintiff brings a meritless SLAPP suit that a court has decided is meritless and then loses, the plaintiff should have to pay the defendant's attorney's fees. That both serves as a disincentive to bringing the meritless lawsuits in the first place, and makes defendants whole for having gone through the process of defending the meritless case. These are the kind of provisions that make an anti-SLAPP law effective and reliable. A stronger anti-SLAPP law helps organizations of all kinds and people of every political leaning. I've seen that firsthand as my colleagues and I at Ballard's Bar have filed anti-SLAPP motions for conservative anti-abortion filmmakers being sued by a Democratic state court judge, and for a national Democratic advocacy group in a lawsuit brought by a GOP megadonor. In the past few years, we've asserted anti-SLAPP law protections against an iconic Republican sheriff and against a rising star Democratic lieutenant governor. Anti-SLAPP laws are, no matter what anyone will tell you, they're not a partisan issue. The last thing I would say is that the time is now to put these protections in place, because every day, I can tell you this because it's what I work on every day, those who I refer to as libel bullies bring meritless lawsuits because they feel confident that even if they lose, they still win the battle overall by forcing defendants to spend time and money to defend themselves. I'd urge the committee to report this favorably. Thank you.
Thank you. My name is Ronald Jericho. I'm testifying on behalf of the Maryland Association for Justice. We have a position paper that I'll talk about in a little bit. I'm a former judge on the Circuit Court for Anne Arundel County and a practicing lawyer here in Annapolis. We support this bill because it is a change. It's long overdue. The study that was done, that I've got attached to the report, was done by the Institute for Free Speech and rates all the SLAPP laws throughout the country. Maryland's law rates a number 10 out of 100. We're one of 2 states that rate 10. We're one of 5 states that's under 50. 30-something states have a score between 87 and 100. So Maryland's law is woefully inadequate and needs to be reviewed. The uniform law done by the Uniform Law Commission has been adopted in at least 14 states in the past 5 years, and 7 adopted it in the past 2 years. So it is time to adopt this law and update Maryland's law. As has been mentioned, a SLAPP suit is a meritless lawsuit, and this provides for an expedited motion to dismiss so that it gets resolved quickly without cost to the parties, because normally the parties are individuals who are trying to participate in public matters or criticizing public officials. I was defended in a SLAPP suit about 2 or 3 years ago when I criticized an administrative law judge who was violating ethical rules in the District of Columbia. So I'm well familiar with it. Maryland's law is important because it changes this bad faith standard and creates it to be one of public expression. A couple of other things in there. It adopts the motion to dismiss expedited. It creates a good dismissal standard, and the recovery of attorney's fees was mentioned, but I need to point out is balanced. If somebody files a meritless, a frivolous motion to dismiss, then the plaintiff can get attorney's fees against the defendant. With that, we request a favorable report.
Thank you, sir.
Good afternoon, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We are here in strong support of House Bill 650, and we have long supported bills to improve Maryland's SLAPP statute for a lot of the reasons that have already been covered: expedited review, stay of discovery, ability to rule even if the responding party dismisses the case. All of these are very important procedural improvements, and we are hopeful that this bill it'll protect some disclosures of sexual assault and sexual harassment. It's not, however, clear that it's really going to cover all of those cases, because the speech that's protected has to be on a matter of public concern. And in about 21 states across America with SLAPP laws, it's unclear whether sexual assault is a matter of public concern. In 8 states, yes, probably. It is, after all, a matter of public health. In 6, definitely no. But more importantly, the proposed law requires that the litigant asking for dismissal prove that there's no genuine issue of material fact. And I do think that's unlikely in many sexual assault cases, because just the fact of whether or not there is an assault, whether or not it's consensual, whether or not sexual harassment is welcome, all of that will probably lead to a finding that there's a material issue of fact disputed. It's still a partial solution, though. Think about the case that I know you all have heard about, where we had a doctor. He was filing a defamation suit, one of many, many claims against someone that he had fondled during an exam. There was no dispute about when he filed his defamation claim. He was way past the statute of limitations. It's going to help in those sorts of situations. So this is a partial solution to the issues that I work on. It's still a partial solution. And so we still support this bill. It is still a step in the right direction. And MCASA generally really supports free speech. So we urge a favorable report.
All right, thank you. Colleagues, questions? Delegate Cardin.
Very much. Thank you for bringing the bill. I'm a co-sponsor. I'm happy to be helpful. I just, Mr. Jericho, it's always great to see you. Just confirming, does the prevailing party, if it's determined that the other party was being frivolous, does the prevailing party get attorney's fees or only the defendant?
No, it's what I'm saying, it's balanced.
It's balanced.
So for a meritless lawsuit, which is what's defined as a slap suit, and the defendant, who's an individual, goes to great expense to defend, and if you, the normal process is you go through weeks and months and years of litigating and you great expense. It provides for an expedited motion to dismiss. So if the meritless lawsuit gets dismissed, the defendant can get attorney's fees. If, on the other hand, the case is merit, as it was being testified to a minute ago, and you file a frivolous motion to dismiss, then the plaintiff who brought the meritorious case can get attorney's fees against the defendant who filed a frivolous lawsuit. So it's balanced. A frivolous motion to dismiss, I should say.
Yep, thank you. And I do think that this does, I would say it works for the similar legislation that you guys had the other day, Ms. Jordan, dealing with perpetrators filing lawsuits to stop victims. And I think this does actually work. I know that you don't think it's perfect, but I think this goes a long way. So thank you.
Another example that came up in the Senate testimony was a public group that was opposing a development of a landfill kind of thing, and they were sued by the developer to stop them from speaking out against the development. And that's the kind of thing where the motion to dismiss would be appropriate.
Thank you. Delegate Embry?
Thank you, Madam Chair. Following up on Delegate Cardin's question, this is for Ms. Jordan. Could you expand on your comparing sort of the two approaches, this and House Bill 465? Could you just describe in a little more detail how they differ, how they relate?
Yes, thank you, Delegate Embry. I appreciate that question. I think also to Delegate Cardin, I don't think that this bill would help in the cases involving kind of retaliatory litigation in sexual harassment, sexual assault cases without some amendments. And I look at other states where you have something similar. Virginia, for example, has something very similar. But in that state, you may remember that there was a very well-publicized defamation case between Johnny Depp and Amber Heard. And they said that the SLAPP statute did not protect in that case, did not protect her because she was countersuing, did not protect him because his statements were not considered a matter of public concern, right? And so again, what's protected under SLAPP is communication with legislative, executive, judicial, administrative, other governmental proceedings, right? So that is not necessarily going to cover Title IX proceedings, which are not governmental proceedings. It's not going to cover group therapy session. You could do it. I mean, I absolutely think that it is possible to modify either this bill or the bill on Stop Silencing Survivors to address those issues. But as it's written right now, I think it's too much of a Swiss cheese effect. You could consider, for example, in Virginia, they have a longer list of forums, right? So they include Title IX hearings, they include local hearings. And also just that issue of on a matter of public concern, you might want to look, does that include not only the issues that we've discussed previously on the Stop Silencing Survivors Act, but you could tailor this so a matter of public concern might include other matters of discrimination and give some sort of safe harbor for good faith statements.
Thank you. Delegate McComas.
Thank you, Madam Chair. Speaking of the issue of SLAPP suits when there is public comment, let's say about a comprehensive plan or a development, is there any way that that you can avoid some, because it seems like it's also should be a freedom of speech, you know, if the community says, hey, we don't want this, let's say, I'm trying to think, you know, a dump, okay, next to our place, or we don't want this 10-foot or 10-story big apartment building when we all have these little, you know, single-family homes, and it's just going to ruin the whole dynamics of the neighborhood. Is that going to help if we pass this bill? Because what, you know, the developers have a lot of money, and the residents don't, and it's an imbalance of power. And I guess I'm just wondering, is there a way that you could kind of, that it's not going to be so imbalanced, because they may not be able to afford an attorney. And we had some folks back in my jurisdiction, and they were dealing with a rather tough developer, and I think they ended up splitting the legal fees, because I don't think he helped pay their legal fees, or they just kind of each went their way. And it was unfortunate, because they really shouldn't have had to pay a dime, the folks that were concerned about the development.
The principal purpose of our SLAP law, and any SLAP law, I would assert, is public speech on matters of public concern, to borrow a phrase, for a redress of grievances with a governmental action. And that should be the focus of a SLAP bill. I thought I was very open to changes in broadening or narrowing my previous bill, but I don't think the SLAP law was intended for Johnny Depp. It was intended for private citizen Smith, or whatever the case may be, or McComas. And even for, I mean, this is public, for a SLAP suit in Fells Point, where one of the parties was the husband of the comptroller of the state of Maryland, in his private capacity. But the SLAP suit should be focused on lawsuits arising out of a public matter before a public body, which is the current definition.
What was interesting about that whole issue is it was also the timing of the comprehensive plan, so that those folks were afraid to even deal with the county comprehensive plan, because they'd already were fighting with this person. So it was ugly, and so I don't know who did what. I'd have to go back and ask them, but it's very frustrating to watch that happen.
I think I can speak to this specifically. So the classic example of a SLAP lawsuit is a bunch of community members get together and sign a petition saying, we don't want fracking in our community, we don't want a 10-story building in our single-family home community. And the developer then says, if you sign that, goes around and says, don't sign this petition. If you sign this petition, I'm going to sue you for defamation, or goes ahead and sues for defamation. What the SLAP law does is, because that is speech, either if it's a petition directed to the local zoning board, or it's speech on a matter of public concern, it should qualify for protection under the anti-SLAP law. And what the uniform law does is it gets rid of the current standard of bad faith. You would have to show that the developer acted in bad faith by bringing this lawsuit, which is an incredibly difficult standard to apply. Courts don't want to find it, and replaces that with a much more objective, is this case meritless? And so a petition signed by a bunch of community members saying, we don't want fracking in our community, we think it's unsafe, classic expression of opinion, it's a meritless lawsuit. It makes it much easier for those community members to defend themselves. And of course, like you said, the developer has reserve, the cash reserves that the community members don't. If they have to go out of pocket to defend themselves, they can get their fees back under the uniform bill much more easily than they could under what is the sort of current.
So is it fair to say that this is really going to give the neighborhoods and each community a little bit more power to deal with the Uber developers that are, going to want to rechange the world, so to speak, and up into communities?
Absolutely.
Okay. Oh, sounds good.
Thank you. Delegate Cardin.
Thank you, Madam Chair. Just a comment, notwithstanding what Delegate Rosenberg just said, maybe we should work on drafting those amendments just in case, Lisa, just in case we have this bill is our vehicle.
I think you could both be respectful of the sponsor on this bill and also amend another bill that might be before the committee and accomplish the same
Fair enough,
goals.
understood, but, always like to try and use our double protection aquafresh.
Any other questions for this panel? All right, we're going to move to the, thank you so much for being here. We're going to move to the virtual favorable panel. I'm looking for Beth Poggioli, Snea Ravi, Timothy Nelson, just those three. You got all three? Awesome. Great. So they heard me murder their names. Could you please say your name and you can begin? Beth.
Okay, Beth Poggioli. Hello, my name is Beth Poggioli. Thank you for the opportunity to testify in favor of House Bill 650. And thank you, Ms. McComas, for referring to my case. That was me back in 2016, together with Stephanie Flash. I recognized the need to inform our neighbors about the Harford County land use document. This document proposed expansion of the county's development envelope. After gathering signatures for a petition, Stephanie and I met with our district's local officials and submitted our printed petition. Just 1 week after that, a lawsuit in upwards of $75,000 was filed against both Stephanie and me by a developer whose property stood to be affected by the land use changes. The filing of this lawsuit left me feeling shocked, dismayed, and deeply confused. I could not understand how my First Amendment right to free speech could be threatened by another party. My family and friends became stressed and anxious in response to what we perceived as a bullying tactic. As a middle-class family with children in school, we did not have the financial resources to match those of a developer capable of hiring expensive legal representation. We incurred legal expenses totaling over $8,000 until the American Civil Liberties Union graciously agreed to take our case. Unfortunately, this experience had a chilling effect on our community, and many citizens were intimidated by the prospect of legal action and withdrew from public participation. This legislation would offer critical protection for citizens who speak out on matters of public concern. It would provide a mechanism to dismiss weak lawsuits at an early stage. I support legislation and would discourage the filing of meritless lawsuits designed to suppress free speech. Thank you so much for your time today.
Thank you. All right, are we ready for Ravi? Could you introduce yourself and you may begin.
Sure. Thank you, Madam Vice Chair. My name is Sneha, and my family has proudly been in Maryland since the 90s. I strongly implore the passage of this bill, which feels like a godsend. I am a concerned citizen and former pediatric dental patient, now in my mid-20s, currently being intimidated into suppressing lawful speech about documented harm I experienced as a child patient. My background includes business and healthcare ethics at Wharton, which is part of why I refused an NDA for money 3 years ago on principle, and why I felt compelled to share my experience to the community. Everything I have shared is firsthand, truthful, and documented over years, including the practice's own written admissions. More details on that are in my written testimony. But just last week, I received a cease and desist threatening litigation in response to recent public advocacy. In 2025, I filed formal complaints active with the AG, HHS, and board. I reached out to local dental associations and also very carefully shared my experience online. Not for nothing, by the way, as a few in Maryland have reached out with similar experiences at other practices. Through this process, I also discovered that this practice has been misrepresenting certain affiliations. Their threat non-coincidentally arrived after all of this. I believe it is a bipartisan value to protect truthful free speech. The proposed fee shifting and expedited motion deter baseless suits, and Maryland has an opportunity to catch up to states with stronger protections. The threat of litigation when baseless is really a threat of cost. I'm not afraid of a ruling. I'm confident in truth. But there is fear of draining savings on counsel as an early career individual if they do file just to defend my truth and patient safety. I'm open to any questions. Given ongoing legal risk, I prefer to answer in writing, and I'm very thankful for this time.
Thank you. And did Ms. Timothy Nelson? Is he in the room? Mr. Nelson, Timothy Nelson? Okay, oh, he couldn't stay. Okay. Thank you very much. Okay, can you see if that is Mr. Nelson? Maybe using someone else's?
Hello.
Hi, I was just waiting on, is Timothy Nelson going to testify?
I don't know who that is. I'm Tina Nelson. I'm here to testify on behalf of HB 738.
Oh, okay, thank you, Ms. Nelson. We're not there at the moment.
Thank you.
Okay, thank you. All righty. Members, do we have any questions? Okay, seeing none. That concludes this panel. Did we call? Yeah. Thank you very much for being here and being online for us. Okay, and I have the next panel, Laura Bodley, unfavorable, online. Yes? Okay. Well. Oh, good. So, do we have Ms. Bogley? Okay. Okay, perfect. Ms. Bogley? Ms. Bogley, can you hear me? Okay, great. So you are signed up as unfavorable. You'll have 2 minutes, please.
Good afternoon, Madam Vice Chair and members of the committee. I'm Laura Bogley, Executive Director of Maryland Right to Life. And once again, we respectfully urge you to preserve free speech and the integrity of this assembly by rejecting this bill and its expansion of frivolous lawsuits. Despite the change in name, this bill carves out a similar loophole to allow content discrimination that you have seen fit to reject year over year. We have more reason than most to oppose SLAPPs. The original statute already provides equal protection to all defendants against frivolous lawsuits and invokes the guarantee of free speech for all under the First Amendment. But this bill undermines the legislative intent of this assembly by depriving defendants this affirmative defense when the government itself is the plaintiff. We believe that courts, not politicians, should interpret whether speech or action constitutes a threat to public health or safety. The Constitution and federal judicial precedent are clear that pro-life speech is protected speech. Still in Maryland, pro-life speech is routinely suppressed and pro-life citizens are threatened, including by the state. Already, the General Assembly denies us the right to have pro-life legislation brought to a vote. Elderly prayer volunteers have been threatened with prosecution after being viciously attacked themselves, and taxpayers were forced to pay $500,000 to abortion clinics for security upgrades, despite the fact that since 2022, 70% of the cases of violence investigated by the FBI have been incidents of pro-abortion violence against pro-life citizens and centers. The ULC has stated that they did not intend for speech itself to be considered a threat to public health or safety unless it constitutes incitement. Please allow the courts to do their job. We respectfully urge your unfavorable report on this SLAPP expansion bill. Thank you.
Thank you. Members, do we have any questions? Seeing none, thank you, Ms. Bogley, for testifying. Have a good evening. Okay, we're going to move to our next bill, And this will be Delegate Hornberger. Sorry. One moment. Oh, there was a deal made that I didn't know about. Okay, Delegate Schmidt. I hope you have as good of jokes as Delegate Hornberger had this morning.
It's gonna be tough.
So this is House Bill 863.
Yes, Madam Chair. May I bring up my panel?
Yes, please.
Thank you, Madam Chair.
So I have, so I have Kathy Wright, John Jocelyn. And
Thank you,
Very
Madam Chair. I think the joke is me being back in this chair fairly often this session. Maybe that's the joke. I'm not sure if it's on me or on you or the committee, but that's where we're at with this. Thank you. Good afternoon, Chair Bartlett, Vice Chair Davis, esteemed colleagues of the hardest working Judiciary Committee. I am Delegate Stuart Schmidt, representing District 33B. We've heard this bill for many, 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 many years. I am now the new infamous carrier of this bill. You can look back at it, it's an esteemed history. The purpose of House Bill 863 is to classify the theft of a firearm as a felony. It established penalties. You can read them in the bill there. Like I said, this bill has been introduced for many years, earned bipartisan support, and it has a long time coming. Let this year be the final vote to move it forward. Maryland would not be alone in adopting this policy. Such states as California, Idaho, Arizona, Ohio, and Washington already classify gun theft as a felony. Since 1998, Maryland has passed 28 gun control bills restricting who can purchase and use a firearm. These laws were intended to make our state safer from firearm violence, yet firearm violence still persists. 2024, there were 671 firearm fatalities in Maryland, 780 non-fatal shooting incidents. Over the past decade, there are troubling numbers. From 2017 to 21, more than 1,074 guns were reported stolen nationwide, 76% increase in guns stolen from parking lots, cars, and garages. This bill addresses a clear gap. By elevating firearm theft to a felony offense, we create a meaningful deterrent to those who would steal guns and put them into illegal circulation. Reducing the supply of stolen firearms is a practical step forward in reducing crime and violence. It is also important to recognize that 44% of the 671 firearm fatalities in 2024 were suicides, a major, major concern. In Maryland, half of all suicides involved a firearm. By strengthening penalties for firearm theft, we add another layer of protection that may prevent someone in crisis from accessing a stolen gun in a moment of desperation. Even one life makes this bill's effort worthwhile. Finally, this policy has strong public support. In 2024, 89% of Marylanders supported making possession of a stolen firearm a felony. Our constituents want safer communities, and they believe this bill is part of that solution. There is a proposed amendment that the State's Attorneys Association has listed here. It's in your committee testimony. You can take a look at that. And for these reasons, I respectfully urge a favorable report on House Bill 863. Thank you.
Thank you. Ms. Wright, would you like to be next?
Yes, thank you, Madam Chair, and thank you, committee members, for considering my testimony. I'm Kathy Wright. I live in North Beach, Anne Arundel County. I am here as myself, for myself. However, full disclosure, I am a member of the Board of Directors for the National Rifle Association. As the delegate just explained, the gun thefts are a serious threat to our safety. If we are serious about reducing violent crime, then our state should treat gun thefts as a serious crime, not a slap on the wrist. Theft of firearms is considered a felony in many states, as the delegate just pointed out. In Maryland, conviction of a theft of a vehicle of any value is a felony. Why is conviction of a vehicle theft considered a felony, but not a conviction of a firearm theft? I provided copies, information about that code in your packet. Thieves and criminals know that if they steal a rifle or a shotgun or a handgun, they are not held accountable because the value of such a firearm is most likely valued less than $1,500. and theft is not punishable by imprisonment. The monetary value of a firearm is irrelevant when it is in the hands of someone with evil intent. We need to be committed to ensuring that our state's laws are tools to deter and to hold and to make criminals accountable for their actions. I respectfully request a favorable report on HB 863. Thank you.
Mr. Jocelyn?
Thank you, Madam Chair. John Jocelyn, speaking for 2A Maryland in support of House Bill 863. As my colleagues noted, the theft of a firearm is a very serious item. Any firearm that is stolen is now never going to be used for legitimate purposes and is now in the hands of a criminal. This presents a real and present danger to society. We believe it's time to recognize the threat that exists and treat it for the threat that it is by elevating this crime to a felony. We strongly support elevating the theft of a firearm to a felony, and we ask for your favorable report.
Thank you very much. Members, do we have any questions? Delegate Valentine.
Thank you, Madam Chair, and thank you, Delegate, and thank you, panel, for being here today. I do note the favorable with amendments of the State's Attorneys Association. I do want to read that on myself. I noticed there's no unfavorable in this entire section of the database, so that's great. My question is, we have different advocacy, and this is to the delegate. We have advocacy groups that come in before this committee on a daily basis for different firearms legislation to promote public safety, and I don't see any of them listed here. Did your office or did those groups reach out to you to advocate for this as a way to prevent gun violence or in any capacity during this process?
Yeah, thank you, Delegate. I appreciate the question. I have talked to advocacy groups multiple years, multiple times, including this session, and asked for their support. I know that they do come before the committee fairly regularly and make a stance. They have taken no position that I'm aware of, but I have asked them numerous times to support this bill and to stand up behind me when I testify.
To promote gun safety?
Correct. Okay. Correct, yep. Multiple organizations, I've reached out to the lobbyists of the organizations to get their help as well.
And they have not done so?
Correct.
Thank you.
Thank you. Delegate Simmons.
Thank you, Madam Chair, and thank the panel for coming. I was just interested to get some feedback from the NRA as well as 2A. When it comes to, excuse me, gun safety, what's some of the steps that you feel that we can take when it comes to literature that can be put out, or how do you connect with purchasers of guns to make sure we're educating them on that safety?
Maryland already requires training in order to purchase a handgun. It's the handgun qualification license training. For carry permits, we have a 2-day course that gives appropriate information in that regard. I personally am a firearms instructor. I hold a Maryland State Police qualified handgun instructor license. We are constantly reaching out to our members. Whenever we have a meeting, we discuss safety because safety is paramount. I have a rather bad reputation with my own club for being the RSO with no questions asked. You either do it right or you do it wrong, you're going home. Because I am responsible as the range safety officer when we do an event that everybody follows the proper protocols. And we constantly dote on safety because safety is paramount. Any accident individually is a tragedy. As far as the overall perception of the shooting sports, it damages the shooting sports as well. So we have a vested interest in advocating for firearm safety.
Delegate, thank you for the question. The mission of the National Rifle Association is firearm safety and marksmanship, and it has been since it began in 1871. We have hundreds of thousands of trainers such as John across the country that provide training and safety measures, and we will continue that effort to the very end.
Yeah, can y'all, I think what I'm trying to see, so besides the training, which I really appreciate, and that's critical to safety, is that training. Is there anything that y'all give them to take away, anything that they can study or review when it comes to those skills of it?
The gun stores.
There is a lot of material that is provided through the NRA, through the trainers, yes. It's available. Many of the gun stores in Maryland and across the country have information about the NRA in their stores, and the access to that information is available to the purchasers.
Sure, so what does the material reflect? If you don't mind me asking.
Safety and marksmanship.
Okay, thank you. Thank you. Appreciate it. That's.
Yeah, if I may, Delegate.
Yes, sir.
We do reach out to the general public. In the last 2 years, I've reached out every year to the Maryland General Assembly offering to teach the NRA's Refuse to be a Victim course for free. And I've done this every year, and so far I've not had a single response. So we can reach out, but unless the public reaches back, handing out literature doesn't really accomplish the task. We have to have that interaction.
Outstanding. Thank you.
Thank you. Members of, Delegate Mangione?
Thank you, Madam Chair, and thank you, Delegate, for the bill and the experts for being here. I would say, and maybe, Mr. Jocelyn, you can talk about this, many of our existing gun laws actually criminalize kind of products, so to speak, whether it's a magazine that has too many bullets or a certain type of weapon. But this bill attempts to actually criminalize a criminal act like theft. To me, that sends more of a message that we're serious about going after people that are committing or may potentially commit gun crimes. Can you talk about how this bill may be more effective than something like criminalizing simply the actual product itself?
This bill dovetails quite well with our ongoing policy that we oppose criminalizing objects. We support criminalizing and punishing the behavior. And in that respect, this is punishing the behavior. No inanimate object does anything on its own. And historically, our focus has been on establishing rules that the criminal should not violate and punishing them for doing it, because violence is behavior, not technology.
Yeah, thank you.
Delegate Mangione, okay. But with that said, if I stole a knife that was valued at, I don't know, $15, what would my punishment be?
I would have to look at that section, Delegate.
Okay, but the point is that
it is minimal.
You're right. The punishment is minimal because it's based on the object and it's based on the value of the object, right?
Under current statute, that is correct.
Okay, just wanted to make sure we clarified that. Delegate McComas?
Yes, I kind of want to read what the state's attorneys say, because I think, and get your response. Theft of a firearm presents a unique harm. In addition to the ordinary harm inflicted on victims in every theft case, stolen firearms can quickly be diverted into criminal markets, used in violent crimes, or otherwise contribute to the growing threat of gun violence in our communities. By making theft of a firearm a felony offense punishable by a maximum sentence of 5 years, HB 863 sets out to address this harm by deterring the conduct and punishing those who would choose to engage it. Just, would you like to react to that from the State's Attorneys Association? Your thoughts on that, as opposed to just that it's just an object and it's only worth $15?
I think they're spot on, personally. And to answer the previous question, for property value of at least $100 but less than $1,500, it's a misdemeanor for first offense not exceeding 6 months, or a fine not exceeding $500.
Thank you, Mr. Jocelyn. Any other questions, members? Seeing none, that concludes this panel. We still have a panel that is online. Mr. Mark Pinnock and Galen Muhammad. And in that moment, I think I see Delegate Kim Taylor's light.
See my light.
Concludes this panel. We still have panel that is online. Mr. Pinnock, we just need you to close the video. Muhammad. And in that moment, I think I see Delegate Kim Taylor's. Oh, she's gone.
Come back. Tell her come back.
They all left. They didn't care this year.
Did you get him? Can you get him? Okay. Okay. Delegate, Mr. Panak, can you hear me okay?
Yes, I can. Thank you.
Okay, you may begin. Thank you.
Thank you, Madam Chair. Mark Panak, President of Maryland Show Issue. I stand in staunch support of this legislation, and I echo the remarks that you've already heard. I do want to bring attention to the committee's attention to what the punishments are for this crime of stealing a handgun or a firearm worth more than $100, which is almost all firearms are worth more than $100. And that's probation. It is the least punished crime under the Maryland guidelines. First offense, probation. Recommended second offense, probation. Probation for this up to the 6th and 7th offense. Every firearm stolen is a crime gun. It will be quickly diverted into the black market, just as the state's attorney has articulated. There has to be a deterrent to this. Right now, Maryland has, through legislation enacted 2 years ago, created a whole host of gun-free zones which permit holders may not carry their firearms. So where do they leave them? They leave them in their cars. That leaves a perfect opportunity for them to be stolen. Now, they don't have any choice about that. It's either disarm themselves completely or leave them in a vehicle where they may be stolen. The incentive for theft is immense because there is no punishment. The firearms can be quickly converted into profit and turned over multiple times and result in crime. They quickly become untraceable because of the multiple turnovers. So this is just so clear. And I like to compare it to the crimes that this state visits upon the law-abiding. A failure to register a firearm, a handgun, within within 90 days is punished by 5 years in prison. That's a law-abiding owner who moves into the state, and yet no punishment for the theft. Please enact this legislation.
Thank you, Mr. Panak. And I must say, in the 7.5 years I have been in office and been in this committee, this is the very first time that you have not been here in person. But I appreciate all your diligence and your years of testimony. I just wanted to make sure I acknowledge that. So thank you for always being here, waiting with us all day long, and testifying on all of these bills.
Well, thank you, Madam Chair. I would have been there in person, except unfortunately last week on the ice, I took a very bad fall, and I'm kind of mobility limited at the moment.
I'm sorry to hear that. You take care of yourself and do what the doctor says.
I have no choice.
Okay, great. Members, do we have any questions? All right, seeing none. Thank you, Mr. Panak. You take care.
Thank you, ma'am.
All righty, bye-bye. Okay, Delegate Hornberger, is this a good time?
It is. Thank you so much, Madam Chair.
You're welcome.
Madam Vice Chair, members of the committee, Delegate Hornberger here on behalf of HB 820, handgun permits, special endorsement for security clearance holders. This bill was actually brought to my attention and requested by a constituent. As you know, we are in close proximity to Aberdeen Proving Ground. We have a number of current and prior law enforcement and federal employees who reside in our districts and throughout the state. And a small select few of them possess a high-level clearance, which we've denoted here in the bill as TS-SCI, top secret. And what this bill would allow is for those individuals who are currently in possession of that security clearance or who have previously held that clearance for 10 years and are retired would be able to have enhanced ability to wear, carry, and transport a handgun in basically the same posture that law enforcement would. So the question is, why do we need this bill? Why should this bill help? It's over the last few years, this body has taken great strides to restrict where one can wear and carry. And, although I might not have agreed with that, there are instances where a person who is trained and competent and is wearing and carrying can be a positive attribute for fighting crime and keeping people safe. And these folks, again, are at the highest echelon of clearance, and it's believed that they would be perfectly competent and able to wear and carry in the same area that law enforcement would. They would not take away or supplant, but they would be there as a backup. So with that, we would ask for a favorable report, and I would also draw your attention to the fact that there's just a one-time fee associated with this for computer programming purposes. Other than that, there is no fiscal note. So, thank you.
Thank you. Members, do we have any questions? And also, just want to make sure, Mr. Jocelyn?
Yeah, we do have some favorable.
Yes, you're listed as favorable, and Mr. Kasuba, you're also listed as favorable.
Yep.
I'm sorry I didn't call you up. Okay, Mr. Jocelyn, if you could give your testimony.
Thank you, Madam Chair. John Jocelyn speaking for 2A Maryland in support of House Bill 820. Given the overall performance of carry permits in Maryland, the holders, they have an exemplary record. They do not constitute a threat to society. The gentlemen who are listed, or the persons listed in this bill as the special security clearance, they do have a real threat because of the knowledge they carry. And we believe that it's in the public's best interest and their best interest to give a favorable report on this bill.
Hi, my name is Thomas Kashuba, Ellicott City, Maryland, registered Democrat. I fully support this bill. It's a long time coming. This bill recognizes the extraordinary level of trust and integrity and accountability that such people holding the TSSI clearances have. They undergo the most rigorous background investigations conducted by the federal government and remain subject to continuous evaluation. And during my research for this bill, I went ahead and created a little chart, which I've supplied in my written testimony, and it is, to me, quite shocking at how the great distance between law enforcement vetting versus a TSSI clearance holder vetting is. And you can see that the vetting is extremely leans toward the TSSI clearance holder. The most important thing of this bill is it imposes no cost to the taxpayer. It uses the current existing structure of permits. And as the delegate has said, it supplies yet another level of safety to the community at no cost. Keep emphasizing no cost. Any concerns of the misuse are unfounded because the TSSI holders have demonstrated long-term reliability, respect for rules, and adherence to strict legal and ethical standards. And if anybody says, well, training. I have firsthand experience with the Meade Rifle and Pistol Club. And since we're associated with Fort Meade, we have Cybercom and the National Security Agency members. And their training goes above and beyond that required for their job duties. Twice a month is offered handgun training. It is optional, but it is well attended. And also many of the members supplement that training with yet even more private training. And with that, thank you.
Thank you. I appreciate your testimony. I have a quick question. Delegate Cardin and I might have the same question again, but I'll let you go first. Go ahead. Sure? Yeah, sure. Go ahead.
I don't want to steal your thunder. So the people who were seeking to benefit from this, they have special knowledge that they've gained over the years, and they've got special certifications over the years. Would that be fair to say, Delegate Hornberger?
Yeah, that's accurate.
Yeah. And thank you for bringing the bill. In fact, you would say that once they have this knowledge, they don't lose it. They keep it. They retain it. Would that be fair to say?
Yeah, so you can continue to carry your license or your clearance after you retire. I currently have a clearance, even though I'm no longer working for the federal government. And depending on the level of clearance dictates how many years you can carry after.
So it would be fair to say then that these people can't lose their stripes?
No, because you don't keep it indefinitely.
Just like a zebra, they don't lose their stripes. Is that correct?
I walked right into that. Yeah, I walked right into that.
In fact, if we have all these specialized people with all this knowledge that they've had, you would say that every stripe counts.
I would. Yep.
Okay, I just want to make sure of that.
Yeah, I think
Okay, that's not what my question was at all.
he really ran away with that one.
Yeah, well, you know, remember what the speaker said when she had that bill about the bears?
Oh, yeah,
So,
sure.
My question was, I wanted to know if there's any type of mental health check with respect to the TSSCI clearance. Because in Maryland, we do have that requirement for our law officers, so I just wanted to see if that existed.
Oh, yes, there is. Upon a full scope polygraph is before you're hired. And that includes mental health, that includes a session with a psychologist. I personally know some of the psychologists that perform those duties. It also includes a polygraph. If anybody's ever undergone a polygraph, it's an interesting experience. And you are subjected to yet another reoccurring polygraphs every 5 years. There's also the wrap back program, I believe it's called, where if you are a security clearance holder and you have any encounters with law enforcement, that is reported, your clearance issuer it is told to them quite rapidly, and they will investigate that. You know, you could have your clearance pulled, you could have it suspended. Yes.
Yeah, one thing that I wanted to add, because I bring these bills to committee in good faith, and I had, you know, a number of questions from my constituent that brought this forward about, you know, how is the federal government communicating with the state government, right? Are they every day saying, yeah, still have it, yeah, still have it, yeah, still compliant? And the feedback that was given to me is that Maryland State Police, who is the issuer of this concealed carry permit, is in constant communication with federal law enforcement. So if there was a situation, let's say that someone had this clearance and got caught for a DWI, for example, we'll just use that as a scenario. There would be immediate revocation, and they would be placed on suspension pending further review. Of course, everyone's entitled to due process, and the MSP would be notified. So there is a feedback mechanism between the Fed and state government that would ensure that someone couldn't continue to carry this should their security clearance lapse.
Thank you. I'm going to go to Delegate Boucher because he was first, and then I'll hop back around.
Thank you, Madam Chair, and thank you, Delegate, for bringing this bill forward. I'm curious as to whether this bill will exempt them from permit renewal after retirement, or will they be subjected to the same as all other retired law enforcement officials?
Yeah, the way that we request the bill, and I believe is reflected in the fiscal note, is that they would still have to have the same application process in the beginning. They would have to have the same renewals. It would just enhance their ability of where to carry.
Thank you very much.
Delegate McComas.
Okay. I'll make it quick. My question is, basically, depending on where you worked and everything, there may be an issue of somebody might try to harm you or try to get information from you. Is that fair to say? I mean, that's a concern, and so you probably have some secrets that you don't want to get out that people might be interested in, I guess.
Yeah, and what I'll say, and I can't speak for all federal employment, but even for law enforcement, there's certain places, be it a SCIF, be it highly secured areas where a firearm would have to be checked, right? But when you leave that whether it's Aberdeen Proving Ground, regardless of where you are, once you leave that, you still possess that clearance. You still possess access to those secrets. You're still a target by foreign threats. That never stops, even though you might have clocked out for the day. So that's why we feel that to cut down on the confusion of where they could carry, and then also have the added enhancement for law enforcement, parallels, that this bill makes sense.
Delegate Simmons.
Thank you, Madam Chair, and thank you, Delegate, for bringing the bill. So when you talk about the federal government, federal employees with clearances, there are certain restrictions to facilities when it comes to weapons and accessing those facilities with weapons.
That's accurate.
And some of that is a criminal offense. if you enter, whether you have a clearance or not. So can you tell me how this works out with someone with that clearance? Because it doesn't necessarily mean that the individual with the clearance is an actual law enforcement or LEO. They could just be someone working for the government with a clearance. And that by them having that weapon, they would put them in violation of federal law. So can you talk about that?
Yeah, so I can offer some anecdotes, and then my panel can back me up here. So I worked on the Hill for many years, worked in buildings that were accessible by the public, albeit federal. Law enforcement would have to come there all the time. You're checking your weapon at the door. You're calling ahead and saying, hey, I'm carrying. What are your procedures? Am I allowed to carry within? You're checking in at the front door before you go to magnetometer, before you go through your entrance. You're checking that weapon so that you're not bringing it into a restricted area. And I would imagine the same would be for other places of federal employment, but if you wanted to elaborate on that.
Okay, this was brought up at our monthly meeting at the Meade Rifle and Pistol Club. Federal property, this is a state law, right? So everybody realizes that federal property, you're still going to be prohibited, right? This is just state only.
Is that fine, Delegate Simmons?
Yeah, so if you're prohibited federally, you would continue to be so.
So, I just have to ask this because I'm curious. I have to ask two questions. Are there other states that have something similar to this particular bill?
Yeah, I would say that Maryland, maybe with 3 or 4 other states, has these restricted zones that they've expanded to include things like parks, restaurants, and the like. And in those particular states, again, probably less than 5, they do not allow for this. I would say that in most other states, it's not an issue because you are allowed to carry, if you have a permit and you're in compliance, in most everyday areas that people would interact. I don't know if you guys want to add to that.
Well, not directly relevant. Maryland law, as the delegate mentioned, prohibits in parks. But I can tell you, if you go out to New Germany State Park on the Saturday after Thanksgiving and you don't have a rifle with you in the cabin, people are going to look at you like you're some kind of a tourist. Because the park people realize there's so much revenue generated that they simply say, keep it in the case, don't do anything stupid, and we go on and everybody's happy. But it is nonetheless illegal.
Okay. And what allows the state to supersede the federal ability with respect to wear carry?
Well,
because this is federal, isn't the SCI license?
No, the way that the bill is written is saying that if you possess said clearance, then that will enable you to carry in additional areas in Maryland in the same posture that law enforcement would be able to carry it. So when we created all these restricted zones in Maryland, we exempted law enforcement.
Okay, so just 1 second.
Yep.
Okay, thank you. I just needed to make sure I understood. Sure. Okay, thank you very much. Any other questions? Delegate Simmons?
Thank you once again, Madam Chair. So obviously Maryland, we have a lot of military or government installations throughout. I happen to have worked at Andrews and Bowling Air Force Base as a federal police officer. And during that time, we have police officers, different people with concealed carry that would come onto the base. Yep. And then they would get searched, random searches, and as a result, they would get arrested. Yep. Even with that concealed carry license, that because they was in violation of federal law. That's and, things like that. So that's my concern. I'm trying to see what kind of rope are we walking here when it comes to these type of mishaps, because that's what they really were, right? Someone forget they have their weapon in their vehicle, or they're a soldier and they want to come on the base to go to the commissary, but they carry a weapon off base and now they're in jail. So how do we protect against that?
I think I can address it with a parallel. I'm not totally familiar with how the federal government operates. I can tell you that in my volunteer fire company, we do have a battery of lock boxes So the persons who have carry permits, once they enter the building, the first thing they do is they go to the lockbox, they lock up their firearm, they take the key that is specific to that box, and they keep it with them. And they don't go further past that point. So I would presume at some sort of a sally port, there would be an equivalent piece of equipment that as the employees come in, they would then check their firearm in the secure box and then proceed to do their business in accordance with the federal regs.
I can tell you that's not the case. I can tell you that anybody that come on any federal installation, that if they're identified of carrying a weapon and that is illegal, they are immediately arrested and they work out the rest later. So that is not the case. They don't house your weapon under no circumstances because you shouldn't be there with it.
So passage of this bill would not change that process.
Okay.
I guess is the best way to answer the question.
I appreciate it. Thank you.
And having worked on the Hill, it was an everyday occurrence that someone from Texas or Kansas or one of these more liberal carry states would show up with a firearm. I didn't know. You can't claim ignorance on the law.
Right.
Slapping the bracelets on you or confiscating the weapon.
That's correct.
Okay, thank you.
Yep.
Very interesting.
Thank you, Madam Chair.
Well, that concludes our testimony. If members have no further questions, thank you very much, Delegate. And thank you, witnesses. That concludes the bill hearing for House Bill 820. We have some very special guests in our audience today. As you might not have noticed, I don't know how you couldn't, but today is AKA Day in Annapolis. And Delegate Kim Taylor and I are members of Alpha Kappa Alpha Sorority Incorporated. And Delegate Taylor?
Thank you, Madam Chair. We actually have two special VIPs in the sorority. They're sitting over here, and both hail from this great state of Maryland. Dr. Mona Calhoun, first of all, who serves as our North Atlantic Region Liaison to the International Strategic Partners Committee. She's also the president. Get this, you guys, the president of the National Association of Parliamentarians. And when she wears her professor hat, even though she hails from Morgan State University for a PhD, she's the chairperson for the Health Information Management Program at Coppin State University. So please help me welcome my sorority sister, Dr. Mona Calhoun. Now, I'm even more honored to introduce to you our North Atlantic Region. She is our North Atlantic Regional Director-elect. So we just came off the heels of our North Atlantic Region in Boston, where she was elected. And I wasn't there, but I know it was unanimously. If I had been there, my hand would have been up there for you also. But Dr. Tanya Ringgold, if you would stand, please. Dr. Ringgold is a proud Marylander and has 30 years in higher education. She served, and she's no stranger to Annapolis, she served as Assistant Secretary for Higher Education at the Maryland Higher Education Commission. So MHEP, she's one of us.
She's one of us.
She has been and may still be the president of the Morgan State University Alumni Association. And among all her other achievements, she has 5 academic degrees, including a doctorate in education. And Dr. Ringo has achieved the Daily Records Circle of Excellence, which means you had to win the Daily Records 100 Women multiple times in order to get into the Circle of Excellence. So please, colleagues, help me welcome our North Atlantic Regional Director-elect, Dr. Tanya Ringgold. And other sorors as well. Sorority sisters, thank you.
Yes, please stand. Okay. Thank you. Thank you so much for being here. I hope you all are having a day of learning, a day of, I know you're having a full day of civic engagement with other members that you're meeting, and it's just a pleasure to have you here. Thank you so much, and congratulations. Thank you. All right, thank you. So, oh yeah, we got more bills, don't we?
Unless you say otherwise.
I think I know, I was gonna say, I think Delegate Simmons, Phillips, Taylor, Embry, and Grammer would say otherwise. Delegate Simmons? House Bill 875. Okay, Delegate Simmons, I see Mr. Bellamy, and it looks like it's just the two of you.
Outstanding.
So whenever you're ready, thank you.
Madam Chair, I can tell you I'm just so nervous with the distinguished ladies in the back, watching us. It's a lot of pressure, a lot of pressure. I'm gonna try to stay focused. You're right. So Delegate Gary Simmons, District 12B, bringing to you House Bill 875, distribution of literature, purchase of firearms and ammunition. This is a bill that this committee heard last year. We are reintroducing the same bill this year in reference to material that once an individual purchased a firearm or ammunition, that literature would be provided, and we heard previous testimony about literature relating to firearms and ammunition and the importance of it as well. So this would provide some literature around suicide prevention and other healthcare, mental health related stuff with individuals once they are purchasing, go to purchase a firearm or ammunition. And as you know, anytime you go to purchase any type of material such as a vehicle, it comes with instructions and what to do with it. If you go to buy a fan or any other thing like that, everything today comes with some sort of written instructions. And this would be an enhancement of that when it comes to firearms, giving an extra layer of information for those individuals to do in a sense of making sure that they review the pamphlet, know what to do when they're in crisis as well, and what can do to help them. This will be distributed by our Department of Health to our local departments of health as well, to make sure that we're doing our part as stewards of our public, to make sure we're advocating for information, to make sure that we are there for our constituents when the time arises. So with that, I would like to turn it over to my witness as well. Thank you.
Thank you. To the AKAs in the room, I'm really glad to see you all. You saved me when I was in college, when I was pledging with in the blue and white family as Delegate Phillips. So thank you, AKAs, for helping my academic career. Madam Chair, Madam Vice Chair, members of the committee, my name is Lorenzo Bellamy, and I'm here in support of House Bill 875. I represent the Teachers Unified to End Gun Violence. This is a grassroots movement organization of educators and school staff across America, educating and advocating and demanding safety from gun violence in their respective communities. Teachers Unified was founded in January of 2022 in the wake of the Oxford High School shooting in Michigan on November 30th, 2021 by 3 public school teachers. 2 of the co-founders survived 2 of the worst school shootings in U.S. history, Sandy Hook Elementary School in Newtown, Connecticut in 2012, and Marjorie Stoneman Douglas High School in Parkland, Florida in 2018. The founders intend Teacher Unified to fill a gap in the national dialogue around gun violence that doesn't always include teachers, yet we know that schools have been targets. I have to admit that this bill does contain a cost, and it was in the bill last year, House Bill, I think it was 713, or 713, had a cost to it, and essentially the cost was for the publication of these pamphlets. The fiscal note said that it would cost at least $25,000 in 2026, $25,300 in 2027, and $26,000 in 2030. This bill has a fiscal note for FY27 of $41,800, going all the way up to $52,200 in FY31. The only difference that I can see is that the FFLs that would be required to receive these pamphlets went from 750 in the last bill to 785. So 35 additional FFLs, and yet you have this significant increase in the actual cost. So I'm curious about how that comes about. As Delegate Simmons said, and I thank you, Delegate Simmons, for this bill, The literature would address firearm safety and safe, secure storage, firearm training, suicide prevention, and thank you, Delegate Schmitz, for mentioning that, mental health awareness and conflict resolution. And so we think this is a very no-brainer bill here, and we urge a favorable report. Thank you.
Thank you. Members, do we have any questions? Delegate Simpson?
Have you considered reducing the cost by making an electronic or QR code instead?
To my knowledge, that has not been considered. I think the idea behind this was to make sure that we're putting literature in the hands of the gun purchasers as well as the ammunition purchasers, but that is not a bad idea.
I mean, you could say either or. I mean, obviously, if I have my phone and most people do, and you're purchasing a gun, you could just, and you would actually know that they downloaded it clearly.
Douglas Simpson, I'm Simpson, and you're Simmons.
We're not
Simpson.
related.
I know.
Are you sure?
Sorry. One of the areas, the reason why we think they also increased the cost is that in this year's note, it says that they would have to hire, Department of Health would have to hire a part-time person to do this. They didn't mention that in last year's bill, but for this year, they're saying that I guess the additional cost, in addition to perhaps printing papers increased a little bit over the last year or so, but also adding an additional part-time person.
Okay, well, just a thought about whether or not you want to go electronically and maybe cut some of that cost.
That is the way of the future, right? Technology. Yep.
Yep.
Delegate Conaway?
Thank you, Chair. Thank you, Delegate. Bill, thank you, witness, for coming in to testify. So, Delegate, you had this bill last year,
Yes, sir.
and what happened to it?
The bill was passed out of, I believe, out of this committee. We was on a timeline, so, I think that's what.
It just didn't get across
Fell
the street
short.
in
Yeah, it
time?
fell short.
Thank you so very much.
Yes, sir.
So Delegate, I have a question. I notice in the text of the bill that it's the Maryland Department of Health that creates this literature.
Yes.
Why is it the Maryland Department of Health?
So the Maryland, the Department of Health is a lead agency for the state. So what they would do was kind of be the blueprint for the language. So once they make up the language for the bill, then it would be distributed to our local health departments, where they will actually be the ones distributing to local gun shops.
But why is it a health issue?
It's a health issue because we're talking about mental health. We're talking about when people are in crisis, what will happen. So it's to address some of the woes of our community when people are under pressure and they have a deadly weapon with them, and what they can do to intervene with that as well.
I have two more questions real
Yes,
quick. So we're both from the same county, Anne Arundel County. Did Anne Arundel County do anything with something like this?
Absolutely. So Anne Arundel County passed this out earlier in 2022, and it was challenged in the U.S. Supreme Court, in which they took no position on this at the time, and it was returned to the county for that purposes, and they have been moving on the literature ever since.
Thank you very much. Delegate Aragon.
Thank you, Madam Chair. I just pulled up the bill from last year, and I just wanted to give you an opportunity to correct the record. The bill was never voted on.
Yeah. Okay, my apologies. Yeah.
Delegate Taylor, I was looking at you and I was thinking you could read my mind. Sorry about that.
It's okay.
Delegate Taylor.
Not yet. I haven't gotten to that point yet. Thank you, Madam Chair. And Delegate, thank you for bringing this bill. I actually have a bill that's coming up in the, next two hearings here.
Yep.
That there may be some synergies between our two bills.
I've heard.
And I'm wondering if, Madam Chair, if you don't mind, maybe we could put our heads together and potentially put our bills together if there's some synergy there. My bill deals with training the firearms dealers, and in that training, it's the same, issues there. But when the employees are trained, they might have something that they could give to the purchaser. And that sounds like what you're developing with your bill. So
one team.
Potentially.
Yeah. Agreed.
Thank you.
Collaboration is always appreciated. Members, do we have any other questions? Seeing none, that concludes this panel for House Bill 875. We're going to move to our unfavorable panel. Mr. Kasuba and Mr. Jocelyn, And online, Mr. Penix.
It's the same, issues there. But when the employees are trained, they might have something that they could give to the purchaser. And that sounds like what you're.
Okay, Mr. Kasuba.
Hi there, my name is Tom Kashuba, Ellicott City Registered Democrat. I believe that this bill is unnecessary and duplicative and imposes new regulations and enforcement burdens without demonstrating any measurable public safety benefit. It was said that, everything comes with written text about use today. How many people really read those things? Are we just burning trees to produce some paperwork, right? Because I know when I buy things, all that paperwork ends up in the recycle bin immediately, right? But more concerning about this bill is that it compels a private business to disseminate government-approved and authored messaging under threat of fines and inspection. Now, what if we put some literature out there and said, hey, a gun can save the life of your family. Why don't you buy two? Now, would that be acceptable? No, of course not. While the Anne Arundel County similar approach was not accepted by the fickle U.S. Supreme Court, I'd like to point out that the National Institute of Family and Life Advocates versus Becerra in 2018 in California, the U.S. Supreme Court declared that it is clear that the government may not compel private parties to deliver its message absent a very compelling justification. And I don't believe one has been shown here, right? Already, if you go to a gun shop, you see other pamphlets like the campaign for straw purchases called Don't Lie for the Other Guy. Really, how many people read that? It's a cool, catchy thing, but does it really stop anything? So I believe that public education should remain voluntary, targeted, and evidence-based, and not enforced through penalties against lawful businesses imposed upon citizens exercising their constitutionally protected rights. And I'm done.
Thank you, Madam Chair. John Jocelyn speaking for 2A Maryland in opposition to House Bill 875. Literature topics in the bill are largely duplicated by our handgun qualification license and carry permit training. It imposes an unfunded mandate on the local jurisdictions. These agencies lack the financial resources and personnel to implement the requirements of this bill. It entails enormous logistic and enforcement challenges. The fiscal and policy note acknowledges these problems, but it fails to take into account some others. Each jurisdiction will have to determine how many firearms license holders there are in its jurisdiction, how many of them are actually selling firearms. Also, you do not have to have an FFL to sell ammunition. If you go to Western Maryland, you can buy ammunition in any 7-Eleven or gas station, convenience stores, hardware stores. So they would not be identified readily unless each jurisdiction goes to each retail outlet to say, are you selling ammunition? They would have to monitor whether they decide next month they will sell ammunition. It's unknown how the jurisdiction will enforce this by going retail to retail to determine if they're actually complying with it. Mention was made about the cost was for printing. Printing is one thing, but distribution is another. We think the bill is well intended, but we believe logistically it is not workable, and we ask for an unfavorable report.
Thank you, Mr. Panak. And you just have to turn off the video, the YouTube part, so that we can hear you. Okay. Go ahead and unmute him.
Thank you, Madam Chair.
Thank you.
Mark Pennock, President of Maryland Show Issue. In the interest of full disclosure, I was counsel for the lawsuit that challenged the Anne Arundel County case. We did lose that in the Fourth Circuit, and we took it to the Supreme Court, and the Supreme Court denied certiorari. Denial of certiorari does not imply any sort of merits inquiry at all. Since that time, there's been numerous developments in the law of compelled speech, which this is obviously a compelled speech. And there is a case currently before the Supreme Court presenting a square circuit split on this very question of compelled speech and the scope of what the localities and states may compel. So if that is sort of granted in that, and if it comes out as I think it might after 50 years of observing the Supreme Court, I have a pretty good sense for it, then you can be sure that if this bill passes, I will challenge it again, including every county ordinance that incorporates this requirement already. But apart from all that, I wanted to point out, I'm a lawyer for a bunch of dealers. And every dealer can easily defeat the purpose of this bill by putting a trash can next to their counter and inviting their customers to throw away the literature. And once you force people to be agents of the state, to be, if you will, arms of a state compulsion, you're going to generate resentment from the very dealers that you need cooperation from. If you made this bill voluntary, if you made the distribution so the dealer has an option of distributing or not distributing it, you will actually accomplish the objectives of the bill far more likely than you will be by jamming it down dealers' throat and compelling them to do so on penalty of massive fines every time they forget to do so. A simple omission can hit them with being resulted in a fine. So I would urge the sponsors of this bill to think about at least making it voluntary. I urge an unfavorable report. Thank you.
Thank you. Delegate Ericon.
Thank you, Madam Chair. You know what this kind of reminded me of just now? When you go to Chick-fil-A and then they say, like, if they forgot to give you your receipt, you can come in and let them know, you get your meal for free. What if we get our ammo for free if they forget it? I mean, we might all agree that that is not a terrible idea in that case. Isn't that so?
Delegate Simmons. It's not even 8 o'clock yet. We were here till 9 last night. We can't get punchy yet. Okay, Delegate Simmons.
So thank you, and thank you, Mr. Purnett, for bringing your testimony. Let me ask you this. Are taxes charged when you purchase a firearm?
Oh, of course.
Taxes. Okay, all right, yeah. So taxes go to where? Where do the taxes go?
Wherever the wisdom of the General Assembly directs them.
Right, so taxes is part of the government. So you're acting as an agent of the government when you collect taxes. So you said that there's, that distinction, that be number one. So anyone that's collecting taxes on behalf of the government is an agent of the government. Sir, you are a firearms trainer?
I am indeed.
So when we look at firearms trainer, do we teach nomenclature, and what does that mean?
Well, of course you teach nomenclature. In fact, it's required subject matter for the HQL and the wear and carry permit.
Right, so is that y'all just tell it, or do you write it down? Like, is it in paper form, or is it a booklet? Like, what is it? How is it administered?
In the NRA courses, and which are incorporated in the state mandated courses, it's usually in paper form. It may or may not be distributed to people to keep. But what we're talking about here is not something other than compelled speech on the exercise of a constitutional right. So there is a constitutional right to purchase firearms. Now, what you're also levying on top of that is a dealer being compelled to speak the state's message on that purchase. That is compelled speech by Supreme Court precedent. There's no dispute about that, by the way. So compelled speech is a First Amendment issue. It's not simply anything other than that.
Sure, thank you. Many of us have been on the firing range. Many of us know the importance of misfires on a firing range, one's capability or mental capacity, right? Safety, safety, safety.
Amen.
On a firing range, that is about one's capability. There have been situations where people have been actually shot on firing ranges.
Absolutely.
So when you look at the material is talking about one's ability to offer literature that gives one insight into what to do in addition to that nomenclature in event of a crisis that they may be experiencing, tools that one can use in addition to the expert training that the firearm instructors give on a daily basis? No?
Delegate, you're arguing the merits whether the speech is good or not good. The point is not that at all. The point is that the state is exercising its police power to compel people to exercise speech in a certain way. That's a basic First Amendment issue, whether or not the speech is good or whether or not the speech is bad.
So would you say that the state's responsibility is the safety of all citizens of Maryland?
And the state can speak
No,
all
I'm asking,
it
that was a
wants.
question. No, but it was a question. Would you say that it's the state's responsibility for all safety of Maryland residents?
Well, that's a philosophical question. Of course, the state is responsible for seeing to the welfare of its residents. People are responsible for themselves as well. But the point on this is that the state does not have a proper role in telling people what to think or what to say. And this bill compels people what to say. And that the state may not do.
Thank you, sir.
So, Mr. Pennock, I know you said that you have, I think you said you have a pending lawsuit on this, or did you say, or was it that there is a pending lawsuit in California?
There is a pending lawsuit. Well, let me back off of that. Right now, there is not a pending lawsuit on this sort of bill that's actually on the exact firearms. What there is a pending lawsuit and pending in the U.S. Supreme Court on petition for certiorari, in which the circuit split on the scope of the Zouderer doctrine, which is at the heart of the compelled speech doctrine. So Zouderer, and you see this from my written testimony where this is laid all out in very exquisite detail, is the Supreme Court has allowed compelled speech where it's strictly a matter of the terms of condition for the sale. So the terms of condition is like, yes, you pay me X amount of dollars and this is what you get. And these are the restrictions that you may have on that. Attorney may be compelled, for example, to disclose that his contingency fee will not cover costs. That's the content of the Zouderer case itself. The conflict in the circuits right now, and it's a big conflict, it's a 5-7 conflict, is how far that Zouderer doctrine permits the state to compel speech. That's on the case of the petition for cert right now. The circuits are split on this. The Fourth Circuit is, in my view at least, is on the wrong side of that split. That's my case. That's the Anne Arundel County case. If the Supreme Court takes cert in that case, it will resolve that split. And when that happens, and the right side, in my view at least, wins, then yes, all these kind of bills will be susceptible to challenge. And I will bring such a challenge.
I have no doubt that you will. And I'm not going to argue the merits of speech, but I will say that there are numerous instances where the state's interest in public safety is a lot. There is an element that the state could require a certain level of articulation by anyone who is either selling a product that could be dangerous or that they are involved with the public. So there are instances of that. And like I said, I don't want to litigate your case, but in my opinion, I'll just say that, in my opinion, there are situations where, there is, because this case, this is about public safety, okay? And the public safety in the sense of suicide. Quite frankly, I don't own a gun, but if I were to own a gun, I would want some level of instruction, but that's just me. My husband never reads the instructions. I know he's listening right now. I'm sorry I said that, honey. But my husband never reads the instructions. I always read the instructions for something. And I understand, and I take your point, as the constitutional scholar that you are. But we, as sometimes we do, I just think we might disagree on this part.
We can agree to disagree, but I would like to point out, even under the Fourth Circuit's misguided view, the compelled speech must be, quote, purely factual. In other words, not subject to reasonable dispute, and as a conjunctive, and uncontroversial. So the Montgomery County, the Anne Arundel County literature did not, for example, the court held it didn't pass those bounds. So that's a limitation that even the Fourth Circuit recognizes. But more importantly on this is that this is not a subject matter that is uncontroversial. So what does the Department of Health know about firearms training that is not controversial and is purely factual? I mean, I teach this stuff for a living. I teach this stuff to people who want to learn about it, but I don't shove materials down people's throat who don't want it. And this is what the bill does. If you ask the dealer to say, would you help us with this? You might be surprised how many dealers would say, sure, if it's appropriate. And what they're not going to say is, I don't like being told what to do, and particularly on stuff I may not necessarily agree with. And they're going to get massive resistance on that, thereby defeating the very purpose that the bill is intended to achieve. What is that? What does that accomplish?
I appreciate you, as I said earlier, and I appreciate your comments, and I took notes, as I usually do. Delegate Conaway.
Thank you, Chair, and thank you for your comment about reading instructions. I started reading instructions a long time ago, and you get electronic equipment and it'll tell you if you don't fully charge the battery, a lot of times you'll damage it. So I suggest you read the instructions, but my question for the panel is, do any of the gun manufacturers offer literature that they can send to the dealers on these 5 different topics?
Yes, they do, and the National Shooting Sports Foundation also has literature which you can download. The question that we get into with a bill like this, and I want to thank Delegate Simmons for bringing it up because I hadn't thought about it, is he mentioned a misfire.
The what?
A misfire. You know, if you're going to put it in the literature, a misfire is a real thing. It's a safety concern on the range. However, it's only one of 4 possible ammunition malfunctions. A misfire is when the primer is struck by the firing pin, and the cartridge fails to discharge.
Yes.
Then you have a hang fire where the primer is struck, but there is a definite delay between the strike and when the primer activates and fires the cartridge. Then you can have a squib, which is a cartridge that has insufficient ammunition, and you will get a change in the report and in the recoil, and you may have the round lodged in the barrel. And then the 4th ammunition malfunction is called a cook-off, when the barrel is very hot and the round has been in the chamber for a period of time, the heat from the barrel transfers through the case to the powder reaches ignition temperature, and then the cartridge discharges. Each one of those is a range safety issue. If we were to get into the minutia of firearm safety, we would have something that looked more like the Manhattan phone book than a pamphlet.
Okay, I appreciate that. I thank you so very much, because I read one time on a box of what you call shells that said, do not sit this on the stove.
No brainer. You'll only do it once.
Well, thank you very much, and I appreciate the testimony. This concludes the bill hearing and this panel for House Bill 875. We're going to move on to Delegate Phillips for House Bill 738. And Delegate Phillips, I have a panel. Ms. Sarah Mancini, Jane Stranecki, Megan Good, Tina Nelson. Do we have someone from the AARP?
Yes, for the delegate.
Okay, all right. And Mark Cantuna is going to be on Zoom, please. Also, if you could just bear one moment, and Delegate Phillips, I tell you, I don't do this on purpose, but Delegate Woods had announcements she wanted to make.
Yes, colleagues, I would like you all to join me. I have a guest visiting with us who is also here as part of the AKA. Her name is Raina Williams. If you would stand up, she is one of my co-workers at the DC Child and Family Services Agency. So I wanted to make sure you all had the opportunity to meet and welcome her also. Thank you, Madam Chair.
Great. Thank you so much. And Delegate Phillips, whenever you're ready.
Thank you, Madam Chair. Back again. Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. Today, I am respectfully requesting a favorable report on House Bill 738. This is a replay. We're coming back again. This bill establishes the Maryland Transfer on Death Deed Act, allowing a homeowner to transfer real property to a designated beneficiary outside of probate, effective upon death. It is modeled on the Uniform Real Property Transfer on Death Act and is already law in 38 jurisdictions, including Virginia, the District of Columbia, and most recently Delaware. Quite simply, if you can designate a beneficiary on a bank account or an insurance policy, you should be able to do the same with your home. Under this legislation, the deed must be notarized and recorded before death to be effective. During the owner's lifetime, nothing changes. The owner retains full control, the right to sell, refinance, encumber, or revoke the deed at any time. The beneficiary has no present interest. This is a non-testamentary instrument and does not operate like a will. Over the past year, we worked closely with the Uniform Law Commission, members of the local bar, title attorneys, and legislative colleagues in Delaware to address concerns raised last session. So, there are some amendments, and the amendments provide clarity and guardrails. Where multiple beneficiaries are named without specifying ownership structure, the bill defaults to joint tenancy with right of survivorship to avoid unintended disputes. We remove distinctions between married and non-married joint owners while preserving existing estates and trust protections regarding divorce and revocation. We strengthen the form and the frequently asked questions to clarify that a transfer on death deed controls over contrary provisions in a will and that inheritance taxes may apply. We clarified revocation procedures, including revocation by inter vivos deed, and we streamlined proof of death by allowing either an affidavit or a death certificate. We also removed any requirement that the administrative office of the courts provide legal advice, responding directly to prior concerns. Colleagues, this is a fundamentally an access to justice bill, and it is a legislative Black Caucus priority. In too many communities, particularly communities of color and working class neighborhoods, access to estate planning is limited. Lawyers are less prevalent, resources are constrained, and when a homeowner passes without a clear mechanism for transfer, title becomes tangled. Properties sit in limbo, families lose wealth, neighborhood stability suffers. This bill does not replace wills, it does not eliminate probate, it does not create shortcuts around creditor protections. What it does do is provide simple, revocable, affordable tool to preserve intergenerational wealth and prevent unnecessary loss. We often talk about closing the racial wealth gap. We talk about stabilizing communities. We talk about preventing distressed sales and heirs property complications. HR 738 is a practical step in that direction. And for those reasons, I respectfully ask for a favorable report on House Bill 738. Thank you, Madam Chair.
Members of the committee, again, my name is Megan Good. I'm an attorney with the Maryland Volunteer Lawyers Service, an organization that provides free civil legal services to individuals across Maryland. And my team works with low-income families to preserve and pass on the family home. I'm asking for your support of this bill because the transfer on death deed is an important tool for enabling homeowners to plan for and pass legal title to their home, even if they cannot afford an attorney. In our work, we meet heirs where the title to their homes are fractured across numerous family members, and the hurdles necessary to move the deed into the name of the acting homeowner are often insurmountable. I include 2 client stories in my written testimony. Tangled titles heighten the risk of housing deterioration and loss because many programs designed to support low-income homeowners are only accessible to individuals when their name is on the deed. And the power of the transfer on death deed is its accessibility. Though it serves the same legal function as the life estate deed with powers, a homeowner cannot adequately create a life estate deed without an attorney. In the absence of the transfer on death deed, homeowners rely on advice and forms they find online to create bad deeds that have errors in them or work against their interests. This reliable form is even more important now in the age of AI, as we're seeing more and more people go to the internet for their legal needs. The transfer on death deed fills an unmet need by providing homeowners who are already trying to do things on their own with a reliable tool. Another important thing this legislation does is clarify and standardize recording practices across the state. Currently, counties have inconsistent practices for deeds that provide for a future transfer in property. I'm happy to take more questions on that if you're interested. As stated, we've been working hard as stakeholders to strengthen this legislation, and MVLS fully supports the amendments being offered by Delegate Phillips. We ask for your full support of this bill. Thank you.
Good afternoon, Chair Bartlett and Vice Chair Davis. My name is Jane Sternicki, and I'm Legislative Counsel for the Uniform Law Commission, where I work on enactments of uniform acts in real property. We strongly request your support of HB 738 to establish transfer on death deeds. This act is based on uniform legislation created by the Uniform Law Commission, which is a nonprofit state-supported organization with attorneys appointed from across the country to draft uniform legislation on areas of the law where it makes sense. My primary goal today is to provide an overview of this Uniform Act and discuss some of the Maryland-specific changes that we made over the course of the past year. I would like to note as well that amendments were just published this morning in advance of the hearing to address some minor inconsistencies and concerns that we incorporated from the land title industry and from the Maryland State Bar Association's real property section. As background, in 2009, following a 3-year period of study and drafting, the Uniform Law Commission finalized this act to address a growing trend towards non-probate estate planning solutions. However, unlike other states, Maryland does recognize a common law right to transfer real property at death to a designated beneficiary through a life estate deed with powers. When we adapted this Uniform Act to Maryland, we did acknowledge this, but we decided to leave life estate deeds intact to avoid disruption to attorneys' current processes. Instead, HB 738 creates a new statutory process in Maryland with clear parameters for attorneys and transferors who do not have access to legal advice and counsel. Transfer on death deeds are ideal for homeowners whose primary asset is their home. These individuals often have recorded beneficiary designations for bank accounts, for their securities, and for their vehicles. This allows property to transfer automatically at death to a designated beneficiary. We view it as a tool in the toolbox for estate planners and families alike. Transfer on death deeds have 3 key fraud prevention mechanisms. First, they are fully revocable until death. Second, they have no effect until death, unlike a joint tenancy. And third, they're recorded in the public land record so concerned family members and friends can review them. We strongly request your support and a favorable vote. Thank you.
Thank you.
Good afternoon. It's a pleasure to be here, Madam Chair, Vice Chair, members of the committee. My name's Jim Campbell, President Emeritus of AARP Maryland and a former state delegate. And I'm somewhat used to hearings like this, but you guys are hanging in there. So I'm going to summarize my testimony since most of the points have been made already. But in the interest of time, I'm going to kind of summarize some of the points that I wanted to make. One is that this bill is an important step towards simplifying estate planning and easing the burdens that many Marylander families face after the death of a loved one. For many Marylanders, their home, as has been stated, is their primary asset. HB 738 helps keep those homes and families by reducing probate costs and preventing unnecessary sales. It modernizes our laws in a way that promotes accessibility, fairness, and peace of mind. HB 738 offers a practical alternative to ensure that everything a family owns is passed on to those they really care about and those they choose without adding the burden of legal challenges when dealing with the death of a loved one. So strongly urge support of Delegate Phillips' Bill 738. Thank you.
Thank you very much. And Delegate Campbell, it's always welcome. You're always welcome back and welcome home.
Thank you.
So you represented District 42, Baltimore City and Baltimore County?
Yes, yes.
All righty.
Maggie McIntosh and Sandy Rosenberg were there.
Oh, great. Okay. Well, good to see you. Thank you for
Nice to
letting
be
us
here.
know.
Thank you.
Okay, so that's everyone for testimony. Do we have any questions? Delegate Conaway.
Thank you, Chair. Thank you, Delegate, for bringing the bill. Thank you, witnesses, for coming to testify. So one of the witnesses, you said they were designated people to receive the cars and some other things. What was it, the automobiles and what else?
So in today's environment, you can put a death beneficiary on your bank accounts. You can put a beneficiary or a person to take at the time of your death your vehicle. You already put a death beneficiary on your insurance policies.
Okay.
So similar.
On your car, so when you go to the dealer to purchase the vehicle, They might ask you, who would your beneficiary be, or
On the titling, you can do that.
on the titling, okay? And the people that we're talking about, are these people without a will? They don't have a will?
Perhaps they could have a will, but they could be used in conjunction with a will. So it doesn't say you can't have a will.
Yes, but are the people that you're talking about people that have a will?
So what we're really targeting is
don't
those,
have a will?
No, so what we're really targeting is those individuals who would like to figure out how to transfer their property without going through probate.
Okay. So they'd want to bypass the registered wills office, not have a will, basically, what you're saying, and just transfer the property from one person to another?
Can I add to that?
Go ahead.
Is that what we're saying?
So the deed does allow for that. It allows for automatic property transfer, just like any other type of joint ownership. And a lot of the clients that we're serving, which really are kind of the target people that we're thinking about, folks who can't afford an attorney, the ones that we do reach and able to talk to them about what we have now, the life estate deed, many find that direct transfer really appealing for a couple reasons. One, they may be passing, they know that they're passing their home to a loved one who themselves would struggle to go through the probate process because of their own limited resources or maybe just challenges with navigating administrative processes. So they recognize that by titling their home in a way that provides for an automatic transfer, they are increasing the likelihood that their intent to pass on the property will succeed and they won't lose it because someone doesn't know how to change the deed after they die. The other thing that this is really important is that it is providing folks who are doing it on their own with a way of creating joint ownership while protecting their own rights and interests. So without this deed, what we see people doing is adding their child as a joint owner today, which opens the home to a lot of risk because that child could sell their portion, their creditors could come after the home, things like that. So when community members learn that a tool like this is available, it is extremely appealing to them because while they're alive, they retain full power over their home. Their child's debtors aren't going to come after the home, but they know that when they pass, they've provided for their child to be the owner automatically.
Okay, so this is the direct transfer deed. And would you suggest getting that deed done at the time you purchased the property?
It could be done at the time, or it could be done at any later point in time, once you've made some decisions about how you want that property to transfer.
So then you would have to get the deed changed? You would go to attorney and get the deed changed?
No, you wouldn't go to an attorney. That's the whole point of the transfer on death deed. So the transfer on death deed is situated in a way with a set of FAQs, frequently asked questions, similar to what we've done now with the model power of attorney, if that makes sense.
How much would this cost?
Just the filing fees.
Okay, and when you have a home, let's say it's $200,000, it's paid for, and you have a will, you have to pay a death tax on that property be transferred?
Depends on who you're transferring it to.
So with this bill, you can transfer it to anybody?
With this bill, you could transfer it to anyone, yes.
Yes, okay. All right, thank you so very much, though.
Just to be clear, if there are any inheritance taxes due, that this bill changes none of that. So that's a common question we get, and that's one of the improvements we made this year. We added that to the commonly asked questions. Sometimes people will say, well, I want to avoid probate because I want to avoid inheritance taxes. Inheritance taxes are due regardless of how it's transferred. And so we do provide that information in that supplemental form so people have that information.
Well, I appreciate that because that changed my perspective. So how much does it cost to register your will since you won't have to pay for the transfer? Do you have any idea how much it costs to register a will?
So the costs.
So Delegate, the cost of registering a will depends on which jurisdiction, I believe.
Okay, let's say Baltimore City.
I think it's still $5.
I think it's like what?
I think it's $5.
Yeah, I think it's $5. So why not register your will and it'll be transferred through and only cost you $5 down at the registered wills office?
A common, honestly, this actually leads to a lot of the tangled titles that we see. Many people say, well, I am the homeowner. Look, here's the will where my mom left me the home.
No, I'm on the, you go down to the registered wills office down in Baltimore City. You go up on the 3rd floor, 4th floor, you pay your $5, you register your will, somebody dies, you go down there and say, can I get a copy of this will?
Yeah, the will doesn't transfer title to the home. And so a lot of people miss that step. Just because your name is on the will saying you get the home doesn't mean you have the home. You have to go through the entire probate process where you do things like collect other assets, pay debts, et cetera.
Yes.
And so many people don't know you have to go through that process or can't go through that process. There's many barriers, and by the time someone gets to that step, we see other people who've inherited passing away and tangled titles being created. So this deed, the point is to get broader access to a deed that allows for someone to transfer their home automatically without going through that.
You might not be able to directly transfer the deed over, let's say if there's a $50,000 mortgage on the house or something like that. You might have to go through some paperwork. Is that what we're saying?
I think really, and so let's work our way through this. The having the creation of a will does not necessarily equate to the transfer of property from one person to a next.
I agree. Go ahead.
I list a person who's a beneficiary, but I must come through the estate process and go through the probate process to pass that property. As an attorney, many of those who practice in estate planning would suggest to you that it is in your best interest to make sure you have no probate assets and that all assets would transfer outside of the probate process. Unfortunately, most people that can take advantage of that have estate planners which they're spending thousands of dollars to lay out that plan. In the alternative, the transfer on death deed gives an individual who may not have thousands of dollars the opportunity to take their largest asset and do the same thing that folks that have trusts and attorneys, et cetera, do on a much more efficient and effective basis.
And cheap.
Absolutely.
Is that what you're saying? And cheaper?
Absolutely.
Okay. Thank you so very much, Delegate.
Delegate Woods.
Thank you, Madam Chair. This question is actually for Mr. Necki. Did I say that correctly?
Close enough, yeah.
All right, thank you, my apologies. What are the changes that were made, if you could be more specific, to adapt the Uniform Real Property Transfer on Death Act for Maryland?
Thank you so much for that question, Delegate. So the key differences between the Uniform Act and the Delaware version of the Uniform Act are that the Delaware version has the default be joint tenancy. So when two people, let's say I'm going to transfer my property to my two children at my death. Under the default rules created by the Uniform Law Commission's version, we would defer to the common law, which just says that it becomes tenancy in common. Tenancy in common creates myriad problems from an heir's property perspective. That share gets passed down through the generations and segmented and segmented. The default under the version that we've created for Maryland, this bill, is that instead those two children would inherit as joint tenants with right to own the property, or the deed itself can designate a different ownership structure. So that is just the default. If someone doesn't say it will be joint tenancy, they are more than welcome to write in tenancy in common. They can write in something else if that's their intent. But that is a key change. The other significant change is that the Maryland version allows revocation by an inconsistent inter vivos deed. So that means that if I no longer own the property when I die, I've sold it to someone else, my children will not get anything. The Uniform Act it acknowledges this complicated property concept called a pecuniary devise, where my children might be entitled to something. We've basically decided we're not going to deal with that. That's in line with existing Maryland law. So if I don't own the property when I die, my children get nothing. Those are the two most significant changes, and we made those changes in light of discussions with many stakeholders, with Megan's colleagues, with the Land Title Association, with the Maryland State Bar Association. The Uniform Law Commission is always sensitive to the needs of the enacting state, and we certainly were here as well.
All right, thank you so much. Thank you, Madam Chair.
Thank you. I'm going to wait, and somebody might ask my question. Delegate Taylor?
Thank you, Madam Chair. Did this bill pass out of this committee last year?
Good question. I don't remember. I don't think so.
I don't remember
either. I don't think so.
Okay, but is it in the same posture? I know you mentioned
No, we've
several
made a number of
amendments.
changes. So last year, and you'll look in your on your floor systems, we have one unfavorable, and that that was not a part of the discussion, the group that did that. All of the other groups that have participated and perhaps were unfavorable last year, MSBA, Maryland Land Title, and the courts have all, now they're favorable with amendments. So we really worked really hard to address the issues that were raised last year to come to some resolution to move this forward.
And Delegate Phillips, if I may add, so the Uniform Law Commission actually didn't view last year's version as uniform. So we made a number of changes to bring it into uniformity so that people who move between Delaware, Maryland, Virginia, DC, they're all going to have those same protections, and they can trust that if they record a transfer on death deed in Maryland, it will have almost the exact same benefits as in all those other states.
Thank you.
Delegate Embry? I didn't skip you on purpose, Delegate Valentine. Delegate Valentine? I just happened to write down your names in that order, but go ahead, Delegate Valentine.
Thank you, Madam Chair, and thank you, Delegate, and thank you, panel. Unfortunately, I had a little bit of experience with one of the topics you brought up, and I asked this for a reason, for the life estate component, because I know multiple of the testimony is kind of alluded to life estates. Can you tell me the main difference / benefits of going this route between the life estate route when doing a property, just so I can kind of understand the difference of what this bill will accomplish?
Yeah, the main benefit of this bill is that somebody can do it without an attorney. Functionally, it operates the same as a life estate deed with powers. And I emphasize with powers because in Maryland, we have two different types of life estate deeds. The one with powers, the owner retains full power over the property. If they name their child, have a falling out, they can change their deed without them agreeing. Like they're not giving up any of their rights. The life estate deed without powers, they are giving up some of their rights as soon as they execute the deed. They couldn't change it in the future without whoever they've named agreeing to it. This is one of the reasons we don't want people trying to do a life estate deed on their own, because they may try to keep full power and fail to do so. Life estate deeds are also, like, it's impossible to avoid legalese. So when I'm working with a client trying to explain life estate deeds to them, I literally have a handout where I have words like life tenant, remainderman, because I can't not use those words. And so usually what I say to people is, it's like naming a beneficiary for your house. And as soon as I say that, they're like, oh, I get it. Because they're accustomed to using beneficiaries in other spaces. So with the transfer on death deed, the main advantage is we're using plain language to enable people to do what we're already permitting people to do with the life estate deed, but they just aren't, they don't know it exists, and they aren't able to actually create one without an attorney. At the same time, homeowners in Maryland can already do a deed without an attorney. So this isn't a new power that we're giving people. The power already exists. What we see are people doing quitclaim deeds, joint tenancy, and usually if they get a deed recorded, it has errors in it, or it has consequences that they didn't intend. So main benefit is its accessibility, it's reliable. We're seeing more and more people use AI. We don't want them using AI to make a life estate deed. And then functionally, there is one difference in the process of recording, which is that this deed has to be recorded prior to the homeowner passing away. And that is there to address some of the concerns related to fraud that people have raised. So that's the only, like that difference in the recording process is the only thing that's really different.
And let me explain why that's important. And also, you got to understand, life estate deeds are a development of common law. Right, and real estate development with attorneys over time. This would be codified, right? So an individual would be able to use codified language to prepare their transfer on death deed. The second thing is, and I'll just talk about just one of the scenarios that I've now seen on multiple occasions about when the document must be filed. In a life estate deed, it is possible to have a life estate deed and not file it prior to the person's death, right? And that's how our current law is in Maryland. Once again, this is common law. When that happens, at the time of the death, let's say there is a will, and the will says property A goes to my wife. But there's a life estate deed that wife did not know existed. The PR did not know existed. That life estate deed could be filed after the death, and now it's not part of it, nobody knows. So when we start talking about fraud, there's all kinds of opportunities there with the existing instrument that we have. So I think we all think that this is a better way of going about it.
Thank you for that explanation. Thank you, Madam Chair.
Thank you. Can I call Delegate Embry now? I'm just giving you a hard time, Delegate Valentine. Delegate Embry?
Thank you, Madam Chair. Thank you for allowing me, Delegate Valentine. I love this bill, and thank you so much for all the hard work I know you've done on it. I just want to, for the record, make sure that you address the judiciary and the circuit clerk's concerns. It sounds like they're resolved, but if you don't mind responding to that.
Yeah, so I believe the outstanding concerns from the judiciary and the Supreme Court are just procedural. So the possibility of adding in a tax affidavit to make sure that the taxing authority understands who now is responsible for the property. And we are open to that, so we would be willing to have those discussions. The only requirement is that it cannot be mandatory. So it must be that the beneficiary is filing this optional tax affidavit to make sure that they get the property taxes and the property isn't subject to a tax sale. But the property has to transfer immediately upon death. We can't have a scenario where it's not clear whose property is it because this person hasn't filed this secondary form yet. So we're confident, unless there's some other concern that I wasn't aware of, we're confident that that will resolve.
I mean, they do have other concerns, but it may be that they're already addressed through the amendments about.
There were considerable amendments that just dropped this morning. So we'll review that, and if there is anything else, we'll have those discussions with them. Thank you.
Thank you, Delegate.
Thank you. Delegate McComas?
Well, there's actually the title companies and also the clerks as well as the courts. But there's something else I'm kind of a little concerned about, because I think you've solved some of the issues of the notice if it's in a town and that they have to do that thing that they're going to file a deed and they have to get everybody to sign off. My concern is if there's, let's say it's a life estate that you do, what happens if the person passes away but they are in a nursing home and that's an asset that Medicaid may want to get, so there will be nothing.
Yeah. So there's still encumbrances. So if the property is encumbered by a mortgage, if it is subject to Medicaid, it's subject to any other form of debt, that would still apply, because you have to remember it's still in the ownership of the individual.
Okay, all right.
Of the grantor.
Yeah, because that's an issue. Yeah. Because you're trying to make sure that the family gets an estate, and then the government comes in and say, hey, you owe some money.
That's true.
Okay, all right, thanks.
Great. Now I'm going to ask my questions. No one asked it. So what we're hearing a lot about is deed fraud.
Yes.
Could you talk to me about what has been put in place with respect to the transfer on death deed to assuage some level of fraud?
Yes.
I know you can't get rid of all of it, but what are the protections?
Absolutely. So it's our very strong position that a transfer on death deed creates no new vectors for fraud, right? We're not naive enough to say that it's absolutely impossible. But the revocability is a very key provision here. So transfer on death deeds are recorded in the public land records. Like I mentioned, anyone can see them, right? So if I'm concerned about my elderly neighbor being potentially a victim of deed fraud, I could look at the property records and see if someone recorded a transfer on death deed on their property. If I suspect that was recorded nefariously and I confirm that it was recorded nefariously, that elderly neighbor could record a revocation. And it would basically completely put the genie back in the bottle. So there would be no effect at all. The transfer on death deed would be revoked. So this is significantly better than quitclaim deeds or adding a joint tenant, where if you add a joint tenant, you cannot take that joint tenant off without their consent. If they are a bad actor, they're not going to consent to being removed. So that's a very significant benefit. So the revocation, the public nature of it, and the fact that it has no effect until you die, those are the key protections from a fraud perspective.
I understand. But that leads me to a whole nother list of questions, which I won't ask here. But it does concern me just a little bit that it doesn't go into effect until you die. So is that an incentive to?
No, so actually the bill does address this. So Slayer statute is incorporated. So
Okay.
if you kill the person, you're not going to get the property to put, not to find a point on it.
Thank you very much. And then my last question is, there's a coalition, and these might be where your amendments came from. The coalition, I was trying to get the name of it, it's kind of long. The TB Southern Region Neighborhood Coalition?
Yes.
Okay, so the amendments that you were talking about, though, seems like some of those are being addressed here.
So some of the amendments were addressed, but some of them are based off of an unfortunate misinterpretation of the intent of the act. So I can go through it directly if you'd like.
Well, you know, if you could put it in, if you could send us an email, that would be much better. And the reason for that is because, you know, it's just in the interest of time, but also because there's a lot. I mean, this is a 27-page document that they sent us.
I will say, I can address them very quickly. It's really just 4 concerns.
Thank you.
So the first concern that they mentioned is that a fiduciary cannot revoke. That is in line with existing trust code in Maryland. So we are not authorizing a fiduciary to revoke. If we want that privilege, you would have to amend the Maryland trust code. The second concern is that the amended bill provides for 2, so they were concerned that we only have 1 beneficiary on the form. That has been addressed by an amendment that adds a second line for a second beneficiary. The third concern is that there's a perception that this bill restricts transfers by tenants in common, and that is a misinterpretation. So tenants in common are not bound by the same rules as a joint tenant. Under this bill, a joint tenant, if you have 2 or more joint tenants, they must all be present to both create and revoke a transfer on death deed. Tenants in common are not bound by that same obligation. A tenant in common can still transfer their single interest with a transfer on death deed. Just because they're not included in that definition of joint tenant doesn't mean that they're excluded from the bill. Both 141001E and 141001F make it clear that a tenant in common would be included. And their fourth concern is a recommendation for a tax exemption. That's beyond the scope of this bill and could potentially be addressed with additional legislation. So those are the 4 concerns.
Okay, great. Thank you very much. I appreciate that. You just condensed this for me. And members, do we have any other questions? Seeing none, that concludes this panel. We're going to go on to our next panel for this bill. And we never did have Mark Katuna.
Madam Chair, Mark Katrona was not going to appear, but Sarah Bowling-Mancini is on Zoom.
Okay, so Sarah Mancini. Okay. But actually, yes, because she was supposed to be part of this panel. So let's just go ahead and bring her in, and then we'll get to our next favorable. Actually, okay. Hi, Ms. Mancini. You're going to need to turn off the YouTube because it will echo for us. Okay, great. Thank you. And whenever you're ready, you'll have 2 minutes.
Thank you so much, Madam Chair and members of the committee. My name is Sarah Mancini. I'm an attorney with the National Consumer Law Center. We wanted to testify today in support of this bill because it is extremely important, and we provide the comparative context looking at states from around the country. In passing this bill, Maryland would now join the majority of states that have a clear, simple statutory process for passing a home or piece of land to one's loved ones without the requirement to go through probate. And right now, of course, there is a growing focus on the challenge of heirs' property around the country. This is the situation when a home or land are passed down over multiple generations without the deed records being formally updated. And of course, that leads to ownership becoming clouded or unclear and also fractured among many heirs, making it difficult to use the property in the future. We know that access to estate planning and to lawyers and courts is not equal, and that's what contributes to the creation of heirs' property. Many groups have been engaging in estate planning and wills clinics in underserved communities, but unfortunately, as has been alluded to by this panel and the questions that arose, When a will is created, the heirs after the death will still have to take that additional step of filing a probate court action, finding and serving all of the heirs at law. That is a meaningful barrier and will not be surpassed by many folks. And so this bill is especially important for people living in legal deserts, rural areas, economically struggling communities, and we think it's extremely important that they have this option to have a clear and simple method of conveying their home to their loved ones that'll help protect generational wealth and protect stable housing, and we would urge that the bill be favorably reported. Thank you.
Thank you very much. Members, do we have any questions for Ms. Mancini? Okay, seeing none, thank you very much for testifying. We're going to go ahead and just get everybody on the favorable panel now. Carithia Chambers, Vanessa Clark Brooks, Tina Nelson, who may be online. She is not? Oh, she was here earlier. Okay. Okay. Tina Nelson, maybe she's watching.
I think she's on.
Yes. Oh, sure. For the, oh.
Since we're announcing AKA.
Oh, sure.
I would like to introduce one of my favorite AKAs, a person that I adore and love and have grown to admire for so many years. My cousin, Lisa Harris Jones. Unfortunately, she doesn't have pink and green on today, but she is an AKA.
Well, thank you. Thank you very much. And we always welcome all AKAs to this committee. Sorry, I'm just joking. We welcome everyone to this committee. Okay, so let's go ahead and get started. We'll start on this end. And are you Ms. Chambers? Yes, ma'am. Yes, and so whenever you're ready. Thank you very much.
Chair Bartlett, Vice Chair Davis, and members of the committee. My name is Carithia Chambers. I am a student attorney in the Estate Planning and Heirs Property Clinic at Howard University School of Law. And the families I work with are exactly the people this bill is designed to help. Elderly homeowners who want to keep property in the family but cannot afford an attorney to make it happen. Under this bill, the deed creates no present interest in the beneficiary and does not expose the property to the beneficiary's creditors. That also means no transfer has occurred for Medicaid purposes, so an elderly homeowner who later needs nursing home care will not face a penalty period that blocks their benefits the way a life estate deed can. And the bill includes a statutory form any homeowner can complete and record without hiring a lawyer. That is the heart of this bill. Right now, families must pay an attorney to use the only comparable tool available. And if that deed is drafted incorrectly, they can permanently lose control of their property. This bill gives them a straightforward path they can take on their own. Delegate Phillips' constituents and constituents across the state deserve the same planning tools for their homes that Maryland already provides for everything else they own. I respectfully urge the committee to vote in favor. Thank you for your time and consideration.
Madam Chair, I think I should be on this panel. My name is Maya Buchanan.
Ms. Buchanan, whenever you're ready.
Okay, thank you. Chair Bartlett, Vice Chair Davis, and members of the committee, thank you for the opportunity to testify in support of this legislation. My name is Maya Buchanan, and I am a third-year law student at Howard University School of Law. Over the past 18 months, I studied transfer on death deeds, and I had the opportunity to observe and conduct research in the drafting of this bill. At its core, this legislation is about individual property rights and whether families can keep and pass down the homes they worked their entire lives to secure without unnecessary legal barriers. In many communities, especially communities of color, limited access to estate planning means property is often transferred informally, leading to unclear ownership, property disputes, loss of the home, and displacement. Transfer on death deeds offer a straightforward solution. A homeowner may designate a beneficiary using a standardized, publicly recorded, and revocable form that takes effect only at death. They are both transparent and safe. This is particularly important for Black and Brown families, for whom housing wealth is often a primary asset passed between generations. When title becomes tangled, that wealth can be lost, leaving families vulnerable to predatory acquisition. This legislation also aligns with Maryland's broader commitment to reparative justice, including the Maryland Reparations Commission. Supporting families and preserving existing homeownership is one of the concrete ways to prevent further erosion of generational wealth. Transfer on death deeds do not create wealth, but they help prevent its loss by allowing property to transfer outside the probate process, which can be expensive and time-consuming. Importantly, this bill does not replace traditional estate planning. It reaches those who would otherwise do nothing at all. For families, the choice is not between a transfer on death deed and a lawyer-drafted plan, but between a transfer on death deed and no plan at all. This is an access to justice issue. Providing a simple, accessible, revocable, publicly recorded option helps close that gap and protect families across generations. For these reasons, I respectfully urge the committee to support this legislation. Thank you.
Thank you. Chair Bartlett, Vice Chair Davis, and to members of the Judiciary Committee. My name is Vanessa Clark Brooks. You may know me as Chief of Staff for Delegate Phillips. I am a Maryland resident of the 10th District and a former resident of Cecil County. Thank you for the opportunity to testify on this issue. After working closely with Jane Sternecki and Megan Good, I shared my personal family story on the issue of tangled title. They encouraged me to put face to the issue, so to speak, based on a personal family experience. The transfer and death deed can prevent tangled titles resulting from homeowners dying without a will and specific heirs. In my family, this happened over several generations. Property passed through Maryland intestate laws to tenants in common that allowed the property to go to a forcible sale. My great-grandfather, George Hyman, was able to purchase two adjacent lots, 115 and 117 Milburn Street, Elkton, Maryland, in Cecil County. My grandparents built a home, a duplex, and my grandparents and their two of their four daughters resided at the property. When my great-grandfather died, he left no will. When my great-grandmother, Annie Congo Hyman, passed away, she left no will. The property passed to four surviving daughters. Two lived on the property until they died. Several of the grandchildren of George and Annie lived in the properties with their families until their last grandchild that lived in the property died. For a few years, both properties remained uninhabited. Ownership of the property was unclear, and the title would remain clouded regardless of who paid the back taxes on the property. My mother and her first cousin were remaining tenants in common, neither of whom wanted liability without clear title, so property was forcibly sold by one of them. The property was sold for less than $3,000 and was purchased by investors. In short, we lost a family home because there was no clear title. This legislation will help many families like mine preserve their properties, and I thank you for giving me the opportunity to testify.
Thank you. Did you get a chance to finish?
I wanted to say just one other thing.
Please do.
The sale of the properties on Milburn Street in Elkton led to the loss of ownership for all potential heirs and resulted in the loss of intergenerational wealth. The property was not sold at fair market value. Several investors have since purchased what is now two adjacent lots valued at $45,000 each. To reacquire the former family property, it would cost us over $90,000.
Thank you. Members, do we have any questions? Delegate Phillips, you don't have any questions?
Well, my question is this. So first to the law students, you're doing this work and you're doing this through your clinic. Can you tell us a little bit about the clinic and any other information that you've garnered over time about transferring properties?
But briefly.
Briefly.
Thank you.
I won't take too long. So in the estate planning and heirs property clinic, we essentially serve DC and Maryland residents in terms of helping them get their affairs in order. As we know, minority communities aren't very well versed in just what it takes to be able to take care of that, protect their assets and transfer them. And so we like to stand in the middle and be able to provide education on trust, transfer on death deeds, ADHCs, which is Advanced Directives for Healthcare, and durable powers of attorneys, just to ensure that in any event that their assets, their interests, and their overall generational wealth is protected.
Thank you. And to Ms. Brooks, thank you. I didn't know you would testify.
Surprises.
Isn't that so?
And happy Ayami to you. This is our Baha'i Festival of Happiness, so to the whole committee, happy Ayami.
Thank you so much. Ms. Buchanan and Ms. Campbell, I wish you the best in law school. Thank you for being here today. Go back and read. Okay, no, and I'm not saying that because you got anything wrong. I mean, because I know you have a lot to read for school. Delegate Conaway.
Thank you, Chair. Thank you, panel, for coming in to testify. So, in your opinion, what's the difference between this type of deed and you registering your will at the Register of Wills office? Anyone can answer.
Difference between what?
Well, this is the, yeah.
So.
She's in the clinic.
Yes. So with the life estate deed with powers, during my research, what I've been able to see is that it creates a present interest that the beneficiary can take advantage of. And so with the transfer on death deed, one, it just creates a division between what can be done presently, but while the transferor is still alive, as well as once they pass away. And so what we do, what the transfer on death deed does is kind of create that delineation. So there, in terms of like Medicaid, for example, you won't be able to, in terms of when you want to take advantage of that type of assistance, you need to be able to, the Medicaid Association or organization will do a 5-year look back. And so you want to make sure you don't look like you're just dropping off your assets. And that's something that would be deemed if you do a life estate deed with powers. So it'll automatically trigger the look back. And so you want to ensure that you are not trying to take advantage of the system or anything like that. And so what a transfer on death deed does is allows you to be able to, get access to your Medicaid benefits or, take advantage of that, but not have the look back that are subject to you, like a delay or like prevent you from being eligible to be able to take advantage of those benefits.
So in other words, your benefits, if you take advantage of your benefits for 2, 3, 4 years and you pass away, then that won't be held against the property? Is that what you're saying?
Under a transfer,
But if
I'm sorry, apologies, not held against the property, but not, it won't hinder you from being able to take advantage of those benefits.
Right, okay. Oh, because you have property? Yes, okay. Thank you so very much.
Great, thank you very much. Members, do we have any other questions? All righty, thank you for being here, all of you. Appreciate your testimony. We're going to move now to, is Tina Nelson online? I believe not, right? Okay, so we're going to go with our favorable with amendment, Jeffrey Thompson, and online, Aisha Sneed, online. Okay, so we're just going to go with Mr. Thompson.
Madam Chair, Madam Chair, members of the committee, I'm Jeffrey Thompson. I am here on behalf of the Maryland Land Title Association. It is the association that represents the interests of the title companies as well as and forgive me, I think I do better if I'm standing up, but it represents the interests of the title industry.
Mr. Thompson, can you just, yep, there you go. Thank you.
I'm usually short enough that I don't have to do that. But we represent the interests of the title insurers who insure property and the title companies who handle the transactions and work on behalf of the title insurers. And I'm happy to say that for the first time in I don't know how many years, I'm actually here not to say this will never work. We do have the life estate deed with powers of alienation. That's going to continue. What this does is it adds one more tool into the box that will help people preserve their estates. And we have worked very hard with Delegate Phillips' office and over the last year to get items in there that fit because Maryland is unique. It's not uniform, and we had to conform the laws to those of the Maryland constituents. The one item that is not there that we're working on is a trigger that allows the State Department of Assessments and Taxation to change their records so that the tax bills go to the people that will need to pay the taxes, so the property doesn't wind up in tax sale. That is the purpose of the amendment that we're working on. And as far as concerns that I heard about fraud, about other things, we have that already with the life estate deed. It is the title industry that is your protection and the protection of everyone else. We're the ones that stop that at the table and ferret that out so that people can have clear title.
Thank you very much. Mr. Thompson, don't go anywhere yet. I have a question.
Yes.
Because you triggered something. How does the land and title associate, or how does title, what is the word I'm trying to come up with? How do you all protect against fraud? That's what I want to know.
When you put your contract in and the contract goes into a title company, one of the very first things that has to happen is we have to determine that the people that are going to be sitting at the table transferring the property are really the people that own the property. There's a very complex procedures that are now gone into in terms of verifying that the individual sitting at the table really is them. There are many vendors that provide validation services so that we know that the driver's license that's handed to us is real and is accurate. There are procedures that we go through in examining the title to determine whether or not the people are there. Sometimes it boils down to a gut feeling. If somebody has come in and they want to represent their parents because they have a power of attorney and they want to transfer the property to themselves, quite often that's not going to make it past the title company because the power of attorney doesn't give them the authority to do that, and the title company then has to reach out to the individual and say, are you aware that your attorney is, your attorney in fact is doing this, and do you really want to do it? So
you would be at the table how would you help with respect to a transfer on death deed, though?
With a transfer on death deed, it would be the very same thing that happens with a life estate deed. We would look at when the deed was completed. And in reality, if a transfer on death deed is signed, the night before the person dies, there will be a very careful examination as to whether or not the individual understood the significance. That doesn't take away from what the transfer on death deed accomplishes. What that does is it means that as an industry, it is the title companies, the title insurers that examine the process to make sure that the intent behind the transfer on death deed was genuine.
So last question, how on a transfer on death deed, how would it be initiated that the title company would even be involved? Because part of the testimony was that we want to make sure that this becomes less expensive, we don't have lawyers and all that. So how would you all be involved?
That's actually an excellent question, and the answer to how we become involved, we're not involved when the title transfers in keeping with the transfer on death deed. We become involved when that individual either wants to refinance or wants to sell. And if we can't insure the property, then no lender is going to lend and no buyer is going to wind up buying. So it's very important that the property not only transfer, but the property be insurable. And that's what we've been working with Jane Sternecki, with Megan Good, with Delegate Phillips, to make sure that the bill that you have in front of you provides a tool that is not only capable of transferring title and preserving generational wealth, but is insurable when they go to use it.
I really appreciate you here, and thank you for your indulgence with my questions. Thank you, members. Thank you. That concludes our testimony for House Bill 738, unless we have Aisha Sneed online. Nope, we do not. Okay. That concludes the bill hearing for House Bill 738. We're going to move now to Delegate Taylor. House Bill 741. And Delegate Taylor, I have a few witnesses. I have, for your panel, I have Kelly Sampson.
Yep.
Karen Herron, I didn't see you there. Okay, perfect.
Madam Chair, may the rest of the panel be called up too?
Yes, Layla, is it Layla Greeton? Ethan Bartlett. Is Mr. Bartlett here? Okay.
No?
You can call
And
him
also
on.
the virtual witnesses?
There's one, there should be one more. Nayla Jimenez.
Say that name again?
Nayla Jimenez.
Well, let's see.
Oh, Ethan's online.
Oh, yeah.
Let's see who we have here. I have, is Mary Kana here?
She would be virtual.
No?
She would be virtual if she is.
Okay. I tell you what, here's what we have. I have Kelly Sampson, Karen Herron, Layla Greeton, I'm sorry, Ethan Bartlett, who I see there, and I don't have anybody else. But if you tell me your name once more.
Lindley.
It should be Nayla Jimenez.
Okay, and what did you say, Delegate Taylor?
Steve Lindley, Aaron Earp, and Mary Kana.
Right, Steve Lindley is online. And Aaron Earp is online. But we don't have Steve Lindley? Okay, ma'am.
Mary Canal submitted written testimony.
Okay. Ma'am, why don't you go ahead and have a seat right there at the end? So you're with Team Enough, and perhaps I'm not reading this correctly. Okay, Delegate Taylor.
Thank you, Madam Chair. Thank you, Vice Chair and fellow members of the Judiciary Committee. For the record, I'm Delegate Kim Taylor, representing Prince George's County's District 23. House Bill 741 strengthens Maryland's firearms dealer oversight system by closing a gap in our current law. Gun dealers and their employees serve as the frontline gatekeepers for firearm access. Their decisions, often made in real time on a sales floor, directly affect whether guns are diverted into illegal markets or reach individuals at risk of harming themselves or others. Yet today, Maryland requires only the licensed dealer to complete a one-time initial training, not the employees who handle and sell firearms every single day. That's the loophole that this bill seeks to address. Under federal law, employees of federal firearms licensees, or FFLs, as you heard earlier, are not required to receive training before handling or selling firearms. Maryland, however, has taken steps through licensing, inspections, and one-time dealer orientation, but we still lack standardized, ongoing training to help identify straw purchasing, trafficking, fraud, or buyers in crisis. House Bill 741 closes that gap by requiring training and basic written exam for dealers and employees. And with a pending amendment, that written exam may become virtual. This approach is not new. States like California, Colorado, New York, Illinois, and New Jersey have adopted similar standards for firearm retailers. House Bill 741 simply aligns Maryland with common sense practices already in use across the country. House Bill 741 is a collaborative bill that establishes practical training standards, strengthens accountability at the point of sale, and helps prevent illegal firearm transfers before they occur. As a result of yesterday's Senate hearing, Senator Will Smith offered several amendments that we could talk about. But in the meantime, I look forward to continuing to work with the Maryland State Police, other stakeholders as this bill moves forward. And for these reasons, Madam Chair, I respectfully ask for a favorable report.
Chair Bartlett, Vice Chair Davis, and committee members. I'm Kelly Sampson, Senior Policy Counsel at the Brady Campaign to Prevent Gun Violence. HB 741 is a win-win. It not only equips gun dealers and their employees to comply with what current Maryland law already requires them to do, but it'll also save lives. Right now, Maryland's oversight and regulations on firearm sales are good, but gaps still remain. And one of the most consequential gaps is the lack of any required training for employees who handle and sell firearms, and the lack of ongoing training for firearm dealers. Under current federal and state law, gun dealers and their employees already have the power to prevent sales to gun traffickers, straw purchasers, and those in crisis. This training will help them use it. And training matters. Consider the difference between Maryland and New York. Both states have robust gun laws, but New York requires dealers and employees to undergo initial and ongoing training. Maryland does not. In 2024, Maryland dealers sold 48% of the traced crime guns recovered in the state. In contrast, only 21% of the traced crime guns recovered in New York came from in-state. Training could reasonably account for at least some of these differences. And statistics show that Maryland would be wise to resist complacency. From 2020 to 2024, the number of crime guns traced to Maryland dealers grew every year. Between 2023 and 2024 alone, Maryland dealers sold 4,529 guns traced to crimes in the state, even as the number of crime guns traced to national dealers decreased. In other words, Maryland's dealers and their employees are still allowing too many dangerous sales to occur, and training will help reduce this trend. For these reasons, Brady urges a favorable report on HB 741. Thank you.
Good evening, Karen Herron, Executive Director of Marylanders to Prevent Gun Violence, here in support of HB 741, requiring firearm dealers and employees to complete training and an exam on state and federal law and responsible sales practices. Maryland does have some of the strongest gun laws in the country, yet a significant share of those crime guns are still, coming from in-state dealers. As Kelly just said, in 2024, roughly 48% of crime guns recovered in Maryland were originally sold by Maryland dealers. Maryland dealers also supply a substantial number of guns recovered in Washington, D.C., where Maryland was the second leading source state last year. Time to crime data tells a similar story. This measure, the time between a firearms retail sale and its recovery by law enforcement, is widely used to identify trafficking risks. Firearms recovered within 3 years of sale are considered especially concerning. Since 2020, Maryland has seen increases in these low time to crime guns, and in 2024, Maryland exceeded the national average for the first time in years. At the same time, federal oversight capacity has been strained by reductions in ATF funding and staffing. That makes it even more important that Maryland strengthen oversight within our own system. HB 741 is a practical prevention-focused step. It ensures that dealers and all employees involved in firearm sales are trained to understand U.S. and Maryland law, recognize straw purchasing, identify buyers who may pose a danger to themselves or others, and follow clear compliance practices. This is not about punishing responsible dealers. It's about equipping them with the tools to prevent illegal sales, protect their business, and help keep firearms out of dangerous hands. We regulate professional industries where public safety is at stake, and firearm retail should be no different.
Good evening, Chair Bartlett, Vice Chair Davis, and esteemed members of the House Judiciary Committee. My name is Layla Greeton. I'm a high school student at Archbishop Spalding and the founder of Team Enough Baltimore, a youth-led initiative under the Brady campaign. I'm here to voice my support for House Bill 741. And as president of Team Enough Baltimore, I lead nearly 50 students across Maryland and multiple school chapters with a shared passion and commitment to gun violence prevention. Firearm dealers are on the front line, and they are the only barrier in place that can prevent someone who should not have access to a gun from accessing one. Even the National Shooting Sports Foundation agrees, as they highlighted a story about a firearm retailer in Missouri who denied the sale of a firearm to someone who was clearly exhibiting signs of a potential criminal purchase. By noticing the odd behavior and questions the individual was asking, this retailer prevented the sale of a firearm to an individual with a history of violence against Americans. Educated employees will be able to respond to red flags indicating a possible straw purchase. For example, someone unwilling to undergo a background check, is unfamiliar with the firearm they are purchasing, or is communicating with a third party on the phone during the purchase. And according to the ATF, traffic guns are used in twice as many shootings as guns that are not trafficked, meaning identifying straw purchasers is a prime way to actually prevent violence and save lives. Training will lower dealer liability, ensuring they have a comprehensive understanding of federal and state law, as well as ATF updated policies. The importance of a standardized training program is accepted not just by stakeholders and advocates, but by gun dealers, the NSSF, the Firearm Industry Trade Association, and ORCID, a compliance firm known for consulting the NSSF, all of which have advocated for and educated dealers about training. The truth is, Maryland is in need of common sense gun legislation, and I cannot think of a more perfect fit. Let us take a supply-side approach and prevent tragedy before it happens. Firearms should only be accessible to legal and responsible gun owners, not those with the capability or intent to harm. I strongly urge a favorable report on House Bill 741.
Good afternoon, Chair Bartlett, Vice Chair Davis, and esteemed members of the House Judiciary Committee. My name is Nayla Jimenez. I'm a high school student and a member of Team Enough Baltimore, and I'm here today to share my story in support for House Bill 741. When I was 15 years old, my father was an alcoholic. He was both verbally and physically violent and expressed suicidal ideation. As his disorder progressed, my father would wake up in the middle of the day screaming at me and my mother, asking why we were breaking into his house, often not recognizing us. He was convinced someone wanted to kill him, so he would wake up and randomly leave the house to hide. There was never anyone who wanted to hurt him, and these outbursts were a result of childhood PTSD. One morning when we were driving and while he was drunk, he pulled over and showed me the recently purchased firearm. I want to make one thing clear. From when his disorder seriously begun until he sought out rehabilitation, I did not see my father sober once, not for an hour, not even for a minute. He was always under the influence. That means I can guarantee without a doubt he was under the influence of alcohol when he purchased the firearm. My father was physically abusive towards me and my mother while he suffered from alcoholism. The presence of a firearm only escalated this and put fear in me and my mother's lives. My father was erratic, delusional, and the furthest from responsible. I feared that in one of his episodes, he would go as far as to use the firearm to commit suicide. That gun should have never made it into our home, period. Educated and trained employees can notice individuals exhibiting warning signs, including those of my father in crisis, under the influence. This bill will keep children like me safe. Therefore, I strongly urge a favorable support of House Bill 741. Thank you.
Thank you for your testimony, Ms. Jimenez, and thanks for sharing your story. I'm going to go to Erin Earp next, please.
Good evening, Madam Chair, members of the committee. My name is Erin Earp. I'm a senior policy attorney for the Giffords Law Center, here to testify in support of HB 741, which will ensure that firearm dealers and their employees are properly trained to prevent firearms from ending up in the hands of those who may cause harm. Under Maryland's industry accountability law, dealers are required to implement reasonable controls to prevent sales to straw purchasers, firearm traffickers, prohibited people, and others. They're also required to take steps to prevent loss and theft of firearms and ensure that they comply with all state and federal laws. This bill creates a pathway for dealers to ensure they comply with these requirements by taking the approved training, which covers these topics, and by having their employees take the same training. This training is accessible, it may be taken online, and individuals can retake the exam until they receive the 70% score required to pass. The legal requirements are already in effect. It's critical to ensure that every dealer and employee understands what their legal obligations are when it comes to firearm handling and sales. This will not only prevent harm to the community, but prevent repercussions to dealers for failing to comply with legal standards. And I urge a favorable report. Thank you.
Thank you. Mr. Bartlett, with the great last name.
Fantastic last name. Good afternoon. My name is Ethan Bartlett, and I am an assistant policy advisor for the Johns Hopkins Center for Gun Violence Solutions. I'm here today in my individual capacity, and the views expressed here are my own and do not necessarily reflect the policies or positions of Johns Hopkins University. Research shows that FFLs breaking the law are major channels of trafficked and illegally purchased firearms, which are among the most common methods of diverting firearms for use in crime. Some of these cases involve thousands of trafficked firearms by the same FFL. Maryland currently holds gun dealers criminally liable for selling a handgun to someone they know or should know is buying a gun on behalf of someone else, often a prohibited purchaser, in what is known as a straw purchase. We can all agree that this is a common sense measure. However, we do not position licensed dealers and their employees well to identify these straw purchasers. Neither federal nor Maryland law currently requires firearm dealer employees to undergo training to spot illegal sales. Maryland should require gun dealer employees to be trained in how to spot and stop illegal gun sales. Several states have enacted laws requiring gun dealers and their employees to undergo training to identify and prevent illegal sales like straw purchases. And states with their own strong regulations and oversight of FFLs have lower rates of firearms being diverted for criminal use than states lacking those regulations. The training requirements in HB 741 will equip licensed dealers and their employees with the skills to more effectively prevent access to lethal means by those who are prohibited from owning them. This past Saturday, I attended a memorial service for a friend who was shot and killed in Linthicum last month. His death serves as a reminder that life is precious and should be protected. I simply request that we explore all options with the potential to save the lives of those we hold dear. I urge for a favorable report of HB 741, and thank you for your time.
Thank you. Thank you for sharing your story, and I'm sorry for your loss. Is this Mr. Lindsay in here now? I can't see your names.
It is.
Yes, I'm here.
Mr. Lindley, I'm sorry. Thank you.
Thank you. Good evening, Chair, Vice Chair, and committee members. Thank you for the opportunity to testify this evening. My name is Steve Lindley. I'm a law enforcement professional with over 28 years of experience, including more than 8 years as the chief of the California Department of Justice Bureau of Firearms, where I oversaw statewide firearm regulatory programs and enforcement. I currently serve as a senior advisor to the Brady Campaign to Prevent Gun Violence, and I have testified across the country on firearm policy. I'm also a high school teacher. During my career, I was responsible for ensuring the firearm laws were not only well designed, but also effectively implemented. One consistent lesson learned, whether at the local, state, or federal level, is that strong and effective laws require trained, knowledgeable people to enforce them. This bill addresses a critical gap in requiring licensed firearm dealers and their employees to complete training and pass a written examination on core responsibilities, including firearm laws, safe handling, theft prevention, and identifying illegal activities such as straw purchasers and firearm trafficking. As a former law enforcement officer and current educator, this is simply common sense. The action or inactions of dealers can either prevent or contribute to the diversion of firearms into the illegal market. When dealers are properly trained, they can identify suspicious transactions, prevent illegal sales, and alert law enforcement before a crisis occurs. This legislation reflects best practices implemented in other states where training, compliance, and accountability are essential to effective regulation of the firearm industry. And as the NRA representative affirmed earlier, safety training is important for firearm ownership. This includes training for those who sell firearms. For Maryland, implementing House Bill 741 is cheap, effective, and common sense, especially when compared to the cost of firearm violence. An ounce of prevention is truly worth a pound of cure. Thank you for the opportunity to speak today, and I ask for your favorable report.
Thank you very much. And members, do we have any questions? Delegate Erica.
Thank you, Madam Chair. Hello, my friend from beautiful Prince George's.
Hello, my friend.
Okay, so one of your testifiers had mentioned dangerous sales. I'm wondering what the definition of dangerous sales is and how many we have in the state. I believe it was somebody from Brady, maybe?
Yeah.
I don't think that's how I framed it.
Yeah, I don't know if I use those terms, but in terms of your question of dangerous sales, I think any that are unlawful or unreasonable under the circumstances, which is already part of Maryland law.
Yeah.
And what that looks like in practice, and I should say by way of background, at Brady now I spend a lot of my time working on legislation. When I started at Brady, I was working on litigation. And so we saw cases and circumstances where an individual come in, like Nayla mentioned, under the influence, for example.
Right.
Slurring, or even saying things like, I need a gun to kill someone. And the firearms dealer would still go forward with that sale. And it's important to know that under federal law, FFLs have the right to deny any sale. So what the training would do would really just equip them and their employees to comply with what Maryland law requires and what federal law allows them to do, which is to say, this is a dangerous sale and I'm not going to complete it right now.
Right, yeah, because that was going to be my next question, because the ATF when they're doing their, not really audit, when their very initial interview to give somebody an FFL, they must know how to fill out the 4473 form. And in that, you have to know a couple things: how to properly complete the form, how to identify straw purchase indications, how to match ID information properly, delays, denials, no responses, how to properly correct things. You can't use whiteout, and all the retention requirements. So the ATF actually teaches all these things, and this is a requirement today already for all of these folks. So were you guys aware of that?
Yes.
Yeah, I'm sorry. On the bill, this bill deals with the employee and the FFL.
Okay.
So, what we're saying is not only should the dealer be trained and trained more frequently, or retrained or reminded of his or her training, but also the employee that actually makes the sale should be trained as well.
So as you probably know, if an FFL permitted a deviation from these requirements, their FFL is on the line. So they are extremely motivated to make sure that their employees are not violating this process that the ATF has set up, because they will, as somebody who has friends who have had FFLs, some of them have gotten rid of it because it is such a pain. It is, the audits are a pain. They are so detailed. You have to have every I dotted and T crossed, or they will take your FFL from you. I mean, it is extremely stringent. We actually have somebody, former Delegate Siv Saab. You want to stand up for a second? He's in the back. He just happened to be here. He used to also be an FFL. Hi, sir. Good to see you. Welcome to the Judiciary.
So we have those safeguards, Delegate.
We do.
But yet still 48% of guns involved in crime in Maryland were sold in Maryland. So even though there are those safeguards in place, the FFLs are concerned about making sure their employees know what to do, we still have this high incidence of those guns being involved in crime.
Yeah.
And then in New York, where they have implemented this type of training policy, it seems as though their numbers are going down. Less and less guns that were sold in New York are now involved in crime. So we're just hoping
There's a potential.
to meet something.
I can see there's a potential for a causal there, although I don't know if that's a proof of causality. And I would, of course, ask, even if they were sold in the state of Maryland, the question would be, were they sold to someone who was a prohibited person? Were they sold in violation? Was it an unlawful sale? Or was it a transfer later that was unlawful? We have to pinpoint where the law was actually broken to know if this type of policy is going to remedy what we're seeing in the state of Maryland. The other thing I'll just toss to you is that MSP did come out saying that the deadline was impossible to meet and that the cost would be $800,000 at a minimum to attempt to do that. Do you have any amendments that you're looking at to try and address some of those issues?
It's not my amendment, but Senator Smith has an amendment that right now the state police are in charge of proctoring and creating the exam, and a possible workaround to that is hiring somebody, a third party, that might already have this exam and can be also offered online potentially.
Okay.
So
is that what New York does? Is theirs online?
I am not sure if that's required.
New York's is, I'm not sure if New York's is online or not, actually.
Okay.
Off the top of my head, but I can get back to you.
Yeah, but regardless, if we're using a third party, if the state highway is not involved in actual creation, all that manpower that's needed to do that, and manpower to proctor a written exam, all of that, then I think we should suspect that the fiscal note would come down. And we're in talks with the state police. I mean, this is an ongoing, we're still working on this legislation.
Yeah, so my last question would be, in the state of New York, do we know how many gun shops have closed since the passage of this bill? And could that be contributing to the lower amount of purchases in state? So people would be forced to drive out of state to get their firearms. That's certainly an avenue to look at, to check to see if there's a causal link between the bill and the actual outcomes you're seeing. Thank you, Madam Chair.
Thank you. Delegate Conway?
Thank you, Chair. Thank you, Delegate, for bringing the bill and panel. To the witness on the far end, a straw purchase could be an indicator that something at the gun store believes that you're doing a straw purchase, then they could deny the sale based on that?
Correct, yes.
And if you said something like, I'm buying this for my significant other who happens to be a female and small hands, and therefore I need this type of weapon, would that indicate a straw purchase?
Correct, yes.
And they live with me and I'm gonna leave it in the drawer over there. Does that indicate a straw purchase?
Yes. I believe a straw purchase is purchasing a gun for someone else, not the individual actually having that transaction. So anyone, if a parent wants to purchase one for their child, a grandparent wants to purchase one for their grandchild, all of those are legally defined as a straw purchase.
Okay. And it was made that also you could be denied for buying or trying to buy a gun that you're unfamiliar with at the purchase.
No, that is not what I said. I can clarify that. That is proven as a sign of a potential straw purchase. Because if someone is going in and they're not familiar with the firearm and asking certain questions, and this is just given by the ATF as questions that they have been found, they have statistically by data found that these questions lead to a potential straw purchase. And I can say those again, those are someone unwilling to undergo a background check, unfamiliar with the firearm they are purchasing, or communicating with a third party on the phone.
Isn't that the second one that I said, unfamiliar with the firearm that you're purchasing?
Yes.
Isn't that what I said? Yeah, yes.
Yes.
So if I was going to the store and say, I want one of those lightning rod guns like Dirty Harry had, and they said, well, what does it look like? It looks like this, and I don't know, but he was like, make my day. Of course, I don't know what the gun does. I don't know how it works. I need to read the instructions. But would that be a reason to deny me from purchasing that weapon if I'm otherwise qualified?
I believe that would be in the individual's discretion, but
okay.
I'm not, it's not, I didn't come up with these questions. These are statistically based on evidence that these types of behaviors and these types of actions lead to straw purchasers. So that's something that you would have to look at the ATF when they publish this data, how they came across it. This is straight off the ATF's website.
Okay, I understand that. Thank you so very much.
Thank you.
Very good. Delegate Valentine.
Thank you, Madam Chair, and thank you, Delegate, and thank you, panel, for being here this evening. First, two statements. I believe some of this, if some of this is already covered in the senator's amendments that might be forthcoming, I apologize. Second point, I was going to have several questions about how the bill goes between electronic and written, but I think you touched on that in your initial about how that would be cleaned up, because it kind of goes, I think I read in here, internet-based and then written-based, and I'm assuming that that would be something that you would work out.
That's for sure.
So that leads into my questions. The one on page 3 of the bill, where it talks about state and federal firearm or licensing laws regulating transfer of firearms and ammunition. So ammunition, and that was touched on in one of the previous bills, that doesn't necessarily have to be sold by an FFL dealer. It could be sold in other capacities. So would we need to train them on selling of ammunition when other areas may not have to have an FFL?
So you were right to say that some of your questions are going to be part of the amendments.
That's one.
Yeah, so for sure, the issue of ammunition came up.
Would be resolved?
Yeah, during the Senate hearing.
Second question. and this might have to do with long guns, maybe not necessarily handguns. When it talks about in number 3, teaching customers firearm safety, including safe storage, handling of firearms, et cetera. I know when, like if I purchase a firearm, having been prior law enforcement, I think I've already been trained on that. I wouldn't ask an FFL dealer to do that. Does HQL and that requirement, are those things that are already taught to individuals before they even buy a firearm?
Delegate, we have laws already on safe storage.
So, okay.
Yeah.
Next question. Under number 4, recognizing and reporting law enforcement signs of, and the number 1 or A is straw purchases. We've all talked about straw purchases, and this is a data-driven committee, and really we talk about statistics. I would be very interested to know, like say for the last year in which statistics have been reported, how many straw purchases were charged in this state, say 23, 24, whenever we would have statistics to kind of get a gauge of how big of a problem we're trying to solve with straw purchases. And I would leave that to anyone online or who might be able to provide me with that number.
Anybody have that info?
We can try
We
looking
can get it for you.
Okay, thank you. If I may, Madam Chair, 1 or 2. And my last question kind of pertains again to number 4, where the recognizing and reporting, and we talk about straw purchases, firearm trafficking, fraudulent, all things I know we want to minimize. But my concern is, and this falls into a bill we had last week that was also through firearms. E, any other subject that the Secretary determines as appropriate. That's very wide and very open-ended. Like, how many more subjects are we going to talk about? Can you maybe limit that or give me an idea of what else we might be talking about?
Where are you seeing that?
I see that on number 4 of the bill, page 4, and it starts on on page 3, where we're teaching them to recognize and report to law enforcement signs of, and we talked about the straw purchases, firearms trafficking, fraudulent activity, signs that an individual makes, exhibit, and D, and then E of that section is any other subject. That seems to me very broad. What are we trying to capture now? We in a similar bill last week, we kind of defined what we were looking for. I'm trying to see how we could address that letter designation. The any other subject, kind of open-ended.
That's very interesting. My version doesn't have what you're looking at, honestly.
I have the Senate version here, and it does. So
the Senate version does and mine doesn't, so I can't really answer that.
All right.
But
My apologies, I may have another copy, so
Sure.
maybe that was already struck. My
Yeah,
apologies.
and if we could go back to your previous question, I see that Steve had his hand raised. Were you intending to answer that question? Mr.
I was
Lindley?
going to talk briefly about the straw purchases. And one of the things that we're trying to accomplish with this is to help the FFLs and their employees understand what a straw purchase is and some of the signs of that. So oftentimes what happens during the firearm purchase is the dealer or their employees will actually identify that a straw purchase may be occurring. So that sale actually never goes forward. It's reported to law enforcement, or there's some type of diversion that goes on. So the law in and of itself was protected by it never actually occurring because the dealer is knowledgeable, their employees are knowledgeable about the laws, about the signs of a straw purchase, and prevents that from even going forward. So a lot of it isn't so much the after action, is just educating them and making them aware of the issues so they can prevent things from happening in the first place.
So are you saying that these dealers, many of them already are aware of this and they're already preventing these straw purchases? Or you're not saying that?
No, I'm saying that there are some that do, but when you bring in new employees, they need to be trained. I teach high school students, constantly teach them. There's lots of things that we have to go over multiple times. Educating employee workforce in a lot of different industries is the best way to prevent things bad from happening. This is just making sure they understand those signs. And when it comes to signs of different types of straw purchases going forward, we make sure that the FFLs and their employees understand that through education. It's cheap and effective.
Thank you for that information. I would appreciate the documentation on how many straw purchases were charged in the most recent year. The data would be available if you can obtain that. Thank you. Thank you, Madam Chair.
Thank you.
Thank you. Mr. Conaway, Delegate Conaway.
Chair, thank you, panel and delegate for coming in with this bill. To the last witness that testified, in reference to the straw purchase, when I gave an example earlier, let's say I was buying one for my significant other, I'm going to get denied. They tell me here on the board and all of this. But would law enforcement be alerted that I came in to try to purchase this this gun for a significant other?
So if I hear you correctly, you're saying that I'm purchasing this gun, this firearm.
Yeah, I'm purchasing this gun for, I don't have a wife, so I'm saying for my significant other, my girlfriend, my babe, and all of this. So she lives with me, so it's going to be on that side of the room in case I'm downstairs or upstairs or something like that.
So that
that's what I said, 'cause it's
transaction
not
should
my
not
gun.
go through because you were admitting to the dealer that you
Sure.
are not the person who's going to be owning the firearm. That
Sure,
background check needs to be.
or they have access to it also, but go ahead.
That would be a different issue. But when it comes to the point of a sale, the person who's purchasing the firearm has to have that background check. If you say I'm purchasing it for my significant other, that person needs to go through the background check, because a lot of people will purchase a firearm for somebody else because that other person cannot pass a background check.
Sure, a lot of times people will, and I acknowledge that. But my question was, if I purchase it, which I know, or try to purchase it, which I know now is a straw purchase, will law enforcement be alerted?
Again, that would be an individual situation for every FFL, but they should make a call to local law enforcement and say, I had a customer come in trying to purchase a firearm for somebody else. Those are part of the straw purchase investigations.
Okay, thank you so very much.
Thank you. Members, Delegate McComas?
I'm not sure this was covered, but my concern is on page 3, D of you have straw purchase, firearm trafficking, and then you have fraudulent. What I'm concerned about is D, an individual who intends to use a firearm for unlawful purpose or self-harm. They're not going to go in and say, hey, I want to blow my committee chair, or I want to blow somebody else up, okay? And they're not going to say, well, gee, I'm really depressed and I want to kill myself. I mean, and my concern about this is that, you're not going to really know unless you're a psychologist or a psychiatrist, or you're a real good observer or a social worker and an observer of mental health. So I think this is just basically potentially, and I would like your thought on it, we're kind of legislating liability for FFLs and their employees because nobody's a mind reader. At least I'm not sure that we have any mind readers in this legislature, but we might. So I'd like you to comment.
I'm getting close to that. Getting real close. Hence we need training, right? And inherent in whatever training vehicle ends up being selected, there should be experts on the subject, mental health experts that would help create the questions, create the training to help you identify. Now, I was gonna say.
How are you gonna implement that? The guy's gonna come in, or the woman, gonna say, hey, I want to buy a gun. So are you gonna then say, well, have you been depressed? Are you on antidepressants? Are you suicidal? Are you eating okay? Are you sleeping okay? I mean, come on, that dog isn't gonna hunt, right?
I really appreciate these questions because before I started doing this work, I had the same thought. And then I've spent time in depositions and in these cases in the paperwork, and you'd be surprised. And what it looks like is you don't have to go in and say, are you on an antidepressant? But when we speak to gun dealers and their employees, a lot of times they'll tell us that gun sales are actually it's a social interaction. And a lot of times people will come in and they'll say, I'm looking for a gun so I can hunt or those sorts of things. And we've seen cases where people will come in and they will say, I'm looking for a firearm, I'm depressed. Like sometimes people will just come out and say it. So those are situations where training employees to, number one, be able to tell, like you can tell the difference if someone's asking and they're saying like, oh, I'm really interested in these features because I'm gonna go to the range or I'm gonna hunt with my buddies versus I don't care, anything will do. Those are the sorts of signs that can help an employee, and it's not creating a liability because gun dealers and their employees are already required under Maryland law to not engage in business practices that are unreasonable or unlawful. What this will really do is equip them to keep up with that. And then that's a matter of fact for a court. But we're not asking them to be psychiatrists or psychologists at all. It's more just giving them the tools to recognize the differences and maybe ask more questions or inquire a little bit more.
Excuse me, Manager. But then the question becomes, okay, the person comes on and they want a gun. So how are you going to say, well, I can't sell you a gun? Do you understand what I'm saying? I don't understand how that's going to work.
That happens now.
Pardon?
It happens now. The gun dealer and the employee decides whether there's some dangerous characteristics inherent in the sale and decides to say, no, I'm not going to sell the gun.
Well, I don't know. I'm not into guns, so I can't say that they can or can't. I mean, I'm just saying, I think it puts, they're in a business. And I think that something like this is a liability issue, to put it in.
And to your point, another one of those issues, liability, that came up in the Senate hearing yesterday, and I'm sure that's something we'll be talking about. Thank you for the question.
No, Delegate Valentine?
Thank you, Madam Chair. And I just, as a point of clarification for the delegate, I got to looking at both. I had the Senate version and the House version, and you are absolutely correct. The House version does not have the statement about determining as appropriate. So I just wanted to put that on the record. Isn't that so?
That is so. Thank you for pointing it out.
All righty. Thank you, members. That looks like that concludes this panel for House Bill 741. We're going to move on to our unfavorable panel, Mr. Kasuba and Mr. Jocelyn. And whenever you are ready.
Okay. My name is Thomas Kashuba, Ellicott City Registered Democrat. I hope for an unfavorable with this bill. It imposes a unique and recurring burden on a very narrow industry that's not really imposed on other regulated professions. Yes, other professions are regulated, but not on a recurring basis. This isn't a one-time competency requirement. It is annual testing. Now, do liquor licenses have annual reexamination? Are we talking about bartenders serving underage customers? Are we talking about that? No, we are not. Tobacco sellers, are they required to have any training at all? Never mind annual. How about marijuana sellers? So physicians, nurses, pharmacists, yeah, they're all licensed. And yes, they do continual education to maintain their licenses. But they're not tested to maintain their practice every single year. In my written testimony, I've given you a little chart on that. This bill singles out firearms dealers. It's plain and simple as that. It raises a very serious questions about fairness, proportionality, and legislative intent. Why are they under so much scrutiny? I'm afraid that this bill just adds costs, compliancy risks, and could be a mischievous mechanism for future regulatory expansion. Thank you.
Thank you. Mr. Jocelyn?
Thank you, Madam Chair. John Jocelyn speaking for 2A Maryland in opposition to House Bill 741. Under the terms of the bill, the Secretary must approve at least one course. However, the bill is silent on who creates that course. The bill is also silent on who will create the internet training component, the testing component, and how it will be administered, and how they will do the testing. The bill requires that customers receive firearm safety training in safety, storage, and handling of firearms. This creates a professional instructor-student relationship within the dealership. Now, current law in Maryland, to be an instructor to teach state-mandated training, the HQL and the carry permit course, you have to have training credentials acceptable to the Maryland State Police. You have to have the Maryland State Police qualified handgun instructor license. The bill is silent on this. The bill is silent on what the credentials of the employee might have if they don't have to have the aforementioned credentials. It also means that we are now looking at a teaching environment where the people doing the teaching will be required to carry instructor insurance, because it's a very specialized type of insurance that is not germane to most retail establishments. Most stores do not have the facilities to do training. One-on-one training is impractical and expensive. And there's no provision to exempt customers who've already come in and done the training and now want to purchase another firearm. We're now looking at a recycling. The bill will cost, I think, somewhere close to $1 million to implement. I don't believe that the return on the investment is worth it, since the ATF training does everything but the mandated customer training. We ask for an unfavorable report.
Thank you very much. I have one question from Mr. Kasuba.
Yes.
Do you know, and I don't know the answer to this, just to let you know, it's a trick question. Do you know how many alcohol bills that come through our doors to regulate, and a lot of them have training requirements? And you can just say no, because I don't know either.
I do not know, but have they passed?
I'm sorry?
Have they passed?
Oh, yes. Oh, no, we have something called Alcohol Day. That's because we have so many alcohol bills. And not all of them, truthfully, not all of them have a training requirement component to them, but our speaker, a few speakers ago, was adamant about a training component that was from Anne Arundel County. Whenever we put in a bill, he wanted us to make sure that we had a training component. Just FYI.
Thank you.
Okay, thank you very much. I'm going to go to Delegate Taylor, and then I'll go to Delegate Eric.
Thank you, Madam Chair. And in fact, for certain industries, there are training requirements. For alcohol, it's 4 years, every 4 years to maintain your license. For cannabis, it's 2 years.
But for employees?
For the owners, yeah. For firearms, FFLs, what we're proposing in the original bill was annual. During the Senate hearing, as you probably know, biannual is what we might be looking at now. So, yeah, we're taking it. So you're not wrong. We're going to take that into account. The timing on the training. Thank you for bringing it up.
Okay, thank you. Delegate Ericon.
Thank you, Madam Chair. Thank you guys for being here. Mr. Jocelyn, can you just tell me what happens if, regarding background checks, if somebody refuses a background check, what happens?
If the applicant refuses the check, the sale is terminated immediately.
Okay.
If it's a handgun, you have to first create an account with the Maryland State Police.
Oh, that's right, yep.
You have to list your HQL number and submit all your information. And then once you get the okay from the state police that they've done the background check, they then contact you via email and tell you that the sale can proceed as of a given date. At that point, you have a number from the state police, you visit the dealer, you give them the number, you show them your HQL paperwork, and then they will transfer the firearm. For a 4473 for a long gun, that's done in the store, it's done on paper copy, and that's called in immediately, and it takes 5 minutes or so to get a background. But if the person refuses to fill out the 4473, it's goodbye to the person.
Okay, yeah, it's been a couple years since I bought a new gun. Can you talk to me, do you have any data around the concern around straw purchases? I know that my friend from Baltimore City mentioned potentially purchasing a firearm for a girlfriend, which I think we both know is not permissible under Maryland's transfer laws. But is there any other data available about straw purchases that we have in Maryland?
This is a really interesting thing because years ago when we passed the straw purchase law, the rationale was, yeah, it's a federal law, but we need another tool in our toolbox. The problem is we rarely use it. I was at a gun show in Howard County some years ago, and there was a couple there, and it was pretty clear to the dealer that the wife was attempting to buy the shotgun for her husband. And in his viewing what was going on, what she was saying, what he was saying, he believed it to be a straw purchase. He declined the sale. He then got up on his chair when they went to the next dealer and pointed to the couple and said, straw purchasers. And it went right around the entire pavilion who they were so that everybody was flagged that they felt that this was a straw purchaser. The show promoter called the Howard County Police and reported it. They declined to send an officer. So usually things like this, if the dealer says no, there's no report done. So there's no really data to say beyond when you actually get a prosecution, but they're pretty rare.
Okay, yeah, that's what I had heard. I just couldn't remember if there was any hard facts on it, but yeah. I thought they were just not actually charging these crimes, so I appreciate it. Thank you.
Thank you. Delegate Mangio.
Thank you, Madam Speaker. Thank you, gentlemen, for staying so late. My question, and maybe it was better for the first panel, I'll just hear your expert thoughts, is the testimony from some of them originally talked about, I wrote them down here, keep guns out of the hands, or keep guns out of dangerous hands, prevent someone from access to a gun who shouldn't have access. Guns should only be accessible to legal and responsible gun owners. I think we all agree. Part of this bill specifically, I think, says preventing and reporting theft. So my question, if the purpose of this bill, and of course the goal of this body, is to keep firearms out of the wrong hands with bills like this, would you say it's inconsistent to have a bill like this without having a bill like we heard earlier that makes stealing a gun a felony at any value? Is that inconsistent, you think?
I believe it is. You can't on one hand say that we have to do all these things to keep things out of the wrong hands and then turn around and say, well, if you steal a firearm, then it's only a misdemeanor because it's a property crime. Yes, I believe that there is a disconnect there.
Thank you.
Thank you. Delegate Taylor, do you want a second bite?
Yes. Thank you. And I just kind of want to level set. It's not as hard as you guys are making it, right? This is under the Public Safety Article 5-110. The secretary shall disapprove an application for a dealer's license if they don't pass an exam. That's what we're talking about. We're just talking about training here. And then we go on under 5-145.2, just to describe what might be included in the exam, what type of training is necessary. Not the data and the details of it, but just what the training might consist of. So, you know, just kind of want us to keep on track as to what the bill intends to do and not make it so complex.
I understand, Delegate, but unfortunately, you're simplifying a very, very convoluted issue. The training could be for handgun, it could be for rifle, it could be for shotgun. Each one of the courses that I'm certified to teach has its own handbook that goes with it. And under the terms of this particular legislation, it requires the secretary to approve a course, but it doesn't say who's going to create that course or to what depth one is going to go and how long is the customer going to be standing in the shop to get all this training that's listed, because there's no checks and balances to say, okay, when is enough?
Again, I think you're going too far, but have you ever created training based upon all of your experience?
Yes, ma'am. As a matter of fact, the Maryland Wear and Carry Permit course, the statute states that the secretary may approve another course. So because I am who I am and the way I am, I submitted my interpretation of the state police course in October of 2022. I received approval on it in December of 2024. To the best of my knowledge and belief, mine is the only alternate course that's ever been reviewed and approved by the Maryland State Police.
Thank you. With your experience, then maybe we can work with you in helping to create this course.
Well, I will say, I did have a note and I was just gonna ask if we approved your course, because I knew you had a course, would you come in as a favorable? But I thought, no, I'll leave that alone. But you went there when you said that yours was the only one that had been approved, as far as your knowledge.
That's correct.
Is that correct?
That's correct.
Okay, well, thank you. I'm not gonna ask that question because.
But, Chairman, it was specific to the wear and carry course.
So let me ask you a question. If it says that the, where is it? If it said, when it states that there has to be a course, that there will, I'm trying to find it where it is. I guess my question is, and it's in the lines of where Delegate Taylor was going, we don't have to, we're giving some discretion to the secretary. And that's okay. That's all right to give some discretion to the secretary as to how they're going to go about finding the course and finding the training and all of that. We don't have to direct them as to the course and to the training. Don't you agree with that?
Actually, I would disagree respectfully. The language says that the secretary shall approve at least one course. There's no directive that the secretary has to seek a course. So there's a disconnect there.
Okay, I don't agree with you because I think in order to prove it, you have to find it. But I see where you're going with that. But I mean, that's a step that is inevitable. In order to prove something, you have to at least have it in front of you.
But if you never have it in front of you, how do you approve it?
Well, that's my point.
We're in the circular argument. We're having a good day.
Let's play this game all night. No, let's not. Okay, members, I'm not going to keep you all here much longer. Mr. Jocelyn and Mr. Casaba, thank you so much for your testimony. Members, do we have any other questions? All right, seeing none, thank you again. Okay, we're going to move on. Oh, actually, members, I apologize. I inadvertently, on Delegate Phillips' bill, on House Bill 738, I inadvertently failed to call a witness. You all are fine. I inadvertently failed to call a witness. And actually, she's the witness from the coalition that I referenced. Ms. Karen Sonu or either Ms. Kamita Gray, and I think it's Ms. Kamita Gray who is online. I'd like to give her oh man, we took two, so she was there. She was there, she was waiting on us. If she comes back, please let me know. Okay, perfect, thank you. And Ms. Gray, if you're listening, I did not mean to overlook you on the sign-up list. Okay, Delegate Embry, let's go with your bill. House Bill 1339. We're almost there. We have this bill and one other bill, and we will be finished for the night. So I see Karen Herron coming up, and yep, you're all coming up. You know what, let's pull up the virtual panel. Do we have Aaron Earp, Steve Lindley from before, and Kelly Roshcom?
I think
we might have lost one or two.
I think we lost Kelly to childcare.
No worries. Okay, so let's go with who we have. Delegate Embry, you may begin, please.
Thank you, Madam Chair, Madam Vice Chair, everyone. So I'm going to start with a little background on what is the handgun roster, why we created it, and then why we think we need to reform it. So it was created in 1988 as a consumer protection entity because of Saturday night specials. So there were this cheap handguns all over the place in this country, and they were malfunctioning and they were poorly made. And so it was viewed as helpful to have a body assess the safety of these firearms. So that's why it's a handgun roster board. It was responding to that issue. And then over time, as questions have arisen about what should be, what type of handgun should be legal in Maryland, the sort of legal analysis piece of the board has increased, and sort of the review of what is a handgun. So those are the functions of the board. The problems are lack of clarity in terms of how the board should make those decisions. The fact that the board, it's a citizen board, so they may or may not be authorities on these areas. And then the final problem is the testing, which is authorized and the state police oversees. There's very little to make sure that the testing is consistent with industry standards. You can also, if your gun fails the first time, you can refile over and over. There's no limit. So those are some of the problems that we're seeking to address. And I want to stress that this bill is complicated, and so there are substantial amendments coming to you. So please give me some patience in getting them. We're working very hard to accommodate lots of different feedback, including the Attorney General's office, to make sure that the bill is doing what we want it to do. And we'll also be working with Maryland State Police. But again, what the bill is trying, I've described what the problems are. What the bill's primary goals are: one, to have legal review in the hands of the Attorney General's office. So the board would not be responsible for legal review. That would be federal and state law. Two, a structure that would allow for better testing, would allow MSP to outsource some of that to vendors that are expert in this, because it will be probably a more substantial burden. And also providing some framework so that the person petitioning to be on the board pays for the cost of the training. Right now, there's no fee. And also setting up some parameters for how often a handgun can be submitted if it repeatedly fails testing. And then the final piece is currently the board has no authority to look backwards. So if they've approved a gun, it's on there forever. And reasons that we might want them to look backwards are primarily safety issues that arise, but also if there's changes in the law, we want to be able to respond to that. So those are the three areas. And again, we're working on amendments, and look forward to your questions after our experts talk. Thank you.
Good evening, Karen Herron, Executive Director of Marylanders to Prevent Gun Violence, in support of HB 1339 to modernize Maryland's handgun roster process. More than 35 years ago, this body created the handgun roster as a consumer protection tool in response to a market flooded with cheap, unsafe firearms. The goals were simple: to create a statutory compliance checkpoint and consumer safety safeguard. But the firearm industry of 2026 is very different than it was in 1988. We now see high-capacity semi-automatic handguns, modular and polymer designs, firearm kits, and rapid-fire modifications, yet the roster process has not kept pace. For years, most firearms have been added with little or no meaningful review. Problematic and at times unlawful firearms have made it onto the roster, and once they are on, there is no clear mechanism to revisit those decisions. The result is a system that can legitimize firearms that may not actually comply with Maryland law. This bill would fix that. It assigns legal review to the Attorney General, the state's chief legal authority, to determine first whether the firearm is lawful under all state and federal law. It establishes real product safety testing standards. It creates a pathway to reassess firearms already on the roster if new information emerges. And finally, it clarifies that the board's role would become procedural oversight and public accountability. Importantly, what this bill does not do is it does not expand the roster, and it does not change Maryland's underlying prohibitions. It simply ensures that our existing laws function as they are intended. So we respectfully urge a favorable report.
Good evening, Madam Chair, Madam Vice Chair, and members. Again, my name is Layla Gretton. I'm the president of Team Enough Baltimore and a high school student at Archbishop Spalding. House Bill 1339 will improve oversight and safety regarding the handgun roster board in Maryland. Currently, there is no process to reevaluate approved guns and no meaningful safety testing to ensure that the firearms that are approved are actually safe. Additionally, a misapplication of Maryland law results in multiple firearms being approved that meet the definition of assault weapon or otherwise not a handgun. Marylanders deserve to know that the firearms they are sold, if called a handgun, actually are a handgun. Unsafe or non-compliant guns should not enter Maryland communities, and this bill protects both consumer safety and public safety. This fix is simple and will ensure the safety of Marylanders and our broader community. Handguns have a definition according to Maryland law, and our citizens deserve to know that if they purchase a gun labeled as a handgun, what they receive matches that label. Faulty firearms and assault pistols can harm our communities if sold under the wrong pretenses, and this oversight is needed to keep our homes and children safe and ensure legal practice. I strongly urge a favorable report on House Bill 1339. Thank you.
My apologies. Delegate, I'm sorry. Ms. Earp?
Good evening again, Madam Chair, members of the committee. Again, my name is Erin Earp with Giffords Law Center. I forgot to mention before, I'm also a resident of Calvert County. But thank you for the opportunity to testify today in support of HB 1339 to reform the Handgun Roster Board. This bill makes important changes to ensure that handguns approved by the board are safe and, importantly, are handguns. Maryland's definition of handgun in the criminal code explicitly includes short-barreled rifles and shotguns, unlike the federal definition, which does not include them. While the current Handgun Roster Board statute has a separate definition in its text, that's not actually the one used in the rest of the provisions. The criminal law definition is what is used. And so in the bill, I think you'll see it in the amendment, would apply the definition that's already in the Handgun Roster Board statute, and that is the definition that excludes short-barreled rifles and shotguns from the definition of handgun. And that's critical because in recent years, petitions before the board quote, have come in great numbers to approve short-barreled rifles as handguns. Analysis by the Baltimore Sun concluded that between 2018 and 2024, 95% of handguns brought before the board were approved, including a number of short-barreled rifles. Changing the definition and adding the Attorney General's review prior to the board review will ensure that short-barreled rifles are no longer added to the roster. This bill will also ensure that the board fulfills its role in protecting consumer and public safety. In addition to the legal review, it codifies robust testing standards. Unlike other high-risk industries, there are no comprehensive federal safety or design standards for firearms, which makes this oversight all the more important. HB 1339 will protect the safety of all Marylanders, and I urge a favorable report. Thank you.
Thank you. Mr. Lindley?
Good evening, Chair, Vice Chair, committee members. Thank you for the opportunity to testify. Again, my name is Steve Lindley. I'm a former law enforcement professional with over 28 years of experience, including more than 8 years as the chief of the California Department of Justice Bureau of Firearms, where I oversaw statewide firearm regulatory programs and enforcement. I currently serve as a senior advisor for the Brady Campaign to Prevent Gun Violence, and I've testified across the country on firearm policy. I'm also a high school teacher. This bill represents a structured approach to ensuring that handguns available for sale in Maryland meet appropriate safety, legal, and functional standards. House Bill 1339 strengthens Maryland's existing handgun roster process by establishing a clean, accountable framework. It requires the Attorney General to conduct a legal review of each firearm before it is approved, and for firearms to undergo objective testing to ensure they function safely and reliably. Sometimes that's the firearms industry does not do. The bill incorporates rigorous testing standards, including live fire reliability testing and drop safety regulations to ensure that firearms do not unintentionally discharge and meet minimum performance thresholds. Again, something that the firearm industry does not do for their products. When done correctly, these systems help ensure that firearms entering the market are safe, reliable, and lawful, while providing clear guidance to manufacturers and regulators alike. Thank you for the opportunity to speak today. I ask for your favorable support, and I'm here for questions.
Thank you very much. And is Kelly Roscom online? Thank you so much. Okay, members, do we have any questions? I see questions. I'm going to start with Delegate Williams this time.
Okay. Thank you, Madam Chair, and thank you, Delegate, for bringing this really important bill. I know over the interim there was a whole article in the Baltimore Sun about a lot of the concerns with the handgun roster board. So thank you for bringing this needed piece of legislation. I was just wondering if you could elaborate a little bit more on the amendments, I just want to make sure I'm clear in my head as to what they are.
Well, the goal of the amendments is to bring it in line with what I've described. So the Attorney General has more of a role in the bill as drafted than we're proposing. And you saw in their letter, they don't want that greater role. They want to,
right.
The legal review makes sense, but not involvement in the testing. And we're maintaining the board as, the power of the board will remain with the exception again of the legal review, which we're assigning to the Attorney General. But they'd remain an oversight entity, overseeing the process, and then providing an annual report out. So yeah, so the as described, the amendments will accomplish what we've described. I think it's, please add anything that I missed.
Yeah, the only other thing I can think of is there is a piece in the amendments that we're adding in that has to do with, this is going to go down a rabbit hole, integrated safety locking devices. That's a piece of law that is not currently being implemented because firearms aren't traditionally having those in it. What we don't want is to create a situation where suddenly we're doing an accurate legal review and then nothing makes it through.
Mm-hmm.
So we're making an adjustment to that to allow those devices to be on firearms if they are, but allow an alternative as well. So there's a simple amendment there to make sure that we don't end up in a constitutional issue where that's concerned.
Got it. And with the Attorney General's involvement in terms of legal review, I guess that removes the ambiguity that the board has traditionally had with what is the legal standard of review that they should be utilizing. Is that what we're trying to accomplish with that piece there?
Exactly, two things. One, clarify the standard and then assign it to the entity that is probably best suited to do it.
Okay, all right, thank you.
Delegate Moon.
Thank you, Madam Chair. I did come across this whole bill when we were looking at gun felonies in a prior year and was recalling the Saturday night special history to this, and when all the Glock and civil suits and all this stuff came up, I was reminded of this, so I'm glad you're taking this on. I guess a lot of how I feel about this, though, hinges on how it's currently working. So since Saturday Night Specials, I guess, which was the genesis of this, I caught someone saying that 95% of the firearms are approved for sale. And so it sounds like they're actively being screened out. But the basis of being prohibited for sale in Maryland right now is not on testing. It's simply on factual features of the firearms.
Well, I went back and looked at recent minutes, and you've been following this for years, but looking at the minutes, the things that were denied were for technical reasons, not just about paperwork, not they will probably be approved in the
Okay,
future.
so that was my understanding. I thought.
That's what I saw, and that was the reporting in the Sun.
Yeah, I don't think, up until very recently, when there's been a little bit of shift in the membership and some pushback, there were no real denials. Something would occasionally get tabled because it kept misfiring or something, but they just would keep bringing it back until they could get it through.
Yeah, so the way I had read what was going on was we banned Saturday Night Specials, we created this whole elaborate system to do it, and then nothing else really has been banned since we did it. And I said, well, that's interesting. We can certainly stand up a whole new system every time we want to do something. And I'm remembering the ballistics collections we used to do, and we got rid of that sometime, I think, in my first term here. And so with those histories, I do have to ask, I mean, it seems to me there could have been a few ways to go about this. You could simply create a petition to remove for sale a firearm on a complaint-driven basis and then submit that this particular item ought to be put up for testing because we have reason to believe there's something unsafe about it. This seems to propose the opposite of that, right? Which is, let's test everything and see if it fits the standards. I don't have a policy problem with that, but it seems to me, since we're going from approving everything right now anyway, that even just getting to a complaint-driven approach would be a step forward if we could identify problem guns to flag for additional scrutiny or what have you. Have you considered a middle position like that?
It is a petition-based system even now, and it would continue to be so
Who would be filing the petition,
Oh, yeah,
delegate,
maybe
in your scenario?
Well, we could talk about that.
Or just to understand.
But yeah, if you had a reason to believe that a gun misfired regularly, I mean, I don't know if you could get into the modifiability and some of the other topics we've gotten into, but simple, like this gun misfires quite regularly.
Well, what
or
about the
safety
legal?
doesn't work, some real basic things that you could discover through testing. So right now, you're saying I can call and have that
No.
removed for sale?
It's petition-based in the sense that when someone wants to go on the roster and sell in Maryland, it's
Yeah,
petition.
I'm thinking.
You're thinking of a,
I see a suit in California, a product liability suit that's moving, and in discovery, we learned that there's all sorts of problems with a particular model of a firearm. I could now go to the handgun roster board and say, hey, look, we actually have real evidence that there's a product defect here. You guys should take a closer look at this.
so what you're saying is sort of how we're envisioning the look back. I mean, not that it's not petition-based literally, but that it would be something would come to the attention of the board and they could then re-examine. But we are operating from the board as it exists and trying to fix problems. I'm interested in what you're saying, but that is just understanding our approach was we were not re-envisioning the board.
So
So currently, every gun is tested. We're just improving the test.
That's not entirely true.
Oh, I'm sorry. Excuse me.
So currently, some firearms are tested unless they manage to make it through as a model change, which these days is a lot. So when you go back and look at the petitions, it's actually a small percentage that actually go through any testing. And the testing we're talking about, if you look at the petitions, it says something like fired 6 times. It's somewhere between 6 and 9 seem to be where it was falling. When we're looking at states like California who are doing robust product safety testing, they're firing 600 times. So, what we're doing now isn't actually product safety testing.
Okay, so this all makes sense to me, and I guess it's really, is there a standard that everybody agrees to as a manufacturer's standard for product liability or safety for what's a vendable, product, so I guess that's question one. And then the other is, if we implement this system-wide, is it going to catch the types of firearms we're hoping to catch? And so I guess you must have some reason to believe that these particular tests and standards will stop. Do we know that there are actually guns too that are likely to be caught, and there are specific ones that we might catch with these tests?
Yeah, and I think Steve would be a really good person to ask. He's been my go-to when I'm asking questions about how testing works, so if he's willing to answer that question.
Yeah, and I guess what I'm trying to get at is it seems like a whole apparatus needs to be set up to do this. And so, what's the yield of prohibited firearms we're likely to get from doing all of this versus what would we catch if we actually just had a strict complaint-driven system where we're not testing everything. We're just testing a few things that are flagged as problematic every year.
I think there's 2 things that are going to happen. One is that the legal review is going to weed out firearms that shouldn't be analyzed by a handgun roster board. And then I let Steve jump in on how the testing can help.
So California is a little bit different where we require a number of other features on the firearm, but before those features were put on there, mainly the magazine safety disconnect and the chamberlain indicator, when it was just looking at the testing of the firearm, whether it's the drop test or the 600 rounds fired, a number of firearms did not pass those standards. Went back to the manufacturer made internal changes to it for it to be able to meet those standards. So having some sort of testing requirement saying these are the bare minimums that a firearm need to obtain in order to be sold in the state is a good direction. And it also gives the manufacturers some accountability for what they're putting on the market, because there's a number of federal protections from suing the firearm industry over their products. So this is just saying, all right, if you want to sell firearms in a particular state, in this case, Maryland, we want it to meet these certain standards. And you'll start finding that there are a number of firearms that will not pass that initial testing. It might pass 6 months later, but oftentimes because the manufacturer has made changes to it to make that firearm better.
So, sorry, can I just follow up on this? So is it correct also to think that a state like California and a state like Maryland, the cost of implementation is going to be the same, right? Because it's probably the same set of products that are going to be attempted to be sold in the two states? Is there a reason for us to
I
believe
would probably say no at this point because California has those two other features that are required on a firearm. So a lot of manufacturers will make two versions of a, let's say for a Glock pistol. In California right now, well, before some current legislation, but let's say last year, only up to the Glock Generation 3 was able to be sold in California, where other parts of the country were able to sell their other versions because of those two safety requirements. Plus, even despite California's laws, it's one of the biggest sellers of firearms in the nation. So just the scalability is there. So, but, at least you can reflect upon the number of firearms that are being tested on an annual basis in California as compared to what's going to be tested in Maryland. And one of the things that this bill also allows for is kind of a third-party testing facility, which is what California uses. California doesn't actually test the firearms ourselves. We farm that out to different laboratories across the nation. So, and that's one of the things that most likely the Maryland State Police will also do because they don't do this. California didn't do this. These laboratories do, and they do it very well.
I guess so. Are you guys seeing where I'm going with this? Like, it seems like it's going to be the same test with similar results, whether California's doing it or Maryland's doing it.
Somehow.
And so I don't know, but I guess I'm just trying to find a way to size down this bill. That's all.
For what it's worth, one of those facilities is in Bell County, Maryland, I believe, that California utilizes.
I really appreciate the question.
Thank you.
Delegate Ericon, did you remember your question?
Oh, yes. I know. Hunter wishes I forgot, but I didn't. Love you, Hunter. Delegate, I'm going to be just as easy on you as I was on my good friend from Prince George's.
You don't have to be.
Oh, good. Oh, good. Then I won't. No, just kidding. Okay. So, I mean, obviously, there's a lot going on here.
Yes.
How did the Senate hearing go? Just off.
Actually, very well.
Pretty smooth.
Really? There was not a lot of questions or opportunities for tweaks that were brought up?
The amendments that we're still working on are
Okay, they were brought up
yeah,
over
yeah,
there.
yeah.
Okay, that's what I thought.
We're operating in tandem, so all the same.
Okay, and do any of those amendments address the state police's estimated $17.8 million estimates for the cost, and then $8.9 million annually?
Well, I will say, let me say one thing, and we are working on amendments. But I will say the one thing that the fiscal note refers to, but is not able to flesh out for obvious reasons, is we would be recovering some of them because some of the costs would be
Passed on to me.
Passed on to the manufacturer.
Oh, well, that means me, because I buy the products later.
Because it does cost the state money. But anyway, we don't, obviously, that would be up to the board to decide how much. But that is one factor that is not accounted for. But we are, and we'll be in conversation about that.
Okay.
Yeah, I mean, I think the fiscal note is, they're always a little unclear, like exactly where where they're getting the dollars, right? And I think they quote like $3,500 per firearm, and best we can tell, and Steve might be able to weigh in here, but best we can tell, that might be the absolute highest end, and it also might be based on if MSP were actually to acquire the equipment to do it rather than outsource it out. So
Right.
I think that number's going to actually be lower. But
Yeah, that was kind of
but there's
my
homework
question.
to do. Yeah.
Okay. And then just on the topic of the issue with the permanent list that you had mentioned, my gut tells me that reviewing guns that are already on the list you're going to run into some constitutional issues because you can't tell us, those of us who believe this list is the good list, we went and bought the guns on the good list, and then you're like, just kidding, these guns are now on a bad list and you can't have these guns. Is that what the goal of the look back is? Yeah. To move the guns from the good list potentially to the bad list?
Well, not in terms of restricting people already owning the guns, but
So
it might mean how
you
they're
would
sold in the
I didn't see a grandfather. Is there a grandfather in here?
Well, this doesn't really deal with gun owners.
Right.
It's really about what can be sold.
Okay.
So, I mean, if we feel like we needed to put a grandfather clause in there somewhere to
Yeah.
protect it, but protect gun owners in this scenario, we can talk about that.
Okay.
But really, we're talking about what can be sold going forward rather
Okay.
than making something illegal from past days.
And in California, they have a similar setup to this. Is that what okay, and what is the rate of denial do they have an application process? Some manufacturers apply. What's the denial rate in California? It says we have 95% here. What is it in California now?
Can we defer to our California expert?
Yeah, doctor?
So what's kind of odd about that is the manufacturers send the firearms to the laboratories directly. So if it fails, California actually might not know if the firearm fails. We only know when it actually passes. Now, we can talk to the laboratories about what actually did, how many times they may have tested a particular firearm, and that does come up in lawsuits. But it's sent directly from the manufacturer to the laboratory, and then California only gets a report if it passes.
Oh, interesting. Okay. And is that the style that you were anticipating having here?
I think that might help with the fiscal note.
We were not anticipating, but we're very interested.
We're working it like it's a subcommittee
This is
while we
amazing.
speak, and we're making everyone listen to the subcommittee meeting.
Your
That's okay.
questions are very helpful.
Yeah,
Thank you, Delegate.
yeah. Okay, I think that was mostly the questions that I had for you. I mean, there's a lot of stuff in here that I think there's a lot of still issues, but maybe the Senate, if you get Senate amendments, just send them my way so we can look at them. Thank you very much.
Thank you. Members, any further questions? Delegate Valentine.
I will not ask all of my questions in the interest of time. But some of it may have already been answered when you talked about the amendment dealing with the Attorney General, because one of my questions was, why are we taking out secretary and so that's already, so some of my questions, and I apologize if any of my questions might deal with that. So one question I have is the makeup of the board on page 11. I'm pretty sure I'm on the right document.
Yes, we have not submitted because the amendments are still, I'm sorry, page 11 you said?
Page 11, where we're removing the representative of the board from the NRA, and why we were then implanting someone from basically an advocacy group that by nature probably would not be firearm friendly or may not have a lot of.
Oh, sorry. I'm sorry.
May not be firearm friendly or may be not knowledgeable as some of these other groups. So I'm trying to think why the change, why are we eliminating the NRA?
So we're substituting a specific entity with a broader definition that would include the NRA. So it could be the NRA or it could be any similar group.
Any other similar group, okay. And in the interest of time, one last question. On page 17, maybe this doesn't apply because the Attorney General doesn't apply. I'm going down, midway down, section 3, subsection 2. Does that still apply? The Attorney General, Maryland State Police, consider board recommendations? That's gone?
Yeah, so they will not be involved. That will be the board's responsibility.
Okay, so that really, until I see the amendments and what's changed, I really don't have too many other questions, but I'm sure I will later.
Yeah, absolutely, and we appreciate it.
Thank you. Thank you, Madam Chair.
Certainly. Members, I see no further questions, so that concludes the favorable testimony for House Bill 1339. We're going to call up for unfavorable testimony Kathy Wright, Mr. Kasuba, Mr. Jocelyn, Mr. Pennock online, and Mr. Weber, John Weber. And whoever sits down first, you may begin.
Okay, Thomas Kashuba, Ellicott City, registered Democrat. Only 3 states have handgun rosters: Maryland, California, Massachusetts, and DC, but not a state. Roster schemes do not regulate bad conduct. They regulate product availability. So what are you doing? You are eroding consumer choice. Everybody likes choice as a consumer. I'm kind of skeptical on the whole, well, this is for you, this is a consumer protection couching of this issue. I highly doubt that the reason behind this bill is so I could get the best handgun ever possibly made, but that's just me. This whole thing creates a dynamic where a firearm access becomes contingent upon not legality or anything, but upon bureaucratic whimsy. And we kind of saw that in some of the back and forth. It's more bureaucratic whimsy. It's like, what do you feel like today? What's going to make it on the roster today? Instead of letting market forces like 50 or 47 other states do. My idea is that this just opens the door for future abuse, incremental restrictions, and puts it behind a closed door where there really isn't much input. My idea of handgun roster reform is to reform it out of existence. Thank you.
You want me to go? Okay. Thank you, Madam Chair. Again, I'm Kathy Wright, and I am a volunteer on the Board of Directors for the NRA, a grassroots advocate to protect our Second Amendment. The Maryland Handgun Roster Board is a bureaucratic blockade designed to limit law-abiding citizens their choice of firearms, whether for self-defense, competition, or sport. This is a direct assault on the core principles of the Second Amendment. The roster isn't about safety, it's a political tool, as evidenced by this bill, which strips authority from the Maryland State Police and gives authority to the Attorney General. The Second Amendment guarantees law-abiding citizens the right to acquire, possess, and carry arms that are in common use for lawful purposes. In District of Columbia versus Heller, the court held that arms in common use by law-abiding citizens may not be prohibited and has reaffirmed that rule repeatedly, explaining that the Second Amendment protects weapons that are commonly possessed for lawful purposes by law-abiding citizens and forbids governments from banning such firearms. I would suggest that we can't afford this bill. The fiscal policy note on House Bill 1339 indicates that the general fund expenditures will increase by approximately $10 million in 2027, $10.2 million the following year, and at least $1.4 million annually thereafter. And the Office of Attorney General's expenditures will also increase. But the report contemplates the potential for revenue fees to cover the administrative costs. Actual revenues that depend on the testing fee schedule ultimately adopted by the bill. And I quote, well, I won't quote.
Go ahead, finish
Oh,
that.
thank
finish
you.
that
It is just one long sentence. Thank you. The Department of Legislative Services advises that in order to generate fee revenue of that magnitude, the testing fees before a handgun can be placed on the handgun roster will need to be significant, unquote. Thank you, Madam Chair.
Thank you. Mr. Jocelyn, we haven't heard from you yet, right?
No, ma'am.
Okay. Can you just pull the mic just a little bit closer? Thank you so much.
Thank you, Madam Chair. John Jocelyn speaking on behalf of 2A Maryland in opposition to House Bill 1339. Under the terms of the bill, it establishes the Attorney General of Maryland as Maryland's handgun czar, who will have control over which firearms will be allowed for sale in Maryland. It requires the AG to base his approval on handguns for sale under certain characteristics. The characteristics are identified but not defined. It eliminates the Handgun Roster Board as a decision-making body and relegates it to mostly clerical duties. The board will have oversight, but it has no enforcement power. The bill requires that the AG can declare communications between his office and the board to be confidential. This flies in the face of transparency. The bill requires physical testing of the 5,000 existing handguns. The test types are identified, but testing parameters are not. Many existing handguns are no longer in production and test samples will not be available for testing. 500 rounds to be fired without cleaning is unrealistic and expensive. Some firearms were never intended to be fired that long without cleaning, particularly target pistols. The bill estimates the fiscal note that as I work it, the estimated cost per handgun to test is $3,500. The bill requires testing of all currently approved handguns by March 31st of 2028. That is only 17 months away. Fee schedules can be recommended by the board, but they have no regulatory authority. However, the board only meets quarterly. They have to have the fees by January 1st, and they don't have a meeting until December of this year. How they're going to work this calendar-wise is unknown to me. With all these things considered and others that I don't have time to get to, we would ask for an unfavorable report.
Thank you. Mr. Weber?
Hi, Chair, members of the committee. My name is John Weber, and I represent the National Rifle Association and our members in Maryland. The NRA is opposed to Senate Bill 830. This legislation reforms Maryland's handgun roster in a process.
Uh-oh. Mr. Weber, somehow you muted. Yeah, there you go. Thank you. Can you start again?
Yes, ma'am. Sorry. My name is John Weber, and I represent the National Rifle Association and our members in Maryland. The NRA is opposed to Senate Bill 830. This legislation reforms Maryland's handgun roster process in ways that introduce political bias, arbitrary decision-making, unnecessary bureaucracy, and added costs with no clear evidence of improved public safety. This legislation will shift core authority to the Attorney General, an elected official, for legal reviews, potentially injecting partisan politics into what should be a neutral technical process. This change will risk turning roster approvals into a tool for advancing ideological agendas, such as restricting compact or innovative handguns without enhancing safety. The new testing requirements will add significant expense, burdening law-abiding gun owners. Petitioners must also navigate additional demands, limits on resubmissions, and this will create massive hurdles for individuals who just want to follow the law while doing nothing to address actual criminal misuse of firearms. This bill creates further arbitrariness by granting the Attorney General broad discretion in weighing factors like concealability or utility for legitimate purpose without requiring weight on any one. The allowing extensions for good cause is also problematic. This could lead to inconsistent, subjective denials based on incomplete allegations or political pressures, eroding due process for petitioners who face appeals. The board's role is diminished to administrative oversight, reducing the checks and balances even further. These reforms impose real costs on state resources without any proven benefits. The Attorney General's office, MSP, and board will need to handle increased reviews, testing, online publications, confidentiality protocols, pulling staff from other duties. This will strain budgets and operations, diverting funds that could have supported actual crime prevention. This bill will only serve to limit mail owners' access to safe, reliable handguns for self-defense and sport. It will not fix a documented safety gap. It only makes the process more cumbersome and susceptible to abuse.
Thank you very much. Members, do we have any questions? Oh, Delegate Arakan has a question. Imagine that.
Oh, gosh, what a surprise. Thank you, Madam Chair. Thanks, guys, for hanging out late at night with us. It's our favorite time to spend together. So I've got a couple things. You had mentioned, Mr. Jocelyn, about the potential for guns. Okay, just talk us back through that. The potential for guns that are commonly owned but no longer in the sales circulation, and how it would be difficult for the state to get versions of some of these 5,083 guns. Can you just explain what the problem is there again, one more time?
The question would be, where would they source the firearm from?
Right.
They're going to subject it to testing.
Right.
And if you cannot get a factory production model, you're now looking at a used model, you've already compromised the test because you don't know how hard it's been used. The entire process is questionable because under the terms of the bill, the petitioner is required to provide certain information to the Attorney General, including handgun marking, serial number, manufacturer, model, and caliber, and an exemplar, which is to say the handgun itself. This creates an interesting dichotomy because under Maryland law and federal law, it is illegal to transfer a handgun to anyone who is not an FFL or a law enforcement agency. The AG is neither. So technically, you can't transfer the firearm to the AG for him to even look at it under the concealability, ballistic accuracy criteria that are undefined, because he can't have it to begin with, unless, of course, he maybe has an HQL. But if he has an HQL, then he's limited to 1 gun a month unless he has a collector's certificate. It just gets better and better.
Yeah, I like it. It's good. Well, we'll have to work on that piece. Maybe there's an amendment coming for that. Okay, so can you explain a little bit more about the testing as it's laid out in this bill and like what the issues we might run into with the actual testing process? Is there a structure here that has been replicated anywhere else that we can look to?
Under the terms of the bill, it lists function testing, including at least 500 rounds, drop and impact testing in multiple settings, but doesn't define what the settings are. It says for multiple heights, but doesn't define the heights. It says in different surface conditions, but they aren't defined. Are we dropping it on my pillow or hot lava? Facetious, yes, but under the language here, it could be either.
Right.
Evaluation of safety mechanisms. Doesn't define what a safety mechanism is.
Okay.
Semi-automatic pistols have far different safety mechanisms than do revolvers, than do firearms that are break action. There are testing standards that are out there. ANSI has testing standards for firearms, as does the National Institute of Justice. However, none of these standards are referenced in the bill.
Oh, okay. All right, so we're just kind of like creating our own on the fly?
Yes.
Looks like, okay. And then I don't know if you heard this, but one of the previous panels mentioned something about integrated safety locking devices. Is that somewhere in this bill that I did not notice? I don't know if you guys.
I did not see it in this piece of
Okay, because
legislation.
there was a mention of it, and you and I both know that's not a real thing today, really. And I assume that they're referencing like the thumbprint, some kind of thumbprint entry to a firearm. I don't know, we should just keep our ears open if somehow that makes it in. But my last question would be, did you guys, I'm sure you were there for the Senate hearing, and I guess amendments were discussed. Did any of the amendments that were discussed remedy some of your concerns with this bill?
We heard reference to multiple amendments being proposed, no specifics. It was very clear from the language that we heard was that the bill was not ready for prime time, and they realized it at that point, but they didn't have the amendments in time to amend the bill before we had the hearing.
Okay, I appreciate it. Thanks for being here tonight, guys.
Yes, Delegate Valentine.
Thank you, Madam Chair. Thank you, panel, for being here today. My one question is for Mr. Kashuba. I just want to understand the one statement you made. You referenced 47 states. You prefer to do like the other 47 states. Is Maryland only one of 3 states that has a roster board? Is that where you were going with that?
According to my research, what I started off with was my research has showed that Maryland, Massachusetts, and California, and the District of Columbia. Have a handgun roster, some type of roster system.
Okay.
All the others allow handgun purchases to be dictated by market forces solely.
Okay. Thank you for that clarification. Thank you, Madam Chair.
Any other questions? Okay, seeing none, that concludes the unfavorable testimony for House Bill 1339, and that concludes the hearing on this bill. All right, next, colleagues, we'll move on to the next, but, last bill on the list. House Bill 712, Delegate Grammer. I see Delegate Grammer is here. Civil Actions Product Liability Artificial Intelligence Systems. Delegate Grammer, I think we have 2 people signed up virtual orally. Jamasa, only one that's left. Lizzie Irwin, we lost her. Oh, she's not there either? Nobody's there? Just the one guy, okay. All right, and so we will start with Delegate Grammer whenever you're ready.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 712. House Bill 712 puts in place civil and criminal liability for creating artificial intelligence with the capability of causing personal injury or death. Local newspapers describe how a Texas juvenile was poisoned against his family. A mother described her own son, who we will call JF, as a sweet kid who liked going for walks and attending church with his family. JF unexpectedly started cutting himself. He lost 20 pounds and withdrew from his family. Looking for answers, his mother searched his phone while he slept. She found screenshots of conversations of an array of artificial chatbots. Some of these chatbots were based on characters from popular media. One chatbot suggested self-harm and cutting as a way to deal with sadness. When his parents limited the time he could spend on his phone, and JF reported this to the chatbots, one bot suggested his parents didn't deserve to have children. Other bots suggested he fight his parents' rules. One chatbot even suggested murder. This is one of the many new realities of artificial intelligence. The formulation of realistic personalities that create new types of influence. For young people, this influence can be very formative and in some cases, very harmful. Most states do not have a way to deal with the new impact of artificial intelligence. What House Bill 712 does, or attempts to do, to handle this problem is it puts in place a framework for civil and criminal liability. The civil liability approach is important with the federal government preemption of state AI regulation. Consumers need some level of protection and producers need some level of accountability. This bill attempts to do that by putting in place a framework for damages for individuals or families that incur injury or death due to the design of artificial intelligence. I'll note quickly, we've been in discussions with the credit rating folks, and we have a proposed amendment to exempt them as they are governed by the Federal Fair Credit and Reporting Act. Also, the Association for Justice, we've been in discussions, but I'll say we have not worked out those issues. I'll be happy to work with those folks. With that said, I'd be happy to take questions, and I'd ask for a favorable report on House Bill 712.
Thank you. Who's online? Jay Jasimha. I totally messed up your name. I apologize.
No, that was very, very, very close. So thank you so much. Can you hear me?
I can hear you. Thank you.
Well, thank you, Chair. I was about to start my testimony by saying good afternoon, but I guess it's well into the night there. So thank you for giving me the opportunity to testify. Good afternoon, Chair. Good evening, Chair, and members of the committee. My name is Jay Jessima, and I'm a co-founder of the Transparency Coalition. We're an independent nonprofit which advocates for increased transparency and accountability in generative AI. I'm in strong support of House Bill 712, which provides a critical framework for accountability in the age of AI. I have a PhD from the University of Washington, and I've spent 30 years working in technology and helping develop AI-enabled products for a good portion of that time. The problem, as Delegate Grammer stated, is AI systems, whether they're generative AI systems like the delegate referenced or high impact algorithms used in AI in healthcare and infrastructure, they've become a daily part of our lives. But they've also introducing unprecedented risks. Currently, if an autonomous system causes harm, there's a legal gray area about who is accountable and who's responsible. Without clear product liability standards, Marylanders who suffer from AI-driven injuries or property damage are left with little to no recourse. In the rush to be first to market, AI developers are conducting a giant experiment on us all with their products that do not abide by the scientific consensus on what constitutes a duty of care. Clearly, these companies need different incentives to do the right thing and exercise appropriate care. House Bill 712 addresses this by establishing clear causes of action against the developer or deployer of an AI system for harm caused by defective design, failure to provide adequate instruction or warning, and breach of a warranty. It also ensures that developers cannot simply point to the black box of their algorithms to escape liability. Most importantly, the fact that the bill holds both developers and deployers accountable, preventing either of them from passing the buck. I also love the fact that it prioritizes safety for minors, requiring developers to specifically mitigate risks to our children. I think one other point I'll make is that, of course, you all in Maryland have a long history of leading in technology and consumer protection. By passing this bill, we aren't stifling innovation, despite what others may say. We are ensuring that innovation is responsible. We're signaling to the tech industry that if you profit from products used by Marylanders, you must also be responsible for their safety. For these reasons, I urge a favorable report on House Bill 712. Thank you for your time and commitment, and I'm happy to answer any questions.
Thank you. And Ms. Durkin, is that Ms. Durkin?
Correct.
Okay, so we're going to call you in just a second because you're signed up as unfavorable, but you're our last witness up for the night, so we just wanted to go ahead and bring you in. Mr. Jay, I want to ask you a question. Do you think that back in, I think it was in the early 90s, when we were looking at the capability of the internet, which was then called the World Wide Web, do you think we should have possibly introduced some type of product liability such as this so that we could, because it's not like this is something we could not have foreseen?
Yeah, I think yes, definitely. I used to work at AOL back in the day, so I know exactly what you're talking about. I do think that software product liability would have been a good idea. I think there's really no difference between what these products are. I think what's unique about them is how they can sort of burrow into your children's minds, and or even adults, for that matter. These are not like social networks or other, internet portals where, you might have a chance to be exposed to some content. These are systems that are really trying to exploit your weaknesses, and all because they want you to stay on for longer. The more you use the system, the more data they collect, the more they can understand who you are, and they might be able to use that data to target other people as well. And of course, now these providers are also starting to run advertising. So you're looking at situations where there's a lot of perverse incentives in the system, and we just need to change them.
Do you know if there's any, and you might have mentioned this already, Delegate, and I was out of the room for a second, are there any lawsuits pending with respect to the fact that the addictive nature or the perversive nature and exposure to children and obtaining information or anything like that?
So if Jai can correct me here, but I believe the lawsuit in Texas was done under the business regulatory fraud framework. But states use what they states use what they have. Texas had their fraud framework, but maybe Jai can clarify that. He's worked on this in several states.
Yeah, there's a number of lawsuits pending. I don't know if you've seen the news. This is more related to social media, but it's quickly sort of spilling over into AI. Mark Zuckerberg was called to testify in LA court. If I can provide you a list of lawsuits that are pending or were recently settled related specifically to AI, if that's of interest to you. So we're tracking this.
Yep, it is, and if you would, that would be great, and we can share it with the committee members as well.
Yeah, they're happy to provide that. And I think the main thing that this type of law will provide is actually provides clarity to developers and deployers too, because it points to safety standards that they can abide by, which will then allow them to potentially have a more, favorable outcome in a court case. So we're not trying to punish people. We're just trying to help them get some of the rules of the road. I used to work at Microsoft. I used to work at Amazon. And one of the things we used to frequently do is meet with lawyers to discuss new product plans. And when we met with lawyers, the lawyer would give you the best advice on how to deal with a new feature. And depending on what they said or how large the financial overhang was, my boss, whoever was running the business, would typically make a decision. And so I think it's really important that this law is not, it's providing rules of the road, and it's providing, plaintiffs for their day in court for when those rules of the road aren't followed.
Thank you. Delegate Ericon?
Thank you, Madam Chair. Thank you for staying up late with us, Delegate. My question's actually for, is your last name Jai, Mr. Jai, or is that
Oh,
your
it's
first name?
it's Jessima, but you can call me Jay.
Okay, Jay, thank you. I'm glad to have you here because one of my latest obsessions is what is going on with AGI, generative AI, and the total gap in ethics that we're seeing from some of these companies that have an enormous amount of both market share and power over the entire world, but especially children. So I guess my question is, what have you seen in regards to, has there been any movement towards actual ethics? Because there has been essentially a massive gap. To me, I almost feel like if we do not pass this, there's almost no way to rein in some of this just total lack of ethics around protecting children from the potential pitfalls of using AI. Have you seen any broad shifts in the market to trigger some kind of change?
The most distressing shift I saw was this morning in the newspaper. There was one company that claimed to stand for ethics. Claimed it was a company called Anthropic. Today they renounced that safety pledge. Right, so you can see what the market forces are doing. The rush to compete, the rush to be first to market, is driving people in the wrong direction. There's well-meaning people. There are friends of mine that still work in these companies, and in some cases they become whistleblowers. In other cases, they're unable to speak out for fear of losing their jobs. I do think, and this type of regulation that you're considering in Maryland is honestly the future of AI regulation. Because a lot of other states, we're active, in my organization in 25 states, and so we see all types of AI regulation, and we support many different flavors of it. But this type of more systematic approach that's providing broader coverage, addressing many flavors of the product, so you can sort of redefine. Well, now you're regulating chatbots for children. Now you're regulating chatbots for mental health professionals. So that piecemeal approach, this will allow Maryland to sort of leapfrog that stage if you all advance this measure. So I sincerely hope you do.
Yeah, and can you just tell us if we pass this bill, what kind of market impact could that have? Would it send a message? For example, sometimes California will ban something and the entire country overnight we see, look, California's not doing that anymore, and the whole market will shift to reflect just what California did. And so all the consumers across the country have a shift because of that. Could we see that potentially happen if we pass this bill in Maryland? Could we be leading the country in a different direction in that regard?
Certainly, we're active across a number of large and small states. California has a disproportionate influence on it because of its size and the presence of the tech economy there. But I'm from Washington State. We're a relatively small state. We do have a large tech presence, in the state, and so we tend to. The way to think about it is, make sure that because tort law is a matter of a state authority, right? You're the only people that can actually affect tort outcomes for people in Maryland. Those people exist. Just because you're a smaller state than California doesn't mean that your citizens deserve any less protection. Hopefully, as more states, we are aware of at least 5 states that are going to run bills very similar to this. More broadly in the chatbot space, there are 35 states running bills. We're supporting bills in over 20 states ourselves. So I think the important thing is that bit by bit, this will change behavior. And because I benefited from AI, one of the reasons I'm able to do this work is because I built businesses that were successful using AI. I'm a big fan of making sure that this industry moves in the right direction in a more sustainable fashion, that it's not, that you build safer products that are designed to be safe for children, for our families, that actually do something useful, and end up being. And I think this type of regulatory approach, which emphasizes comprehensive safety testing, I think would be a great way to go.
And Jay can correct me, but I believe this bill passed, a similar bill passed in a different state. Is that correct?
No, it's under consideration. It's under consideration.
What are the states? You said there's 5 states considering the bill
There's
just like
3
this?
that are not a matter of public record, but there's
Mhm.
there's a bill being heard in Georgia tomorrow.
Okay.
Senate Bill 488, Republican Senator Setzler is running it there.
Mhm.
There was a similar bill there's a similar bill filed in Vermont.
Okay.
And I can send you the bill number. Representative Monique Priestley, she's running the bill in Maryland. I think and I can dig up, there's 2 other states that are not a matter of public record yet, but I'll share those with you. And one very sizable state it's not a matter of public record yet. So.
Well, we look forward to it. Thanks for your work on this and trying to keep our kids safe.
Thank you. We've given you a little bit of homework, but I appreciate your willingness.
Thank you so much.
So, thank you.
Thank
That
you.
concludes this panel. Now we're going to move to unfavorable panel with Margaret Durkin, please.
Good evening, Madam Chair and members of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director with TechNet, a tech trade association. Thank you for allowing me the opportunity to speak tonight on House Bill 712. TechNet and its member companies are committed to the responsible use and development of AI. However, we have significant concerns about this legislation, as outlined in my written remarks to the committee. We believe that a lot of the terms and definitions are vague and sweeping, with the potential to bring in more than is intended in this bill. A lot of the definitions refer to the term could be modified, which is a standard that is especially concerning for our members. It doesn't provide any workable guidance for compliance, and we are concerned that it will invite boundless litigation. Harm is also another broad term. Not only does it focus on the physical harm, but the, quote, distortion of a person's behavior, which in our view is another indeterminate standard. This bill holds developers liable for reasonably foreseeable unintended uses. Unlike traditional product liability regimes focusing on manufacturer defects or design, this framework forces developers to anticipate and prevent any conceivable misuse of their general purpose technology. We're also concerned that this bill could lead to a patchwork of requirements, and for the reasons I stated, as well as what's in my written remarks, TechNet is opposed to this bill. Thank you.
Thank you very much. Members, do we have any questions? Okay, seeing none. Thank you very much, Ms. Durkin.
Thank you.
That concludes our bill hearing for House Bill 712, and that concludes all of our bill hearings for the night. Take care, everyone. Goodbye.